So every day, let us keep doing 3 questions. As I told you, today I'll tell you what is the format to write the answers also. So first I'll tell you the format. From tomorrow, start writing it in that format. Remember, as I always said, in law, the more you practice, the better are the chances for you to clear. Yes. So writing 3 questions every day will definitely keep you on track. I am thinking at least let us do it for 20 days. If we can do it even after that also, it's well and good. Yes. And I'll try to bring little tricky questions as the time pass by. We are just done with one unit, so we have very simple topics with us. Yeah. Okay. And towards the end, now for example, today I'll be sending you this particular 3 questions, and tomorrow again there will be 3 questions. Tomorrow after the test is done, I'll be adding that 3 questions to this three. So that like that I'll be sending you cumulatively. Yep. Yes. Okay. So how do we write the question? As I always tell you, in the exam there is 3 types of questions possible. That is what they will ask. The 3 types of question will be people. One is direct question. Sir, give us an example of direct question. This is an example. What is the role of executive? Explain the Ministry of Home Affairs in detail. That's a direct question. There is nothing much you need to worry about. Whatever is there in the book, write down. That's all. Sir, there is a second type of question, that is people difference-based question. Difference-based question, people, you are expected to write in the tabular column. And remember, let us imagine if the 4 marks question is there. Sir, is it okay if I just write 4 points? No, people, it is not sufficient. In your book, if they have given 6 differences, you are expected to write 6 differences only and not 4. So remember that. The third thing, sir, whenever there is an indirect based question, or we can also call it as people a case based question. Now, how do we have to present this? Now, whatever I am telling you, keep all this in mind. Now, what is that? Certain things you need to keep in mind. First thing, people, sir, is it mandatory for me to write section numbers and case names, case laws, wherever it is required? People, in multiple places, ICAI has clearly said, if you do not write section numbers and case laws, they will not deduct any marks. However, remember, that doesn't mean a person writing sections and case laws, they are not telling we will not allot him the same marks, or they are not telling we are not hereby restricted from allotting extra mark. So a person who is not writing may not be awarded a full mark, but they are not deducting anything. But a person who is writing the case law as well as the section number, you have high chances of getting that 1 mark extra. So wherever possible, try to remember. That is point number 1. Point number 2, remember, never write your answers, whether direct or indirect. Never write it in lengthy paragraphs. Try to split it into points and write. Sir, now what do I mean by that? You have a question, people, today. They have asked, what is the process of making law? If you look at your module, they have given you the answer in a 1 paragraph, which is having 5 to 6 lines. That's a paragraph. Never write the answer in a paragraph form. Try to split the answer into points. Now, what do I mean by this? Now, for example, the same thing. Now, this is what is there in our exam, in our module also. What did I do? I've just split the same paragraph into point-based solution. This will always have maximum weightage when compared to a paragraph form of presentation. Hello? Sir, so does that mean I should just split the entire paragraph into points? Wherever it is sensible, wherever you think it's a different point, that you can make it as a different line. Now, for example, Lok Sabha, Rajya Sabha. Lok Sabha I can make it as 1, and then Rajya Sabha I can make it as 1. President of India I can make it as 1. Official Gazette I can make it as 1. Rather than keeping it as a paragraph. Remember this, keep it in mind. Yes. Because people, paragraph form, it is very difficult for the evaluator to focus where the answer is. It will be very, very confusing. Hello? Making sense? Yes. Now, sir, even in this paragraph, even in this point also, remember, in the entire, now say for example, here there is how many? 6 points. See, we are expecting that the evaluator will go through the entire answer. But my question, what if they do not go through? Now, how do I tell, sir, this is the answer? So remember people, a good practice number 3, the third thing you need to keep in mind, what? Wherever there is an important point, try to underline that. Now because of this, what happens? You're clearly telling the evaluator, sir, you need not even check the entire answer. Don't read it. Why do you have to read it? I am only telling you where the answers are. Please just check these underlined words. Now remember, do not just underline the entire answer script. Whichever you think is a very key word, important word in that answer, underline that. Are you getting the point? All of you? Yes? Now that is the third thing to keep in mind. Underlining is very, very important. Fourth thing, I had to tell, I forgot. Sir, can we, you said if we don't write section numbers, they are not going to deduct the marks, correct? Yes. Sir, what if we write a wrong section? Wrong section, people, is like a suicide. Sorry to say, but yes. Why? People, because if you write the wrong section, people, that means the evaluator will understand you are referring to some other provision. They will not even read. They will, that means what? Let us imagine your section number is wrong. Your entire paragraph is right. The question may be for 4 marks. People, there are chances that you got 0 marks. Never write a wrong section. Never. Keep this in mind. All of you, writing a wrong section is gone. Why? It's like, what is that? Operation successful, but patient died. What's the use? Are you getting the point? Yes? Okay. Now, sir, the last one I need to tell you is how to answer the case-based question. How do I answer the case-based question, sir? The case-based question can be presented in this format. What is that? Always split your answer into 3 paragraphs. What are the 3 paragraphs? The 3 paragraphs are, my first paragraph, I can call it as provision. My second paragraph, I will call it as facts. My third paragraph, I will call it as conclusion. So in your answer, there should always be 3 paragraphs. Now, for example, in our case, what is the question that they have asked? Now, in our case, the question they have asked is people, Mr. Asim is a learned advocate. His car was stolen from his house. He gave an advertisement in newspaper that he will give the reward of 10,000 rupees who will give the information about his car. Mr. Vikram reads the advertisement and on making some efforts got the stolen car and informed Mr. Asim. Mr. Asim found his car but denied giving reward of 10,000 to Mr. Vikram with the words, an advertisement in newspaper is just an invitation to making an offer and not an offer. Hence, he is not liable to make the reward. State with reasons whether under Indian Contract Act, Mr. Vikram can claim the reward of 10,000 rupees or not. Now, first of all, tell me, can Vikram claim this reward? Yes. On what grounds? General offer. Now, you are expected to write 2 things here. What? One is, in the given scenario, whatever they're asking, the main provision that is involved, that is people general offer. Whenever a person who Mr. Asim, he gave an advertisement in a newspaper saying that whoever finds his stolen car, I will give you 10,000 rupees of cash reward. Now, whenever someone people just finds the stolen car after looking at the advertisement, general offer means what people? An offer given to public at large. In general offer, will there be acceptance? No. In general offer, what is an acceptance? You following the conditions itself is an acceptance. That means what? If at all someone is telling, if you can find the missing car, if you find it, that itself is an acceptance. Agreed? So, sir, it's a general offer. Now, they're asking one more thing. Asim is telling, no, this is an invitation to an offer. I invited you to make an offer. They're telling, is it an invitation to offer? This
on the sale of the product, particular thing given in the advertisement, it is considered to be an invitation to offer.
So, what do you mean by invitation to an offer? Invitation to an offer is nothing but where you are inviting the other party to make an offer. Here there is nothing like that. What does the person, who is the other person, Vikram, what does Vikram has to make an offer here? So this is not at all the case of invitation. So when I'm defining my answer, what will I write? In my provision, I'll clearly write people that my provision means what? First, I need to tell what is the law speaking about this case. Meaning on what basis. I always tell you should never answer the question with heart. It should always be with brain. When I say brain, there should be some law behind it. If law is not there, your answer is wrong. Now in my provision, what will I be writing? My provision is very clear. My provision clearly has to say, I have to write what is a general offer. According to general offer, an offer which is given to public at large, which can be accepted by anyone by just following the conditions prescribed in the ad, will itself be considered as an acceptance. Hello? And an invitation to an offer is an invitation which is given to, or which is given in a advertisement form, inviting the other party to make an offer. An invitation to offer is different from an offer. Correct? Huh? Now people, that is my provision. I just need to speak the law terms. Did I say anything about Asim here? Anything about Vikram here? Nothing. So my first paragraph only should speak about the law. Nothing about terms, characters, whether Asim will win, Vikram will win, nothing you should speak in the first paragraph. Now come to the second paragraph. What is second paragraph? Facts. Now what does the fact say? What do you mean by facts? Facts is nothing but people. Summary of your question. Summary of your question. Just divide the question into 2 to 3 points and just write down that only again here. So always remember, whenever I write facts, facts is nothing but summary of your question only. That means what will I be writing here? In the given case, Mr. Asim lost his car and gave an advertisement of rewarding a person whoever finds the car. Yes, point number 2. Mr. Vikram found it and hence claimed the reward amount. Point number 3, Asim denied the claim by saying it was an invitation to an offer. Hello? Did I write any answer here? Nothing. Facts is always a summary of the question only. That's why remember, your provision can be bigger. Facts should never be big. It should be 2 points or 3 points. Because they remembered, you know, I know, evaluator know. You're writing facts on the question only. That should not be lengthy. It should be short. Hello? Making sense? Now come conclusion. What does conclusion say? Conclusion says, now you will have to write who wins, who doesn't win. All of that you need to write it here. Now, how do I have to write the conclusion? Directly go and see. They would have given you in the question itself. State with reasons whether under Indian Contract Act, Mr. Vikram can claim the reward of 10,000. Whether Vikram can claim the reward of 10,000. I will write people referring to the, now I'll write my conclusion referring to the provision and facts, yes, Mr. Vikram can claim the reward of rupees 10,000 as it is a general offer and not an invitation to an offer. Hello? Are you getting the point? Now this is where your answer should come. Now generally what people will do, where do they go wrong? Where do they do the mistake? You will start your answer only with Vikram will win the case, Vikram will not win the case. And that is a very wrong way to write your answer. And this is the procedure you need to follow. Are you getting the point? All of you understood? Now this is clear. Now going forward, this is the format you guys have to present your answer with. Now imagine if there is any, if you guys know any provision, if you know section, how will I write if I know the section? Let us imagine if the question is asked on, say for example, anything, say for example, essential elements. If they are asking a question which is involving essential elements, then how will I write? I'll be writing as per section 10 of Indian Contract Act 1872, the essential elements are defined as, or I can even write according to section 10 of Indian Contract Act 1872. Sir, now what if I'm not able to remember any section? In one of the answer, don't write this for everything. If at all you're not, if you want to present it in a right way, imagine you know everything, whatever is that question, but you do not know the section number alone, and you want to start your answer with that question, then you can write it this way. As per the relevant section, of the Indian Contract Act 1872, essential elements of Indian Contract Act means, and you can write it this way. Understood? Yes, sir. So keep this in mind. Yeah. Sir, and what is the marks and all? You will be having 2-mark questions also. You will be having 7-mark questions also. All of that will be there. Probably towards the end, we'll be taking up question papers and we'll be solving it so that you will know how the question paper is going to come. And remember one more thing, you need not have to write the answers in the same format. That is, I need not have to write 1, 2, 3. I can first choose to write the third question. Next, I can go to the first question. You can mix and match. It is always allowed. Yes. So keep this much in mind. Absolutely fine. Clear? Okay. So coming to today's one. First one we already seen. It's a 3 marks question, which was easy enough. The second one, what is the process of making law? What is the process of making law? There will always be a committee that will be formed. The committee will submit a bill to the parliament. So there will be a bill, a draft will be submitted to the parliament. First it will be submitted to the Lok Sabha. Once the bill is accepted in Lok Sabha, then it goes to Rajya Sabha. Once it is approved in Rajya Sabha also, the President of India assents, gives his consent, and after that it will be published in the official gazette of India. Agreed? So the law will become applicable from the date mentioned in the notification as the effective date. That means in the official gazette, I'll tell you, from the law will be effective from, say for example, 15th of March 2026, and from that day the law will be effective. Clear? Yes, sir. What is the role of executive? Explain the Ministry of Home Affairs. After a law is passed in Parliament, it has to be enforced. Somebody should monitor whether the law is being followed or not. So the role of executive is nothing but they implement the law in the ground level. That's the role of executive. Now what is the role of Ministry of Home Affairs? You were expected to write mainly people, the departments. So how much ever you guys were able to write, based on that you guys will get the mark. Now what do they say? It is a Ministry of Government of India. As an interior Ministry of India, it is mainly responsible for maintenance of internal security and domestic policy. The Home Ministry is headed by Union Minister of Home Affairs. The Department of Ministry of Home Affairs, what and all are there? We had seen. One is border management. Next one is internal security. Next one is Jammu and Kashmir. Next one is official language. This was an all easiest one. You guys could have just written that as well. So Department of Border Management, Department of Internal Security, Department of Jammu Kashmir Ladakh Affairs, Department of Home, Department of Official Language, Department of States. Okay. So if you guys have written all of this, yes, you guys will get the mark. Clear? 4 you wrote out of this. Okay. but if you have written everything else also, out of 5 marks, you may expect somewhere around 4. But if you have written everything else, yes?
Without everything also,
You get 4.
No. Let us imagine out of so many departments, did you write every department?
If we write every department, we'll get 5.
Correct.
so border management, state. and
So let us imagine you have written 1, you have not written, you have not written 2. So accordingly, the marks will also be given. People remember, getting out of 4 is very challenging only. Meaning 5 on 5, your answer should be like a role model answer. That means you should have not missed any key points. Then yes, there are high chance of you getting the out of 4. Clear? Any other thing you guys had? You wanted clarification with regards to questions, answers, and all? How we can present the answers based on marks. So remember, people, how much you write is irrelevant. Yesterday you had that question also. Imagine if it's a 5-mark question. How much am I expected to write, sir? The answer can be even 1 page. The answer even can be 1.5 page. The answer can even be 2 page. That is also fine because you never know what is the provision they're asking you, right? But remember, if it's a 5-mark question, try to restrict your answers within 1.5 page. Don't go beyond that 1.5 page. Yeah? I'm saying because you know that's the weightage. Now 3 marks and all, make sure it is not going beyond probably 3/4 of a page. It should not go beyond that. Keep it short. Why?
Mandated to write one and a half pages for 5 marks.
I did not say mandate. See, the simple is the policy and the process is simple. What? There is no weightage for quantity. Me thinking I'm writing all 1 page, 1 mark, I will pass. That is never the scenario. Then quality. What do I mean by that? That's why I told you, right? Difference between, even if it's a 4-mark question, if the book says 6 points are there, you're expected to write 6 points also. Yes or no? Now, why did I say don't go beyond 1 page or 3/4 of a page for 3 marks question? Because in law, the biggest challenge, as I told you, will be completion of the 100 marks. For 3 marks, if you start writing 1 page, 1.5 page and all, trust me, you're losing time crazily. Now, today, on an average, what is the time you guys took to write the exam? For 3 questions, how much time you took? 25 minutes you took? 25. I think the number of marks was, one was 4, one was 5, one was 3. So 12 marks. You guys took 25 minutes. Now you guys only try to do. In that 2 was like a cakewalk question. There was nothing for you to use your brain. But first one, did you use your brain? At least little. Your book, your pen was getting stuck when you was writing. That's what I'm telling you. The more you practice, the better for you. So do this habit every day. Clear? Yes? Okay. Again tomorrow, the same thing. We will, the class will be 3:30. That means the test will be happening at 3:30. 4:15 we'll discuss the paper and then we'll start the class. Clear? Okay. Sir, if the question only says write 3 differences, then write 3 differences only. I'm saying when they don't say, you have to write everything. We'll discuss now. Okay. Tuck. We'll discuss of 15 minutes. Okay. Now, people, what are the question? There were 3 questions in total. The first question, Mr. Naman is an auctioneer. He advertised in a leading newspaper that an auction would be held on 17th April 2025 in Agra for the sale of some office furniture. Mr. Kanha read the advertisement and traveled about 500 kilometers to attend the auction. When he reached the place of the auction, he found that the furniture had been withdrawn from the sale. Mr. Kanha sued Mr. Naman for the loss of his time and expenses. State with reasons whether Mr. Kanha can claim compensation from Mr. Naman under the provisions of Indian Contract Act 1872. Why? Provision. So, as I say always, 3 paragraphs. The first paragraph has to be law. That means it has to be provision. Second paragraph has to be fact. Third paragraph has to be conclusion. Always remember, your conclusion may be right. If your paragraph is wrong, your answer is wrong. I'm telling you, for example, you just said, will he succeed? You said no. But if your provision is wrong, but your conclusion is right, you won't even get 1 mark.
So provision in this.
Provision in the sense, according to what you are saying, Mr. Kanha will not win the case.
According to the invitation of.
So that is what is called provision. Provision means you are writing the answer according to what? It cannot be just an assumption. You need to substantiate your answer. Substantiate means there has to be some evidence. Based upon this, I am telling that he will not win the case. That is very important. Now again, why I am telling this to you is that is another myth that we have. What is that? Sir, if I write conclusion right, but still they have deducted the marks for me. People, conclusion is even an elementary school person can write, because the answer is so simple. Whether Kanha will win the case or not win the case. Do we need even knowledge to write that? It can even be pure luck, no? Writing yes or no will never get even 1 mark until your provision is right. Provision is law, the first paragraph, the opening paragraph. Getting the point? Okay. Now what is the answer? According to Indian Contract Act, which section now? No section here, because invitation to an offer did not had a section as such. They just gave us that it is different from the offer. So whatever is the scenario, the provision is, as per Indian Contract Act, an invitation to an offer does not create any binding contract, and an invitation to an offer is different from offer. All the advertisements, public notices, auctions will always be an invitation to an offer and not offer in itself. Based on that ground, in the given case, whenever I say that I'll be selling a particular article in an auction, I'm just giving an invitation to an offer. It's not an offer. So on that day, if I did not sell that article, it does not bind anything there. You cannot file a case on me. No, you will succeed. Answer is no, you will not succeed. So how will I frame my answer? My first paragraph has to speak about invitation to an offer. My second paragraph has to speak about the same question. Split it into points. Hello? Now this has been taken from ICAI only directly. Now see how they write. First one is paragraph, that is provision. What is second one? Second one, see what are they telling you? In the instant case, Mr. Naman advertised for sale of some office furniture in an auction in Agra for some. Mr. Khanna read the advertisement and travelled about 500, but he found that furniture was withdrawn from the sale. Mr. Khanna sued against Mr. Naman for loss of his time and expenses. Don't you think that is what is given in the question? Then that's what I say. This is always facts. Facts, there is nothing. It is again rewriting of question in short. See, 4 line, 3 line. Conclusion. On the basis of above provision and facts. Don't you think that is a format we wrote? Based on the facts and provision, advertisement of auction by Mr. Naman is not an offer but merely an invitation to an offer. He is not liable to Mr. Kanha. Hence, Mr. Kanha could not succeed in his suit. Hello? Hello? Getting the point? So, I will write here in this way. Whether Mr. Kanha can claim compensation from Mr. Raman, I'll write no. Kanha cannot claim compensation from Mr. Naman. Because it is just an invitation to an offer and not an offer in itself. Hello? Done? Yes? Hello? Done now? What you guys can do is, as I am telling you, have you guys written it?
Yes.
All of you? Do one thing, exchange your papers and correct it. Who and all have written? Okay, can you guys exchange your papers? Shravya, you give it to Abbas. Abbas, you give it to Shravya. Can you guys do it the same way?
So all the 3 questions.
Whatever you guys have written, everything. That's okay. Give it. Arnavan, what is your name?
Open.
Sopam? Sopam and Arnav, and who else? You wrote? You, why?
I was not sure about that.
You didn't write? Okay. Why?
Came next.
Okay. So based on that, check for the provision. All 3 questions were 5 marks. Now how the evaluation is done? Now I just told you, check for the provision. If invitation to an offer was there, if provision is right, you will get 3 marks. So in the same answers, check if provision is there. If provision is there, give 3 marks.
Conclusion
Wrong.
provision correct.
Like provision is
Now let us imagine if it's a 5 mark question. Your provision is right. You may get 2 marks, you may get 1 mark. But your conclusion is wrong. I mean, your conclusion is right. Your provision is wrong. You hardly will get even half a mark. Yeah? So, again, if provision is right, give them 3 marks. If conclusion is also right, and then facts are also right, then give them another 2 marks. But remember, invitation, they should have written everything. If they just written an invitation to an offer and nothing else, give the mark accordingly. If everything is written 3, if nothing is written 2, I mean, if nothing completely in detail is not written, then give 2. It is just written on the face of it, then just give 1 mark. Done na? Are now done? Yes, okay. Next one. Mr. Sharma, trader, wrote to Mr. Verma offering to sell him 100 barrels of oil. I would say this is difficulty level question. It could have been difficult, but because of being in detailed, I would say this is moderate. If not, this is capable of being difficult question. Okay, Mr. Sharma, a trader, wrote to Mr. Verma offering to sell him 100 barrels of oil at 5,000 rupees per barrel. The letter reached Verma on 1st June. On 2nd June, Sharma posted another letter revoking the offer. The letter reached Verma on 1st June. On 2nd June, Sharma posted another letter revoking the offer.
So the offerer posted another letter for revoking.
Revoking the offer. I have sent first letter saying I want to sell. I have sent another letter I don't want to sell. That has reached second. That is what they are telling you.
So but the first letter have been reached to Verma.
The letter reached Verma on 1st. On 2nd June, Sharma posted another letter. They just said it, he is posted. However, before receiving the revocation, Verma posted a letter of acceptance on 3rd June. So what has happened? Sharma sent the first letter on 1st June, which is reached also.
It is also reached.
He has sent first, this is second letter. He sent it on 2nd June. Now Verma has replied to this letter on 3rd June. Which letter? The first letter. He has replied it already. Revocation is not yet reached. Okay. Sharma's letter of revocation reached Verma on 4th June. See, this second letter has now reached Verma on 4th June. I hope it is clear. You guys go, this one was a top bouncer, or you guys were able to write it. Okay. When Verma later demanded delivery, Sharma refused, stating that the contract was void since he had not specified which kind of oil was being offered. See what is happening? When Verma later demanded delivery, Sharma refused, stating that the contract was void since he had not specified which kind of oil was being offered. Yes, sir. And further claimed that he had no oil stock at all. Verma sued for breach of contract, insisting that valid acceptance had already been communicated. Sharma defended himself by stating that contract was void for uncertainty and impossibility. Examine the relevant provision of Indian Contract Act 1872 and decide whether a binding contract was created between Sharma and Verma and whether Sharma is liable for damages.
No.
That's the question. I would say this can carry probably 6 marks also. Yes? Now,
Because two incidents have been insisted in this question. One is that offer of acceptance, that is revocation, section 4, and then so according to the elements of the
lack of information.
lack of information, that is certainly not vague.
Not vague.
vague.
Under section 10.
Correct. Now you guys will be writing in provision. You will be writing this in provision. What is that? There are 2 provisions now. I hope it is clear. First provision is, in the answer they are talking about whether there is an valid contract between them. See, first the question is, acceptance is valid.
Yes.
He has given it valid. So according to section 4, when does the offer and acceptance, when does they come to an end? When do they become complete? We saw that letters and all. When, how, all those things. So whenever an offer is written, whenever an acceptance is given, matchstick that it has burnt, revocation reads later. Now what should I write? Acceptance, when is it complete? For the proposer, when is it complete to the acceptor?
Accepted.
Hello?
Yes, sir.
So from the acceptor's, from the proposer's point of view, that is from Sharma's point of view, when is the acceptance complete? When the letter was put in the course of transmission only, acceptance is complete. Now can I revoke? Answer is no. Hello? Agreed? Now I need to write that entire provision for this particular part where it says whenever there are so many letters being exchanged. So according to the letter theory, yes, he has given his acceptance and that acceptance is valid. However, according to the essential elements, an offer has to be always certain and it should not be vague. Now here in this, they have clearly said 100 barrels of oil. Now why did I say I could have given this question as a difficult question, but why did I say I would give it as moderate? Because they have only said this point. Where? This one. He had not specified which kind of oil. If this word was not there, I would have given this question as difficult level. Now your mind should have thought in the exam. Yesterday I told you my son's theory. Triangle, square, both is there. Correct? Now why am I putting the triangle in the triangle shape? You need to write. Both the provisions are there. Now it was your mind which had to figure out. Because of this I am telling that it is valid or invalid. Now because people, which kind of oil it is not prescribed. So based on that I am telling you it is a void contract. It's void agreement because the offer was vague. It was not certain in nature. So based on that, can I, what is that? Who can succeed? Sharma defended himself by stating that contract was void, uncertain. Yes, people, it was uncertain, and Sharma is not liable to pay any compensation to Mr. Verma.
Answer one more point. Mr. Verma accepted before that revocation.
Correct. That is what I answered. No, acceptor. When is the acceptance complete? Against the proposer, against the acceptor. Your point should say against the proposer, acceptance is complete. When the acceptor puts the acceptance in the course of transmission, that word should be there. Hello? Yes, Sam. Yes or no? Hello? Pakka? Okay. So how will you give it? Now see, if all those things are there, give 6. Now go and start seeing whether those things were there. They just wrote acceptance is complete. They did not completely write the provision. Then deduct 2 marks. If they did not write the next part, what is the next part?
Facts.
The certainty and all of that. If that was not written, deduct another 2 marks. The main 2 provisions are important. And then yes, conclusion of course. For the conclusion, give 2 marks.
So what is the conclusion?
Conclusion is Sharma cannot, Sharma will succeed in the case. He is not liable to pay any compensation.
Not a valid contract.
It's not a valid contract. It's not a valid, cannot claim damages.
So we can mention that under essential elements in section 10.
So not under section 10.
So not under section 10. It is not like lack of information, certain but not vague.
Correct, yes.
So conclusion is wrong. How?
Conclusion is wrong. But provision is right.
Provision, one provision. is right.
Then just give 2 marks overall. Yes, sir. Now, last one, people. Mr. Das, a landowner, transferred his property to his daughter, Geeta, on the condition that she would pay 20,000 annually to her maternal uncle. Mr. Gopal. Geeta accepted the property but later failed to pay the annuity. Mr. Gopal sued Geeta for recovery. Geeta argued that since Gopal was not a party to the agreement, he had no right to sue. Gopal contended that the consideration had moved from Das on his behalf and that he was entitled to enforce the promise. Examine whether Mr. Gopal can recover the annuity under Indian Contract Act 1872.
Yes.
Yes? How? What is the provision?
The privity of contract. The family settlement exception is there if that like third beneficiary can.
Very good. The provision that you guys have to look out for is people, the provision should clearly say doctrine of privity of contract has certain exceptions. In that exception, people, you should have written acknowledgement. Acknowledgement or estoppel. There, which was a case law. The entire story is similar to some case law. Chinnaya versus Ramaya. Now, what did our book say? If you don't write case name or section, not required. No, see, guideline answer.
Sir, I have not mentioned this in answer.
Yes, that's what I'm saying. Now, why I'm saying it this way is they will write. See here. How guideline answer is coming then? See, I'm not saying they are clearly giving you a notification. You're not expected to write section numbers and case law. They are not going to deduct mark. They are telling you correct. But I am telling you when we are practicing, let us try to practice with section numbers and with this one only. Hello? Yes? Now, how is that they are writing you? Remember people, I need to write two things here. First thing you need to write the definition of consideration. What is the definition of consideration? Section 2D says, what does section 2D say? What is consideration? So, when at the desire of the promiser, promisee or any other person. That's the definition. In this case, that is what is happening. No, promisee or any other person is giving on behalf of the person. I did not give, but my brother gave is what this person is saying. So I will be writing section 2D. And I'll be mentioning privity of contract exception. Hello? So if these three words are there, give them. If not, don't give them.
So can we write consideration must move at the desire of promission?
Consideration must move at the desire of the promiser, correct? But in this case, what is happening? I did not give. Someone else gave the consideration on behalf of me. That point is communicated where? Consideration may move from promisee or any other person. That's the second line of consideration definition, no? Yes or no? So, out of 5 marks, if provision is right, the provision has all three words. Consideration definition, next one is privity of contract and exception. If all three are mentioned, then give them 3 marks. Privity of contract and the other one is written, then give 2. Yes, because if you just actually logically if you think, if you just write privity of contract and if you leave it, that means you are telling the third party cannot sue. It becomes opposite. You should write exception. If not, it is answer itself is wrong.
Please, sir.
Again, same thing. Triangle, square. When there is a similar and decided case law, Chinnaya versus Ramaya, that's why it does not go under family settlement.
So it is estoppel or acknowledgement?
Estoppel or acknowledgement. Why again family settlement is not coming? Paying pension is never part of any agreement, no? Family settlement is a property dispute settlement. Yes?
It is other than property dispute.
Correct. And the better one is acknowledgement or estoppel. Clear?
Its promise can't withdraw. Estoppel.
You cannot step back.
Yes,
Whatever you have agreed to do, you cannot step back. Yes? So overall, check how much you guys have got. Clear? Okay. So people, that's why I say, now you tell me how much time did it take for you to understand and write the questions. Again and again I'm telling you, in law there is no shortcut. You read 100 times. You write 5 times. The person who writes 5 times will clear, not the person who reads 100 times. and this is true. Are you getting it? Yes. So again, now we are solving that class test ka paper. Yeah, the 10 questions thing. Online, you guys also do the same thing. When I'm telling you, you try to evaluate the same way. I'll be telling you the marks for which how much marks can be allotted. So pause it and you guys try to evaluate accordingly. Yeah. Okay. Mr. Rahul, an Indian citizen working in Dubai, was stranded in Dubai as he had no money to come back to India. Mr. Salman, who is Rahul's friend in Dubai, made tickets from Dubai to Mumbai for Rahul and his wife from his own money and gave to Rahul. Rahul came back to India and immediately made a phone call to Salman, thanking him for the help and made a promise that within few days he will refund the amount. Is Rahul bound by any contract to repay the amount to Salman, and if yes, as per which provision of law? Section 2 clause D. First of all, is he liable to repay?
Yes.
Yes. Why?
Because he only
Provision correctly.
when the desire of the promisor, the promisor or any other person does or
Okay. Past, present, future. Okay. Because of that, you are saying it is possible.
yes, sir, that
Okay.
The promise must be more desire of the promise.
Okay. Any other provision? Any other provision you guys wrote? What is your answer? All of you wrote it is exercisable.
Yes, sir. It is.
Contract is exercisable. He can recover the money is what you wrote. Now, why is the provision word very important? Yes, sir. You will be writing the consideration definition, section 2D. That is correct. Is that sufficient or should I write something else? People, consideration correct. You need to write that it is always moving at the desire of the promiser. That I agreed. Now, why is this point coming? If you look at the main point, what happened? Mr. Salman, who is Rahul's friend in Dubai, he made tickets from Dubai to Mumbai for Rahul and his wife from his own money and gave to Rahul. They are telling what? From my money, I paid the tickets for you and I gave it to you.
Voluntary service.
Voluntary services. Did you ask for me? Did I take money from you? No. From my money, I'm giving it to you. Now, what they are telling, I did it on my own. You didn't ask it to me. I gave my money, I booked tickets, and I gave those tickets to you. Now, if you look at it, what are the facts similar to? If that's where I say how to interpret the question, indirect or a case-based question. You need to see where does this story belong to in our provisions, in our sections. Whenever one person is giving everything from his pocket on his own, we call that as people voluntary services. I did not ask for it, but he only did it. Now, whenever it's voluntary services, am I liable to pay for that? Generally, if it is a voluntary service, if you remember, that was a Varsha's example. He went in a cab and he asked for whatever is the cab charges to be paid to repay to give back the, the lost wallet. Whether Varsha will get the money, you guys said no, Varsha won't get back the money. But imagine the owner there said, after receiving the wallet, thank you so much for your service. I will give you, say, 1,500 rupees for your kind gesture. I promised to pay you. Then, people, it becomes a binding contract. And that came under exceptions to quid pro quo.
Section 25 of 2.
Section 25. Even if you guys write section 25, that is more than sufficient. Section 25 says what, people? Section 25 is exception to quid pro quo. That is, even if there is no give and take, the contract will be valid. When? In the case of people, when? Past voluntary services. That's the point you need to write. Compensation to pay past voluntary service. So if that word along with section 2D, if consideration definition is there and section 25, exception to, even clause to know, section 25, exceptions to quid pro quo, if that is there. Again I repeat, section 2 clause D, consideration definition is there. If section 25, that is exception to quid pro quo, that word is written, past voluntary services. If this is written, compensation to pay for past voluntary services, then give them 4-mark question and check conclusion. But if these two things are there, they will get 3 marks. If they have written consideration definition but not exception to past voluntary services, give them 1 mark. and check the conclusion. Whether I can recover the money? Yes, I can recover the money. So if they have written both the provisions and conclusion right, then give 4 marks. If not, just deduct the marks accordingly. Yes? Hello? Done?
No exception is written. So, but promise to compensate for something violated done for the promise is valid even if it is lost.
That's where I say that's not a keyword. We have to give it out of our heart, that's all. But if you go with the same answer in exam, that will not work. That's where I'm saying you cannot use your own language for the keywords. You will not get mark. So deduct it.
So the main keyword is
Compensation for past voluntary services.
So,
Huh.
I want to give 2 marks.
See? If that word is not there, it doesn't work. Clear? Done? Okay, next one. What are the exceptions to the no consideration, no contract? So they are telling that entire section 25 only. Natural love and affection, compensation to pay for past voluntary services,
promise to pay time-based
time bar debtor,
Charity.
bailment,
Completed gift.
charity.
completed gift, charity, agency, surety. That's all, you have said everything. So if you guys have written so much, well and good. Now the question is, it's a 6-mark question. Now you guys will have a doubt. What? Should I explain it, sir, or should I just write the points? Will they give you 6 marks just to write the points? Answer is no. So even if a person has explained 2 lines or 3 lines about each point, good enough. Give them a mark. If they have just written the headings, they have not explained, give them 3 marks.
So we can write maximum 7 heads for this.
No. You are expected to write whatever is there. So how many ever points are there, you are expected to write everything. So never take it as 1 point is equal to 1 mark. Yes? Hello? Everything should be there. Hello? Okay, done. Next one. Mr. Mohit booked a ticket for a movie and on the back of the ticket there was a printed condition. If there is electricity failure and due to that any show is cancelled, then the cinema hall is not liable for the loss to the customer. On that day there was electricity failure and the cinema show was off in between. Mohit wants to claim a refund of his money. Is Mohit entitled to refund of his money? Is he entitled?
No.
He is entitled.
First of all, what is the condition? I mean, what is the main provision? No. What is the main provision? Special conditions. Those who have written the special conditions, they will get a mark. Communication of special condition. Whenever there is anything that is hidden, it need not be oral or writing. If it is in a form of ticket, it is in a form of advertisement, it is in a form of banner in the office. All these are considered as special conditions. Second thing, anyone has written case law. What is a case law?
So,
Lily White.
Where does this special condition? Unreasonable, when did it come? Lily White versus Manuswamy. You can quote that also. Special conditions, no? Yes or no?
as long as they are reasonable.
As long as they are reasonable, it will be binding on the parties. So in this case, what happened? In this case, they are telling that people, if at all, there is a contract between 2 parties and the theatre is saying if there is a power failure, you will not get your money back also, it's your own risk. Now the question is it reasonable or it is unreasonable? That is what they are telling you. The printed were so printed, no. The contract has become void, hence the man became aware of them, but the condition stating not to refund the money of the ticket due to non-perform the contract is unreasonable. Also the contract has become void, hence the rule of restitution would apply. Therefore Mr. Mohit is entitled to get the refund of money of his ticket. Correct? You imagine, you go to a movie show, they will not play the movie. If you do not get the money, would you be okay? It is your duty. Generator, can't you manage? Is it impossible? Can't you play a movie? Don't you think today in all the malls there is a threat of a power failure? But is it affecting our movies? No, because they're taking the backup. So here them telling you will lose your money, you will not even get an opportunity to watch the movie again is unreasonable. Hello? Done?
But they are mentioning before the ticket, backside of the ticket is
Correct. That's what is Lily White versus Manuswamy. No, the backside of the ticket conditions has to be reasonable. Reasonable is what? Let us imagine. If at all if we were not able to play the movie, you will be able to get back 80% of the movie tickets. Reasonable. If they are telling you will not get back even 1 rupee, I didn't even experience the movie. That's unreasonable. That's what I said. Someday someone asked in the exam, how can we make out what is reasonable, what is not reasonable? You can make it out, right? Who would pay? You try to put yourself in that shoes and try to think. Would you accept it? And always remember, there is a difference between difficulty and impossibility. Today, to play a movie is not impossible if there is a power cut. It's possible. It's difficult for him. Yes, generator, backup, all of that. It's difficult. Now, can I say, people, if there is a power cut, then we will not have any classes? Why? Same thing only now. Now, it comes with a cost. There is a backup. Generator and all should run. Agreed? Yes, sir. Okay. Third one, what do you understand by Indian judicial system and what are its various functions?
How much mark for this question?
How much it was? 5 marks. So if provision is right, conclusion is right. Provision carries 3 marks, conclusion carries 2 marks. Award it accordingly. If provision they are able to write special conditions and if they are explaining that completely reasonable, it will be binding. If unreasonable, not binding, then give them a mark. What do you understand by Indian judicial system and what are its various functions? Functions, we have already seen this. 3 functions of Indian judicial system. One is dispute resolution, interpretation of acts, and promote fairness among citizens. Correct? And next one, how do the function people, the Indian judicial system? Through its various courts. There are 4 courts. Just write down that. Hierarchy is there. Supreme Court, High Court, District Court and Metropolitan Courts. Hello? Okay. X agrees to pay Y 1 lakh rupees if Y kills Z. To pay Y, X borrows 1 lakh from W, who is also aware of the purpose of the loan. Y kills Z, but X refuses to pay. X also to repay the loan to W. Explain the validity of the contract between X and Y, X and W. What happened here, people? X is giving some money. X is giving some money to Y to kill Z. Now, how is X getting money? X is getting the money by borrowing from W. So they're asking you, what are these contracts valid? This is contract number 1, this is contract number 2. Are these contracts valid? Contract between X and Y, is it valid? No. Why?
Illegal.
It is illegal. It is unlawful. It is illegal in nature. Why? Because you are doing something forbidden by law.
So, against public policy.
No. Forbidden by law. Against public policy, you have different points. This point is not covered there.
Criminal in nature. Criminal in nature.
No. Where does it come under Indian Contract Act?
So, forbidden by law, yeah.
It is coming under unlawful object, unlawful consideration. Under that, it is coming under forbidden by law. So, if you are writing that, then your provision is correct. Correct? Hello? Essential element, section 10, section 23. Indian Contract Agreement is illegal and void if the consideration object is unlawful. That is. So, if this much is there, give them a mark. If not, don't give them a mark. Yes? So, here people, divide the marks like this. 3 mark for provision, 1 mark for this conclusion, 1 mark for this conclusion. Yes? Now, why is that required? People, a contract between X and Y, is it valid or invalid? Invalid, Pakka na? Okay, this is correct. Tell me between W and X, is it valid or invalid? Why?
Illegal purpose.
He knows it. Okay. But do you write it in any way in the provision?
Binding the contract is illegal.
That's where I'm saying any contract connected with the illegal contract will also be tainted with illegality. That's the word you guys have to write. So if that is there, give mark. If not, don't give mark. So if your provision, if the first provision is correct, give them 2 mark. Even if this provision is there, what? Any agreement or a contract connected with an illegal agreement, it also becomes illegal and hence void, unenforceable. So both are void in the nature. You cannot enforce it in the court of law. Both are invalid. Hello? Because W is aware of it. What if W is not aware? Then this becomes invalid, this becomes valid because unlawful in part. Whatever is legal will be enforceable. Whatever is illegal will not be enforceable. Hello? Clear? Okay. So give it accordingly.
Total marks of questions.
5. So 3 plus 1 plus 1. Mr. Sanjay Kothari was a big businessman having 2 sons and 1 married daughter. He decided to gift his house to his daughter. For this purpose, he called his lawyer at his house and made a written document for such gift. The lawyer advised him to get the transfer document properly registered. When they both were going for registration of document, they met an accident and both died. Later, the daughter found the document and claimed the house on the basis of the document. Explain whether she can get the house as gift under Indian Contract Act 1872. Possible? Yes or no?
No.
First of all, what is the provision?
Exception.
First thing, provision is coming under people. Whether this lady, can she enforce a contract? What happened? The father wanted to gift his daughter one land. He has written everything. Lawyer has written everything is written in a document. But when they were going for a registration, they met with an accident, they died. Based on that document, the daughter is claiming the land. Can she claim it? She cannot claim it. Provision. If provision is right, give marks. Out of 5. 3 marks goes for provision. Now, what is the provision, people? Provision is whenever there is a contract in which there is no quid pro quo. Because father is giving land. What did daughter give in this place? Nothing she gave. So, when will it be a valid contract? Whenever there is quid pro quo, exceptions to quid pro quo. So, what is the daughter giving in return? Natural love and affection. Now, what you need to write? Section 25 of Indian Contract Act, which says there is exceptions to quid pro quo, that is give and take. The contract will be valid if it is having natural love and affection as its consideration. Provided the contract to be valid, it has to satisfy the following conditions. What are the following conditions? First one, the people must be in near relationship, father, daughter, test satisfied. Second one, the document should be in writing. Second test satisfied. Third reason, it has to be registered. They were about to get registered. It is not yet registered. So the third condition not satisfied, and hence the daughter cannot claim this as a valid gift. Now, 2 things that students will generally have a confusion. Sir, they are using the word gift. No, sir. In exceptions to quid pro quo, both will come. Natural love and affection is also there. Completed gift is also there. So why don't we claim it as gift?
Not completed. In a complete, I will register.
It's not completed is what he's saying. One is, okay, he's telling it is not a completed gift. It is not yet registered.
Immunity for the quid pro quo exception is natural love and affection because it is a near relationship between father and daughter which comes into that category.
And second thing, always remember, in a question, they will always give you hints. You see, this hint goes to which provision. It is covering what, or it suits better which provision. They are talking here about writing. They are talking here about near relationship. They are talking here about registration. Or all these conditions coming under gift? No. Then why did they give all these conditions in question? That is a hint. That is for you to think it is not gift, it is the natural love and affection. That's how you need to read the questions. In the questions, you will have hints. Are you getting the point? Yes, done. 5. 3 mark provision, 2 mark conclusion. Section, okay, next one. Priya, a firefighter, is called to extinguish a fire at a factory. She performs her duty and successfully puts out the fire. The factory owner, Mr. Sharma, later promises to give Priya rupees 20,000 as a token of appreciation for her bravery. When Priya asks for a promised amount, Mr. Sharma refuses to pay. Can Priya sue Mr. Sharma to recover the promised amount? Can she sue? No. What is the main thing?
So legally also perform the obligated performance.
So as per the consideration, rules of consideration, people, you cannot claim something which is your duty to perform. You are legally bound to perform cannot become a consideration. As per the consideration definition, section 2, clause D, rules of consideration says whatever is one legally bound to perform cannot be claimed as consideration in the given case. Firefighter, we have seen this also in the class. This was the exam based question. Clear? So if you have section 2 clause D, definition written and also exception written, then give 3 marks. Conclusion goes 1 mark. 4 marks question. Clear? Hello? Okay. Okay. Mr. Ayush, the employer, induced his employee, Mr. Bobby, to sell his one-room flat to him at less than the market value to secure promotion. Mr. Bobby sold the flat to Mr. Ayush. Later on, Mr. Bobby changed his mind and decided to sue Mr. Ayush. Examine with the validity of Indian Contract Act as per the provisions of Indian Contract Act. How is it possible, people? Can I sue? Can Ayush? Sorry. Bobby sue Ayush? Possible? So what is that you will be writing? It is coming under undue influence. Section 16. It's a voidable contract. So can Bobby file a case? Answer is yes. Why did we say it is undue influence and not coercion? Because there's a relationship between them.
Real and apparent conflict.
Correct. And second thing, why do you said it is it is undue influence and not coercion? The reason is they have clearly said that you are doing it for the purpose of promotion. This is not prohibited under IPC. That is in BNS. Now, people, that if at all that's the reason for a purpose they are giving it. Because of that, people, it becomes undue influence. Understood? Yes, sir. Hello. Okay. Mr. Suraj promises Mr. Manoj to paint a family picture for 20,000 and assumes to complete his assignment by 15th March. Unfortunately, Mr. Suraj died in a road accident on 1st March 2023 and his assignment remains undone. Can Mr. Manoj bind the legal representatives of Mr. Suraj for the promise made by Mr. Suraj? Suppose Mr. Suraj had promised to deliver some photographs to Mr. Manoj on 15th of March 2023 against a payment of 10,000, but he dies before that day. Will his legal representatives be bound to deliver the photographs? So people, 2 marks, this will be 2 plus 2. There are 2 questions here. First one person, Suraj promises to deliver a painting. He died. Will the legal representatives be liable? No. Who will execute the contract, people? Who shall be eligible to perform the contract? They're telling you first will be promiser himself. Whenever the contract says so, or whenever it includes a special skill or talent. So painting not everyone can do. Now, when Suraj dies, the legal representatives will not be liable to do the painting. Then what should they do? Whatever is the benefit they got, they have to give it back. What type of contract will this become? This is called as void contract. Very good. Understood? Hello? Okay. Next one they are telling. Instead of painting, Suraj has promised to give some photographs in his house. After Suraj dies, will his family members be liable to give that photographs? We have given this also as an example in class. If it is anything to do with articles or any products, I am liable irrespective of the death. I think in the class we said photographs or table or something. I am liable to give it. I can't stop it. So legal representatives will be liable to give the photographs, but not in the case of painting. Hello? Done. So 2 plus 2 plus 2. That's the weightage. Technically, if you see, there are 3 questions. Agreed? Okay. Give it accordingly. What is the IBBI? Discuss its establishment, powers, functions, and the categories of persons and entities covered under the Insolvency and Bankruptcy Code. See, lottery. People will literally leave and go. IBBI and all. You did not write? Yes? IBBI. What? First thing, who governs IBI? It comes under which act? You can write Insolvency and Bankruptcy Code. You can start from there. Next is, it is governed by which ministry? Ministry of Corporate Affairs, because IBC comes there. Okay, next one. Whose and all insolvency matters does IBBI take up? Individuals, partnerships, LLP, companies. Individual and partnerships, which tribunal should they go? DRT, we had written in the class also. Company and LLP, where do they go? They go to NCLT. And who are the various people involved in IBBI? There is the board in the top. The board is called IBBI. Under that, there are three people. One was called Insolvency Professional Agency. I told you it's your ICA only. Next one was you guys. You are called as Insolvency Professionals. The third one is called as Information Utilities, IUs. Yes. So if you have written entire thing, then give 5 marks. If not, deduct mark for each point. Mr. Y is a government contractor. He received work order from Karnataka state government to install hand pumps in Mysore. When Y was about to start the work, the villagers there promised to pay rupees 5,000 to Mr. Y for the hand pump work. Mr. Y agreed for the same. Later on, when the hand pump was installed, villagers failed to fulfill their promise. Mr. Y seeks your advice in this case. Can he recover the amount? Is it possible? No. Answer is same only. What? What do you guys look out for in the answer?
Performance of what in
Whatever is the
legally.
you are legally obligated to do. If at all that is the case, then you will be liable. If not, you will not be liable. Correct? Huh? See here, they have answered this question in two ways. One, we can take it as firefighter example also. Now, how these people have given the answer, again in the guideline answer, they have given, this person is there, no government contractor. He got the contract from whom? Government. So, he's working, he's doing the work because they said, not because the villagers said. So, the government told him to do the work. Who should pay? Government should pay. Can he take the money from the villagers? No. So that will come under which one? Consideration should move at the desire of the promiser. The villagers will say, did we ask you to come and put the hand pump? Durga Prasad versus Baldio. They have answered this even as per that. But this is a very thin line of difference. We always think if you are a government contractor, that means you are employed by them already. That's how we take it. But that's one confusing thing that they have only given. Yeah. If you ask me, both are valid. If you ask me personally. But the interpretation that the ICAI has taken is Durga Prasad versus Baldio. In this particular interpretation. What is that? It should be always at the desire of the promiser. The request of the promiser. Durga Prasad versus Baldio. That's the interpretation they have taken. Yes?
We can write the reference of that fire extinguisher.
That's what. See, if you look at it, you can take it that way also. That's what I'm saying. According to me, both are right. It all depends upon what is this government contractor. Government contractor means what? Is it something a person has just got a contract and you are doing it, or you are working for government? If you are working for government, then firefighter thing will come into picture. Or if you are just doing the work because it was assigned by someone, you are not everyday working for them, then Durga Prasad thing will come. Yeah. But because both are closely related, go with the interpretation always given by the institute. But if it is wrong, I'll tell you upfront it's wrong. Here both are valid, that's why I said it's okay. Clear? Yes? So, yes, because of that, go with Durga Prasad versus Baldio, go with that interpretation. If we have written the other one, because of this, deduct the mark. Yeah? So, that's this. How much you got? What is the highest score? Yeah? Again, we'll take up the next paper. Yes? Okay. Yes, people. So, that is the, see today's test paper. I know one thing, today we took up a challenge of writing 4 questions. Probably by another 2 days, we will have to go towards 5 questions within half an hour. That's your target. 30 minutes. You guys should be able to write 5 questions by end of, now it's been 5 days. By end of 10th day, you guys should be around at least 5 questions. by the time you guys go towards 15th, 16th day, you guys should be able to touch 6 questions in 30 minutes. Yeah, that's the target. Clear? Because I told you in the exam, you should be able to write 5 marks question within 6 minutes. So you try to do the math. That's what the equation comes down to. Clear? Yes? Okay. Overall, how was the paper? Today's paper was easy. You were able to do? Okay. Okay. Chandan was suffering from some disease and was in great pain. He went to Dr. Junjunwala, whose consultation fee was rupees 300. The doctor agreed to treat him, but on the condition that Chandan had to sign a promissory note of 5,000 payable to doctor. Chandan signed the promissory note and gave it to the doctor. On recovering from the disease, Chandan refused to honor the promissory note. State with reasons, can doctor recover the amount of promissory note under the provisions of Indian Contract Act? Can he recover? First tell me what is a provision? Undue influence. Section 16, undue influence. Mental distress.
Predecessary relationship.
Yes.
He's in dominant position.
He's in a, so I'll be writing, as it is a case of undue influence, in the case of mental distress, there is a clear relationship between the doctor and the patient. The doctor, who generally charges a fees of 300, has charged 5,000 rupees, taking an advantage, unfair advantage of the patient's position. So in the given case, will the doctor succeed? Answer is no, he cannot recover 5,000. However, he can recover whatever his nominal charges are, which is 300 rupees. Clear? Yes, sir. That's the answer. So I'll be writing. This is a 5-mark question. This is a 4-mark question. How will I be writing? For my provision, I'll be getting 3 marks. For my conclusion, I'll be getting 1 mark. Why conclusion has 1 mark, people? Most of the people, one wrong thing you guys would have done here. What is that? You guys would have written as conclusion, the Dr. Junjunwala, he cannot recover the amount as discussed under promissory note. You would have written. But remember, he can recover whatever his usual consultancy fees is. That is, you can recover. Yes or no? So if you write that also, you will get mark. If you just write that the doctor cannot recover any amount, which most of you would have written if I am not wrong, that will give you 0 marks.
Sir, it can performance of
Right.
What?
Performance of that legally bound.
Sir, consideration.
Consideration of what one is legally bound to perform.
We can write in the conclusion that.
No. Why? Because there are 2 scenarios, right? One is, see, generally what is happening, people? A person is using his dominance. There is a, what is that? There is a relationship between 2 parties, doctor and patient. The exact example also we saw in class with regards to mental distress. When a doctor takes an advantage of his position. Now in such case, what is going to happen? That is what is the scenario, right? Yes or no? Hello? Yes, people? Understood this one? Undue influence? Clear? Section 16.
16 is for coercion, right?
Yes, sir. Okay. Question 11. A, B and C jointly promise to pay D a sum of 6,000 rupees. Examine considering the provisions of the Indian Contract Act 1872. Can D compel any of the 3 parties A, B and C to pay him 6,000 rupees? Next one. C is compelled to pay the whole of the amount to D. Can he recover anything from A and B when both A and B were solvent? Second one, A is not in a position to pay anything. 5 marks question. Now what is this, people? This is nothing but, people, joint promisors. What is the scenario of joint promisor? In my provision, what is going to come in my provision? Whenever there is a joint promise where more than one party is promising to repay the debt, all the parties are liable to repay the debt as on the date of maturity. If on the date of maturity, if we are not paying the money on time, then the creditor gets the right to recover the money from any one of the joint promisor. The whole of the money can be recovered. In this case, can D compel any of the three parties to recover? That's my provision. I can compel. Possible. Yes. Now, what is the next provision here? The next provision, people, now there are two questions. How do I write the answer for this? One, you can write it this way, people. The first way you can present this answer is, you guys can write one common provision. The common provision is, as per Indian Contract Act, if you guys can remember the section 42 and all, 43, 44, 43 is more than enough. If you guys are able to write 43, more than enough. If not, also it's okay. So you will be writing, people, under provision as per section 43 of Indian Contract Act. In the case of joint promisors, on the date of maturity, if the total money remains unpaid, the joint promisee can recover the money, the whole of the consideration, from any one of the joint promisor. He may compel. Now see, that's my provision number one. Provision number two. However, such promisor who was compelled to pay the money can recover the money from the other joint promisors. It is allowed. Yes? Now that is what the case they have given. One is when both were solvent. What if one of A is not in a position to pay anything? Now what will you do?
A is insolvent, so B and C will pay.
B and
B
C
will be
pay.
share,
They
getting
will
this.
Correct. So now what I'll be writing, whenever there is any loss, if at all there is any of the joint promisor who is not in a position to repay the loan, in such case, the joint promisors will have to share the losses in the ratio. I mean, in the equally, whatever is the remaining. A is not able to repay, whatever is his share, B and C will have to share that particular loss. Now you guys can also think, sir, why is B and C coming? Why can't we write A's legal representative? We have seen this in the class because we are talking about the position of insolvency, not about the case of death. There is a difference. Insolvency, other promisors will be liable. Death, legal representative and the other promisors will be liable. In this case, it was insolvency. So the legal representatives won't get anything. So why will legal representatives be liable? They will not be liable for anything. So the rest of the money should be shared by B and C in the proportion 3000, 3000. Hello? Understood? Yes, sir. Now that is what you will be writing. That is my provision. Now comes facts. Whatever is given in the question, write it down in 2 or 3 points maximum. Done. In which one? 1 point? Question. That's what? Same thing. Split it into write. 2 line, 3 line, write it down. And how will I write? Last I will write conclusion. Now there are 2 questions, right? I'll write conclusion number 1. And in this conclusion number 1, I'll write referring to the provisions. Yes, this is what he can do. He can compel. Next, conclusion number 2. Now there are 2 in that. I'll write 2A. Or if they have given you any specific, number by the question. I think if they have given you,
A, 1 or 2.
okay, they have given you this way. You also write it that way only. And then it will be 2. This is how you need to present your conclusion also. Hello? This is one way of presenting. Or if you want an alternative way, what is an alternative way? First write 1 provision in the case of joint promisors. Section 43 of Indian Contract Act, if at all they fail, then he can compel any other promisor. Done na? That's my provision na? For that, what is the conclusion? Write off. So answer the first one here. Next write again. So provision, that conclusion. Provision, that conclusion. This is also accepted. So whenever there is, generally students will ask, sir, what if there is more than one provision, what to do? If there is more than one provision, if the topics are not connected at all, then this is the best way to interpret your answer. Provision, conclusion, provision, conclusion. At that time, it's okay to skip facts. So whenever you're splitting and writing provision and conclusion, don't write facts again. Is this clear, all of you? Yes? Okay, any doubts here? No? Okay, done. C can recover 3,000 from B and A. Okay. Kashish was running a business of artificial jewelry since long. He sold his business to Naman and promises not to carry on business of artificial jewelry and real diamond jewelry in that area for a period of next 1 year. After 2 months, Kashish opened a showroom for real diamond jewelry. Naman filed a suit against Kashish for closing the business of real diamond jewelry business as it was against the agreement. Whether Kashish is liable to close his business of real diamond jewelry following the provisions of Indian Contract Act 1872. What is the question saying? What is the provision?
So restrictive covenant.
Agreement? Agreement in restraint of trade. Is it valid? All of you wrote the same provision? Agreement in restraint of trade? Yes. Is it valid? Invalid? See, what is he saying? Kashish was running a business of artificial jewelry since long. He sold his business to Naman and promises not to carry on the business of artificial jewelry and real diamond jewelry in that area for a period of next 1 year. Now, what is that? I am doing one business. I sold it to you and I promised I will not again start something here. If I start also, then what is the point of me selling it to you? Getting the point. So he has promised for next 1 year in that area I am not going to start. 1 year in that area. After 2 months, Kashish opened a showroom for real diamond jewelry. After telling I'll not start for 1 year, in 2 months only he started one business there. Of what? Real diamond jewelry. Naman filed a suit against Kashish for closing the business of real diamond. He said, hey, you have signed Noda, how are you going to start? Now they are asking you whether Kashish is liable to close his business of real diamond jewelry for following the provision of Indian Contract Act 1872.
Yes.
It is not valid.
So Naman suit is valid.
Naman suit is valid, you are saying?
Yeah.
All of you have written the same thing? Naman suit is valid? Why? Why do you think Naman suit is valid?
Sir, restraint of trade are usually void.
Restraint of trade you are saying is usually void. So can Naman sue?
Yeah.
So as it is void,
Can Naman sue or not? He cannot sue.
he cannot sue. It is not artificial. It is real diamond.
Understood. Okay. Nitin? You have written he can sue. Why? Why did you think he can sue? What is your provision?
Sir, agreement is
Restraint of trade. So he is saying I will not start the business. He started it. So Naman can file a case and make him close the business. That's what you are saying. He can sue.
So the restriction of time was 1 year. He opened in 2 months, so he can sue.
He can sue is what you have written. So remember, people, I told you one thing. Exact scenario also I told you in the class. What is that? Remember, people, because this is a scenario. Whenever there is agreement in restraint of trade, if someone is stopping you, the restriction should always be valid. It should be reasonable. Now, what is reasonable here? I said I will not open any store in this area. Okay, this is reasonable. I said I will not do anything within 1 year. This is also reasonable. But something else is not reasonable here. What is that?
Real diamond.
The reason is, people, you sold artificial jewelry to him. And when you promised, you're telling, I will not carry on artificial jewelry also, real diamond jewelry also. What I sold to is artificial jewelry, why should I not carry on this business? It has nothing to do with me and you because I did not sell that to you at all. Now that is unreasonable. Even though I have signed a contract that will not bind me. So you guys were right in 2 aspects. Time period was reasonable. Area was also reasonable. But the business is not reasonable. You wrote this only? Same thing you wrote, Nitin, I asked 3 times. After that, knowing that answer is right, now he is telling, hey, Karla. Yes, sir. So because of this, can Naman succeed, people? Answer is no, Naman cannot succeed because it is unreasonable. So the provision, people, is agreement in restraint of trade. It will be valid as long as it is reasonable. tenure is reasonable here, area is reasonable here, but not the business. On that ground, Naman cannot sue Kashish. Clear? All of you? So what will be my conclusion? Use the same thing. Whether Kashish is liable to close his business of real diamond jewelry, answer is rephrase it the same thing and write. Conclusion will be Kashish is not liable to close his business of real diamond jewelry because it has no or nothing to do with the business he has actually sold to Mr. Naman. Understood? Yes, sir. Samira? Understood this one? Hello? So see, as exception to section 27 is applicable to similar business only. Similar agreement between Naman and Kashish will not be applicable on business of, hence Kashish can continue his business of real diamond jewelry. I hope this is clear. Okay, next one. Mr. Singhania entered into a contract with Mr. Sonu to sing in his hotel for 6 weeks on every Saturday and Sunday. Mr. Singhania promised to pay 20,000 for every performance. Mr. Sonu performed for 2 weeks, but on 3rd week his health condition was very bad, so he did not come to sing. Mr. Singhania terminated the contract. State in light of the provisions of Indian Contract Act, can Mr. Singhania terminate the contract? Can he?
Yes.
So for that 2 weeks, we want to pay.
That is okay. They are asking you, can Singhania terminate the contract?
Yes.
They are not speaking anything about payment and all. Can he terminate?
Yes.
Why? I mean, yes, he can. Under what grounds you can terminate?
If the promisor failed to
Doctrine of? No. What is the provision? Doctrine of? Tell the doctor. Which doctor? Tell. Supervening impossibility. No, wrong. Why supervening impossibility? He is alive only. No. Correct. Difficulty of performances can never be considered as void contract. On what grounds? Abbas, what did you write?
Sir, if a party to contract has refused to perform or disabled himself from performing his promisee in its entity, the promisee may put an end to the contract since Sonu failed to perform the 3rd week.
Yes, people. This is considered as breach of contract.
Yeah.
When the actual breach, anticipatory breach. Here what has happened during the performance, the person has not come, he has disabled himself from performing. Actual breach, what is the right the other person has? He has a right to resign the contract. I also have a right to compensation. Hello, the t-shirt case. Yes or no? Now, what would be your answer in case Mr. Sonu turns up in the 4th week and Mr. Singhania allows him to perform without saying anything? So, he came, I allowed him to do it. Now what can I do? Now if I have allowed him to do, now I cannot terminate the contract. This also I told you. If you accept it later on, you cannot terminate it.
You can't change this.
Correct? You cannot do it. Third one, what would be your answer in case Mr. Sonu sends Mr. Mika on his place in 3rd week and Mr. Singhania allows him to perform without saying anything?
No, but he can claim the damage.
No, sir.
So first of all, can he allow? He can allow? He can allow? Yes or no?
So the promisee is different. He can't.
See, what would be your answer in case Mr. Sonu sends Mika on his place? Now, I have a right to stop him because the agreement involves special skill or talent. Could I have stopped him?
No.
Hey, when someone else comes, can I stop him or not? I can stop him because it involves special skill or talent. But what did this person do? Mr. Singhania allows him to perform. I am okay, you come down. Hello. Now they are telling without saying anything. So now they are asking you. Answer is same, no? What is that? Can Mr. Singhania terminate the contract? In the 3rd scenario, can he terminate?
No, he is allowing.
Because you have allowed people. Now what is my provision? What are you expected to write? Remember, who can perform the contract? Promisor himself or legal representative or 3rd party. When you have accepted the contract from 3rd party, you cannot again exercise it against someone else. So you have accepted from Mr. Mika and later you cannot again file a case on whoever that person is. Sonu. Are you getting the point? Hello? So can I terminate the contract? Answer is no. Can I claim compensation? Answer is no, because you accepted it. Hello?
Sir, if Mr. Singhania doesn't allow, so he can't do, right?
Now imagine Mr. Singhania doesn't allow him. Is Singhania right? Of course he is right. I'll be writing whenever the contract specifically says that the promisor himself has to perform. We saw now who can perform the contract. It is promisor himself when the contract says so. Now here is Singhania right in asking that? Yes, I can stop it. Getting the point? Yes? Huh.
Yeah, can't claim damages for missed third week performance of Mr. Solo.
When? In which case? He can claim compensation. He can claim. But in the third scenario, what is happening? Instead of me, someone else came. You accepted it. Then why will I claim compensation? Understood? Huh? See, in the third case, Mr. Singhania cannot terminate the contractor, nor can he claim any damage from Mr. Sono because you have accepted the contract from a third party. Hello? Could not perform as per contractor. Mr. Singhania can repudiate. Repudiate means what? Cancel. Second case, what happened? He came in the fourth week. He did not come in the third week. I accepted him. So in the fourth week, I cannot terminate the contract. But third week, he did not come. I can claim compensation for that. That is what they would have said. Had given his consent to continue. Mr. Singhania cannot terminate, but he can claim damages for the third week. Clear? Huh? Yes, sir? Done? Huh? Okay. Yes, so tomorrow again take up 4 questions only. It will be 14 to 14, 15, 16, 17. Take up 4. Clear? Yes? Yes, people. Let's quickly do 7 to 9. I think you guys have written. It was a pretty small paper for 7 to 9. It was hardly, I think, 12 marks that was covered overall, though it was 3 questions. But okay, nonetheless, we will see. Sahil sells by auction to Rohan a horse which Sahil knows to be unsound. The horse appears to be sound, but Sahil knows about the unsoundness of the horse. Is this contract valid in the following circumstances? They are giving you circumstance. What is that? If Sahil says nothing about the unsoundness of the horse to Rohan, is this contract valid? I know that the horse I am selling you is not right, but I still sell it to you without disclosing anything. Is this contract valid? Is it valid? Voidable? Valid? Fraud?
Sir, A is void.
Section 17? Fraud?
Section 24.
Abbas, valid or what?
A is void. Void.
Void. It's valid or void? Void. Voidable. You guys have to be very clear in using the word. Is it voidable? Is it void? Is it valid? It's voidable.
Only mistake is void. Section 20 to 22.
Correct. Now this one is voidable.
So section A is valid.
This is valid. Why, Abbas? Why is it valid?
Because I've written seller is not generally obliged to disclose.
Perfect. Right answer. Oh, this is not fraud. Why? Hey, in class 100 times I told you. I'm not. Hey, I will not tell this to Ramana that this mic is not working. I will sell it to him. Is it fraud? I told you it is a duty of the buyer to check. You should also check. You should also make your own inquiries. Hello? I am not under an obligation to tell everything. Seller is not under an obligation. Mere silence does not amount to fraud. We wrote that also. There is only 2 exceptions. What are the 2 exceptions? When does silence amount to fraud? When you have a duty to speak. When silence is equivalent to an acceptance. Hello? Okay. If Sahil says nothing about it to Rohan, who is Sahil's son?
Voidable.
Now what is the scenario? What is happening? If Sahil says nothing about it to Rohan, who is Sahil's son? So Sahil is selling it to Rohan only.
Sir.
Rohan is Sahil's son. And I know it is unsound. And I am still not disclosing anything. Now is it fraud or not?
No.
It is not fraud.
It is between father and son.
Huh.
It is duty to.
So is it void, voidable, valid contract? Is it fraud or not?
Voidable.
It's voidable. So it's fraud. What is the provision? Section 17, fraud, where mere silence amounts to fraud. Mere silence is not fraud. In that exception, you will be seeing people, what? You would have seen something called as fiduciary relationship. A father cannot lie to son. He cannot keep it silent. So it does amount to fraud. That is a place where you have a duty to speak. Hello? Yes or no? Extra gyan karke in PDF there was something in that this example also was there. Illa. Okay. If Rohan says to Sahil, if you do not deny it, I shall assume that the horse is sound. Sahil says nothing. Is it fraud? Is it fraud or not? Is it fraud? And say like this. If it's not fraud, say like this. Is it fraud? Yes. Why?
Silence is equivalent to speech.
When I have clearly asked you a question, if you do not reply, then I will think it is fine only. I have asked you, you have a duty to speak. Now silence is equivalent to speech. When you do not reply, I've clearly said, then I will think it is fine. If I said that and if you do not reply, it will amount to fraud. So in the given three cases, the first one is not fraud. The second and third one is considered as fraud. Section 17. Provision will be Section 17 of Indian Contract Act, and you will be writing what is fraud, and you will also be writing does silence amount to. Silence does not amount to fraud. However, this rule has exception. One is duty to speak. Next one is mere silence is equal to acceptance. Is considered as speech. So quoting that, I will be writing. Clear? So when I clearly say, when that is the scenario, then you have to go with that. When I have clearly asked you, you have an obligation to speak. Agreed? Yes, Sam. I don't know how many of you are realizing all these questions we have seen in class only as example. Yes? Okay. Mr. Vikas, a businessman, has been fighting a long drawn litigation with Mr. Neeraj, an industrialist. To support his legal campaign, he enlists the services of Mr. Manoj, a judicial officer, stating that the amount of rupees 10 lakhs would be paid to him if he does not take up the brief of Mr. Neeraj. Mr. Manoj agrees, but at the end of the litigation, Mr. Vikas refuses to pay to Mr. Manoj. Decide whether Mr. Manoj can recover the amount promised by Mr. Vikas under the provision of Indian Contract Act 1872. Now, why I say this question is good and tricky, because the question is drafted in a very complicated way. They've used the word like brief. They've used the word like judicial officer. So, remember, at times they can use in your exam, they can use certain complicated languages. Take some time and try to understand the scenario in such cases. Don't just focus on those words. Now, what is happening in this case? Mr. Vikas, a businessman, has been fighting a long drawn litigation with Neeraj. Vikas and Neeraj are fighting a case. An industrialist. To support his legal campaign, he enlists the service of Mr. Manoj, a judicial officer, stating that amount of 10 lakhs would be paid to him if he does not take up the brief of Mr. Neeraj. What is Mr. Vikas telling? He is going to one officer, judicial officer. That means imagine he is a lawyer, advocate. I'm going and telling him people what? I'm going and telling Manoj, you should not take up the case of Mr. Neeraj. Yeah, you should not, when he comes to file any case, if he wants to come for help, you're not supposed to take up his case at all. And I am paying for this, I'm paying you 10 lakhs. Now, whatever I did, now because I entered into a contract with Manoj, Manoj did not take up the case. After that, people, he is asking for 10 lakh, Mr. Vikas did not pay it. Now they are asking you, can Mr. Manoj recover the money? Now, under what grounds he cannot recover? What is the provision? First thing, it comes under unlawful object, unlawful consideration. That's the main heading, a provision. Under that you saw agreements that is opposed to public policy. Agreements opposed to public policy. So if you remember, last one, agreements opposed to public policy. Under that we started writing another branch. There it will come interference with course of justice. You cannot bribe the lawyer, you cannot bribe the witness, you cannot bribe the opponent lawyer, you cannot bribe the officers. Why? Because of that, the case is not going the way it can go or it has to go. So based on that, this type of contract is considered as opposed to public policy. So hence, whether Mr. Manoj recover the amount, conclusion, referring to my facts and provisions, Mr. Manoj will be unsuccessful in recovering the amount as this is a contract which is opposed to public policy.
So it is void, right?
It's void. Hello? Yes, sir.
So as you been official authority, we can't.
It is interference in the course of justice. So you cannot stop the case from going in the way it has to go. You cannot stop it.
Stifling, right?
No. That is criminal cases. This is any case.
Other than criminal cases.
See, stifling of prosecution and what is that? Interference in the course of justice. What is the difference between these two? Stifling of prosecution is nothing but settling of criminal offences. You cannot. Death, someone killing, robbery, theft, you cannot compromise them. You have to come to court. If you compromise it, that point comes under stifling of prosecution. Interference in the course of justice. The opponent lawyer will be purchased by giving 5 lakh rupees. I will give money to witness. I will tell don't come to court tomorrow. I'll give 1 lakh rupees to the judge. I'll tell him don't pass the order in the favor of the other person. I'll give you 1 crore. That is called interference with the course of justice. That's the difference between stifling of prosecution and interference with course of justice. Clear? Huh? Hello? Yes or no? Da? Okay. Next one, examine the validity of the following agreements under provision of Indian Contract Act 1872 and justify your answer. See, this is what I told you. They can ask you one main question. So, 9th question, under that they can ask you 5 questions also. And they're asking weightage is 7 mark. So, it will technically be like this, 2 plus 2 plus 2 plus 1. Getting the point? That is how this weightage will be. Now when I am writing it, we'll see whether they all belong to the same provision or different provisions. Getting the point? Okay. Miss Priya pays a sum of 10,000 to a marriage bureau to provide information about the prospective grooms for her daughter's marriage. What is the question? Examine the validity of the following agreements. Is it valid, invalid, void, voidable? What is it? Void. This is void you are saying. Marriage brokerage agreements, they are void or valid? Void. Yes or no? This is a valid agreement. Read carefully. Miss Priya pays a sum of 10,000 to a marriage bureau. Shadi.com.
It's not brokerage.
Yes, sir. Shadi.com. I told you it's not a marriage brokerage. Bureau is what? Data. Is it void? No, it is a valid agreement. Only marriage brokerage agreements are invalid. But in the case of marriage bureau, they just supply the data. Now, what is that? Correct. Now, Ashmita has a question, sir. How will we know all that in the exam? That's why, if you ask me, the examiner is in favor of you. I tell you this 100 times. The question will have hints. Read fully. Miss Priya has paid a sum of 10,000 to marriage bureau for why?
To provide information.
To provide information about the prospective groom. Nothing they have said for marriage, no. And then, is it a valid agreement, void agreement? Valid agreement. So how I'll write? Provision, conclusion.
It's no fact.
No fact, not required. Now how will I write? My question will start with like this. See, 1. Miss Priya pays 10,000 to marriage bureau and about cross relevant section, no? Section 10 and 23. Okay, an agreement is void if it involves an object that is against public policy. In the given case, people offering does not contravene public policy. Therefore, the agreement is valid and Miss Priya has entered into a valid enforceable contract. So, provision, conclusion. Provision, conclusion. Like that you have to write 4. Why Why are we following it this way here? The reason is they do not share a common provision. Maybe it will be different for the rest of it. Understanding? Okay, what is the next one? Bharat agrees with John to sell his white bull. Unknown to both the parties, the bull was dead at the time of agreement. Is it a valid agreement or what? Void? Void agreement, voidable agreement, voidable contract, what? Void agreement? Okay, what is the provision? Mistake? Mistake of fact. Unilateral, bilateral. So you guys have to write completely. Bilateral mistake of fact. It will be considered as void. Understood? Same scenario we saw in class also. The dog. That is when the Satish person came. Rishabh sells the goodwill of his shop to Omkar for 10 lakh and promises not to carry on such similar business within the local limits so long as Omkar carries on like business. Is it a valid contract or void? What do you think? Huh? What is it? Rishabh sells the goodwill of his shop to Omkar. That means I've sold my shop to Omkar for 10 lakh. And I've promised him not to carry on such similar business, same business, within the local limits so long as Omkar carries on the like business. Meaning as long as you are doing this business, I will not carry on this business. If it is 8 years, 8 years, 15 years, 15 years, 50 years, 50 years, I will not carry on a similar business. Is it reasonable? Is it valid or invalid? 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 Why? First of all, what is the provision? Agreement in restraint of trade.
Exception, the goodwill of.
Okay, so is it valid, invalid? It's okay, confidently say invalid. Why is it invalid?
Reasonable.
It's not reasonable. Okay. Abbas, why are you saying it is valid? Meaning what provision you wrote?
That exception to the goodwill of business. So it is restraint of trade. So it is valid.
So it's valid. So you're saying you can stop someone from doing business. Imagine if I'm doing this business for 20 years and you will also not do the business for 20 years. Is it valid?
So the year is not.
Until I do it.
So it is invalid. Accordingly to the restraint of trade, he sold his shop to Omkar for the rupees 10 lakh. Then he told that on the grounds, in the surroundings, I will be not carrying the similar business. But he did not mention any year, that is up to 1 year, up to 2 years. He did not mention any of it.
As long as he carries the similar.
business.
Now, so is it reasonable? When you start a business, do you start it with the mindset I'll do it for 3 years or you will always start it with the long term? So imagine if you're doing it for 5 years. That means 5 years I cannot do similar business. 10 years I cannot do similar same business for 10 years. 15 years I can't do. Why I'm telling that, remember people, most of them will write this restriction is what? They will write unreasonable and they will say it is agreement in restraint of trade. If you ask me people, this is a valid restraint of trade. Why? The reason is people, what are they telling you? Rishabh sells the goodwill to Omkar and promises not to carry on the similar business within local limits.
Only on local.
People in the entire country, I'm telling you, don't do the business in this place called Koramangala. Can I go and do it in Jayanagar? Can I go and do it in Majestic? Can I do in Electron Day? Okay, can I work at a Bangalore Bitpidre? Can I do it in Mysore? This is not a restraint of trade at all. It's a reasonable restriction. I told you 2 things you have to evaluate. I don't know why none of your brains worked on area here. All of you are saying time. Why did you skip the area part? They are just saying only local area. Did I say in the entire country? So it's a reasonable restriction. Hence it is valid. Agreed? Hello? Okay. A property worth 2 lakh was agreed to be sold for just 25,000 by a person of unsound mind. Is it a valid contract? No. Why they are telling you? Remember, there are chances people will write two answers here. One people will write, it's a valid agreement. You know why? They will write, the consideration need not be adequate. They will think that is the answer. Because they are telling the property worth 2 lakh is being sold for 25,000. So consideration need not be adequate and hence the contract is valid. People may write that. But what is the right answer? Competent parties, as long as the person is unsound mind, consideration is irrelevant. So the competency matters a lot because the person is unsound mind. The contract is, the agreement is void. It's a void agreement.
When he's unsafe, can't go to the contract.
Correct. So that's why they have clearly said unsound mind. So I will assume he's unsound mind and the contract, the agreement is considered as void. Clear? Yes, sir. Pretty easy paper, but little lengthy when you guys write. Understood? Okay. People. That's what. That's okay. You need to start from 17 tomorrow, right? Okay. Okay. 14th question. Yes. Okay. Yes. Ramana didn't come for test today. Why did Ramana? Ramana is like, which reason till I tell today? Stomach pain over, fever over, cold over, cough over, leg pain. Leg pain. Tell leg pain today. Tell the leg pain is not said yet. Say leg pain. Why did Ramana? Why didn't you write that? Ramana, this completion will never happen, Ramana. But you have listened to the class, no? You were there, no? Then take it up, it's okay. What I say is, you be in that class. Now I'll tell you what you would have written if, see, you're not coming way too, 5 hours before and all, you're not coming. Half an hour before you're coming. Correct? You just come and sit in the class. Whatever you have at least listened to, with that knowledge try to write. It will make some difference in your life. Correct? Always remember, failure is not failing. Failing to attempt is failing. Something else I said. Failure is not about failing. Failing to attempt is a failure. Quote for auto, no? This is best. Yeah? Because if you think of result and if you stop attempting people, then there is no bigger failure than that. Yes, and always remember, it's okay to fail in the class. No one is judging you. Will I judge you? Will I judge you? Yes. No. Samir, will I judge you? No. Yes? No. What is the only thing? If you guys write, if you guys have a doubt, come with your paper. I can correct you. It's okay for me to correct here than after results, right? Then what can I correct you? Yes? Write it. If you guys have any doubt, come get it clarified. Yes? Again, write it. It's okay. Attempting is more important. Clear? Okay. Mr. Chetan was traveling to Manali. How was this question?
So easy. That is
Easy.
that.
Natural.
Claim for damages or loss by
Compensation.
caused by a breach of contract.
Damages. Section 73.
Damages.
Okay, Mr. Chetan was traveling to Manali with his wife by bus of Hima. I thought of keeping it as Ramana and then I knew Ramana wouldn't come. That's why I kept it as Chetan. Ramana is cursing me. Leg pain. Okay. Mr. Chetan was traveling to Manali with his wife by bus of Himalayan Travels Private Limited. Due to some technical default in the bus, the driver has to stop the bus in midway in cold night. The driver advised the passengers to get to the shelter in the nearest hotel, which was at a distance of only 1 kilometer from that place. The wife of Mr. Chetan caught cold and fell ill due to being asked to get down, and she had to walk in cold night to reach hotel. Mr. Chetan filed the suit against Himalayan Travels Private Limited for damages of personal inconvenience, hotel charges, and medical treatment for his wife. Explain whether Mr. Chetan would get compensation for which he filed the suit under Indian Contract Act 1872. I hope you guys understood what happened. They were going on in a bus. The bus broke down. So the bus driver asked them to go and stay near a nearby hotel until the bus is repaired. So what did they all do? They got down in the midnight. They had to walk. They had to stay in one hotel. When this happened, all the other passengers were okay except Chetan's wife. Chetan's wife fell sick. Now that's why Chetan is filing a case on Himalayan Travels. Why? He wants to recover money for the inconvenience caused. Correct? They had to walk 1 kilometer, and instead of me reaching my place, I did not reach my place also. Next one, we had to stay in a hotel. I have spent money. Technically, why should I spend? Third one, medical charges, whatever, dolo, one doctor consultation, something I had to pay from my pocket. So what is Mr. Chetan claiming? Chetan is claiming all these charges. Now they are asking you whether Chetan will succeed in getting all the compensation. My answer will be provision. Provision is what? Section 73, that is damages. Because you see, this case will fall under which? We have so many types of things, no? Remedies, what and all we have? We have damages, we have injunction, we have quantum merit, we have specific performance, and we have, what else is there? Is it everything?
Yes.
Damages, suit for injunction, quantum merit, and recession. So now all of these are there. Now where does this case go? What nakshatra? The case goes in damages. That is where it more fits. Now the provision will go, people, damages, section 73. Whatever is directly proportional, meaning whatever is the inconvenience I did, that is the bus broke down. For that, whatever is the reasonable damages, that I will pay. I'm not that correct? No. Whatever is reasonable, I will pay. Now, what and all is reasonable here? Inconvenience, yes, reasonable. Directly proportional to whatever is a loss I made. Inconvenience, yes, I am liable. Second one, hotel, yes, I am liable. Why should you pay for the hotel? Because of my fault you are paying. Even for the hotel charges, I am liable. Third one, you caught cold. Medical expenses, am I liable? Yes, sir. Yes, sir. Why? Why, Nitin? Why do you think medical I am liable? Now, people, what are they telling you? There are 40 travelers that were traveling in that particular passengers that were traveling in the bus. Only Chetan's wife caught cold. They have only given her scenario, not even Chetan. Only Chetan's wife has caught cold. Now, this is unusual. Not everyone will catch cold. Now, people, anything that is not directly, it is not directly related to whatever I did. It is somewhere far-fetched. You falling sick has nothing to do with my bus breaking down. Because the rest of the passengers, that's not the case. Not everyone will fall sick when you walk in the night. Hello? Are you getting the point? Now, people, this becomes a case of special damages. Which one? Medical. Medical is not directly proportionate. It is not directly related. It is far-fetched. So my bus breaking has nothing to do with you falling sick. Because rest of all the passengers fell sick. Then I understand. Hello? Now that is a scenario, people. What I can recover everything, but I cannot recover the medical treatment because it is far-fetched. It is not directly related. If I am not wrong, you guys would have written all three is recoverable under compensation. Correct? So out of 4 marks, you will get 2 if you have written everything is recoverable. If someone has written anything with regards to inconvenience and hotel charges, but not medical, then you will get 4 on 4. And check provision, section 73. That is what you should always keep this in mind. Whatever naturally arose in the ordinary course of business, that is what you are liable for. Whatever naturally arose in the ordinary course of business. That means all 40 passengers fell sick, then yes. Natural course, that means it was not, it is not because of her problem. It is because of our problem. That is why everyone fell sick. That is what is the word you guys have to write. Naturally arose in the usual course of things. Hello? Agreed? Yes, okay. See, anything remote and indirect loss, we will not be liable. What is indirect loss? Hadley versus Baxendale. I made a delay in giving your that product crankshaft. For that time I am liable. Your factory was shut for 10 days. That was an indirect loss. For that time I am not liable because I was not aware of it. Hello. Are you getting the point? That is what they are written. So section 73, ordinary damages. I am liable for whatever naturally arose, but not for anything that is far-fetched. That means remote. Remote means what? Indirectly, not direct. Remote means indirect. For that I am not liable. Clear? I hope this is clear. Hello? Yes? Okay. Medical treatment is indirect. Hello? Okay. Next one, M Limited contracted with Shanti Traders to make and deliver certain machinery to them by 30th June 2023 for 11,50,000. Due to labor strike, M Limited could not manufacture and deliver the machinery to Shanti Traders. Later, Shanti Traders procured the machinery from another manufacturer for 12.75 lakhs. First contract was 11.5 lakhs. Because they did not deliver, I had to buy the same product with someone else for 12.75 lakhs. Okay. Due to this, Shanti Traders was also prevented from performing a contract which it had made with Zenith Traders at the time of their contract with M Limited and were compelled to pay compensation for breach of contract. Advise Shanti Traders on the amount of compensation which it can claim from M Limited, referring to the legal provisions of Indian Contract Act 1872. Now what happened in this case? Online, pause and see. If you guys missed the question, pause and see. Yeah? So what happened in this case? M Limited has entered into a contract with S Limited. Why? S Limited have agreed that they will deliver some machinery. Now S Limited did not deliver it to M Limited. I believe, correct?
M Limited is
M contracted to make and deliver certain machinery. So M Limited agreed to deliver it to S Limited. M Limited could not manufacture. So because of that, S Limited had to buy it from someone else. Correct? So they purchased it from someone else. So this contract was 11.5 lakhs. I purchased it from someone else for 12.75 lakhs. Due to this, Shanti Traders was also prevented from performing a contract which it had made with Zenith Traders at the time of their contract. Now, because M Limited did not supply the the machinery on time, I could not take up a contract which I had promised with another company, Zenith Limited. That means, imagine, if I got a machinery today, I could have done some work. Whatever Zenith Limited had given it to me. Now, because you did not give me the machinery, I could not do the Zenith Limited contract. That is gone. So, for that also I suffered loss. Now, they are asking you people, what is the money that S Limited can recover from M Limited? How much can they recover?
1.25.
1.25. Can they recover whatever is the money they had to pay to Z Limited? Because now we did not give their contract, Z Limited has filed a case on S Limited. You promised us to deliver some t-shirts, you did not deliver, so we are filing a case on you. Now we had to pay them some money as well. Now they are asking, can S Limited recover that money? Can they? Again people, the scenario is same only. What? Section 73, ordinary damages. Whatever is naturally arising in the ordinary course of business. You said me to deliver the machinery. I did not deliver. Because of that, you purchased it from someone else. The difference in price is 12.75 minus 11.5. 1.25 lakh is the money that I am liable to pay because it is directly and naturally arose in the ordinary course of business. Sir, this Zenith Limited is the indirect loss, remote loss. So for that, I will not be liable. Same in the case of the medical treatment in the above case. Same thing only, no. So in this case, I cannot recover any money that I had to pay to Zenith Limited.
Here in this question, it is abruptly known that payment to Zenith Limited is remote or indirect. That is not specific.
Okay, now for example, advise Shanti traders on amount of compensation which it can claim from M Limited. Now, in such questions, how to write? Now see, a good question in such way. Now what Varsha is saying is, sir, they have not given in the question whether Zenith Limited ka contract. Shanti S Limited, we do not know whether they have told this to M Limited or not. Question is silent. They did not tell anything whether they have told it or not. So how do you have to write? You can write it with an assumption. What is that? If M Limited are aware of the contract entered by S Limited with Z Limited, then S Limited can recover such loss from M Limited. Correct? Otherwise S Limited cannot recover from M Limited the money that has to be paid to Z Limited. This is clear? So what did I write? I wrote an assumption here. Now can we do this in the exam? Answer is yes, you can do in the exam. Any doubts here? Now remember in exams there
The question is like this: if Z get a claim from M Limited? For this, can we write that?
okay, first of all, what is that? Can Z claim money from M Limited? M Limited? No. Why? Privity of contract. Correct only, no?
Yeah, question is like that. We can apply the
Privity of contract.
Yes. Because there is no direct contract between Z and M, so this becomes privity of contract. Correct, yes.
Third party.
Correct. And remember in exams, these assumptions are very normal. You have to write. You have to say assuming or something like that. That is important. Yes, sir. Now even in this case, had they given no, then they would have written assumption. See here, regarding the amount of compensation which Shanti traders were compelled to pay to Zenith, it depends upon the fact whether M Limited knew about the contract of Shanti traders for supply of contract machinery on the specified date. If so, M Limited is also obliged to reimburse the compensation. Otherwise, M Limited is not liable.
Oh, this way we need to write.
Yes, that's where I'm saying you are supposed to write an assumption because the question is not clear. Getting the point? Hello? Yes, sir? Okay. The last one, in light of provision of Indian Contract Act,
So in conclusion only we need to write the assumption.
conclusion only. Because that is where they're asking whether he is aware or not. Yeah? Answer the following. Mr. S and Mr. R made contract wherein Mr. S agreed to deliver paper cup manufacture machine to Mr. R and to receive payment on delivery. On the delivery date, Mr. R did not pay the agreed price. Decide whether Mr. S is bound to fulfill his promise at the time of delivery. Huh?
Reciprocal process.
Yes, sir. First thing, people, the whatever happened between S and R is a reciprocal promise. Why is it reciprocal promise? S has agreed to deliver the product on a particular day. R has agreed to make the payment whenever the product is delivered. who failed to perform on the delivery date or did not pay the price. When the reciprocal promise, when the other party fails to perform his obligation, the reciprocal promisee is not required to fulfill his part of the obligation. That is the provision. Reciprocal promises. When one party fails to perform the obligation, the other party is not under an obligation to perform the obligation. Correct? Huh? Yes, sir. Amazon, I told you, when you do not make the payment, why will he deliver the product? So on that grounds, people know in the given case, people is yes bound to fulfill his promise? Answer is no. Yes is not bound to fulfill his promise. Next one, Mr. Y has given loan to Mr. G of 30 lakh. Mr. G defaulted the loan on due date and debt became time barred. After the time barred debt, Mr. G agreed to settle the full amount to Mr. Y. Whether acceptance of the time barred debt contract is enforceable as per Indian Contract Act 1872. What happened here? I said I'll repay the debt. I did not repay it within time. 3 years passed. The debt has become time barred. Now he himself has come and said I will repay that debt. Now they're asking, is this contract, if I accept it today, he has said he will pay. I am accepting it. After I accept that contract, will it be enforceable in the court of law? Is it a valid contract? What did you guys write?
Accepting to deliver.
Deliver Allah. He has accepted to pay the time bar debt. I said okay, thank you. I accepted it.
So, yeah.
It's a valid contract.
Exception of consideration. 20,
You,
23,
so what you guys need to write, people, is section 25. As per Indian Contract Act, section 25, what does it say? Exceptions to quid pro quo. Exceptions to quid pro quo had promise to pay time bar debt. Now if I accept it, people, it becomes a valid contract. Now he is agreeing to pay. If you remember, same example we had seen in class. Again I take a fresh check, I will say I will pay you again. For that have I given one more time 30 lakhs? No, the old 30 lakhs only has promised to pay again. Will there be again a consideration from my end? No. So exceptions to quid pro quo. So the provision is, people, section 25, which talks about exceptions to quid pro quo, contract being valid without considerations, which is promise to pay a time barred debt. Kira?
So what if after accepting that again he is failing to do?
He can go and file a case because he'll get another fresh 3 years. Even in the 3 years, if you do not go, again it becomes a time bar debt only. Yes, sir. Is this clear? Huh? Okay. Third one now. A and B entered into a contract to supply unique item, alternate of which is not available in the market. A refused to supply the agreed unique item to B. What directions could be given by the court for breach of such contract? What is the provision?
So that only I don't know.
That only, very good, Nakshatra. This is nothing but, people, suit for specific performance. Remedies of a contractor, whenever a product is of some special importance, or it is a rare item, it is an antique item, it is a unique item, the alternate of which is not available. In such case, the court won't tell you to settle money. The court will tell the other party to perform the contract. What was the example? Example was, there was a property in which a person grew up. The grandfather and parents' house, I told you. Now the court can say, no, hey, take 10 lakh and leave the house. No, the court will tell, you have to give the house only because it has some special importance in his life. Money is not a valid compensation there. So on that grounds I will write here, remedies, people, suit for specific performance. That's the provision. As there is no equivalent object available in the market, the person will be liable to give. A will be directed by the court to deliver the same product as the alternate is not available in the market. That's my provision and conclusion. Is this clear? So if you guys have written all of that, then yes, you will get 7 marks. Is this clear? Huh? Yes, huh? Okay. Online, I hope 180 minutes. So can I tell approximately for each mark you have around 1.8 minutes. That's the time you get. So if it's a 5-mark question, you try to do. You approximately get around 7 minutes for 5-mark question. 7, or let us imagine max is 8. So if it's a 5-mark question, you have max to max is 7 to 8 minutes to solve, to crack. Yeah, so that should be what you guys should be able to aim at. Okay, nonetheless, so please keep doing it. I know you guys are trying to write. Online, again, I'm telling you, if you guys are seeing it, pause it and then you try to write it on your own and then go and verify the answer when I'm telling it. Okay, Raj gives his umbrella to Manoj during the rainy season to be used for 2 days during examination. Manoj keeps the umbrella for a week. Yeah, here only you should understand. This is where I tell that. Don't you think we have seen same examples also in class? All these are past exam questions. While going to Raj's house to return the umbrella, Manoj accidentally slips and the umbrella is badly damaged. Taking into account the provisions of Indian Contract Act 1872, who will bear the loss and why? Who will bear the loss, people? You will be writing in the provision. First of all, whose duty it is to return back? Bailor, bailee. I have taken the umbrella. Then what will be my capacity? My capacity will be as a bailee. So duty of a bailee will come. What is the duty of the bailee? Duty of the bailee is to return the product, and if there is any time prescribed, it is my duty to return the product as per the bailor's direction. That is what he has clearly told. It will be given back within 2 days. So there is a clear timeline given. Now when there is a timeline given, it is your duty to return the product within the 2 days. If you hold the product beyond the 2 days time period, then you will hold it at your risk whether you take a reasonable care or not. That means what? Here they have said accidentally slips. That means it's not intentional, accidental. You have taken due care. Whether you take due care or not, people, if it is beyond that period, you are personally liable. So that is my provision. My facts will be 1 or 2 lines. How will you guys write the facts? Split that only in 2 lines. What is that? Raj has given his umbrella to Manoj with a condition of returning it within 2 days. Manoj keeps umbrella for a week. While returning it, falls accidentally and damages the umbrella. Now, what is the conclusion? Conclusion is referring to the provision and facts of the case. What happens? Referring to the provision and facts of the case. Who is that person? Manoj will be considered as liable to compensate Raj for whatever the damages occurred to the umbrella. You can take it from the question only. What will they say? Who will bear the loss and why? Manoj will bear the loss, referring to the duties of the bailee. That will be my provision. Provision is duty of a bailee. Is this clear? Hello? See, the goods bailed without demand as soon as the time for which they were bailed has expired or the purpose for which they were bailed has been accomplished. Agreed? I have to return it. Agreed? Okay. See the conclusion, how they have given. In the instance case, see, you guys try to use these words. In the instant case, Manoj shall have to bear the loss since he failed. See, question is who will bear the loss? Manoj has to bear the loss to return the umbrella within a stipulated, and section 1 clearly says that where a bailee fails to return the goods within the agreed time, he shall be responsible to the bailor for any loss, destruction or deterioration of the goods from that time, notwithstanding the exercise of reasonable care on his part. Is this clear? All of you? Yeah, okay. Next question. Mr. X sold his agricultural land for rupees 45,000 to Mr. Y with the condition that the price is to be paid within 1 day and the legal formalities for transfer of land would be done on next Monday when the government office would open. Mr. Y paid the amount as agreed, but on the day of registration, Mr. X took objection and demanded extra 20,000 for the land since the market rate of the land is rupees 65,000. In fact, the market rate actually is 65,000 only. State if there is any recourse available to Mr. Y and also to Mr. X in these circumstances. What will happen? They're asking you. What will happen in this case? X has agreed to sell his land for 45,000. But the actual value of the land is people 65,000. On the day of registration, after agreeing, X is telling no, the actual price of the land is not 45, it is 65. If you give me another 20,000, I will sell you the land. If not, I will not sell the land. So they're asking you in this case, who will succeed? Is it X or Y? That is, X can succeed in getting extra 20,000 or X won't succeed in getting that extra 20,000. What do you think? What is the provision? Darshan, what is the provision? This one. Why? Shiva, what is the provision? Shiva, what is the provision? What is the provision? You wrote this? No? Why? Oh, you didn't write test only, huh? Two only wrote. Arnav, what is the provision? No. Ganika? This one. Sopam? Sopam only, correct, no? Yes, Sopam.
Market rate is irrelevant once.
Market rate is irrelevant. Okay, but what is the provision? See, these are all your words. Market, now, can I search this anywhere in the law? Specific performance? Okay. Performance of contract. Now, people, what is X's claim, people? The value of the land is 65,000. I have agreed to sell it to you for 45,000 and you have also agreed. On the date of registration, X wants to go back, saying that the actual value is 65 and not 45. And hence I am demanding you extra 20,000. The question is, can X sell the land for 45,000? If at all yes, sir, will such contract be valid?
Consideration need not be adequate.
That is the answer. Provision, people, will be consideration definition. You need to write consideration cut definition 2D. At the desire of the promisor, promisee or any other person. Yes, sir. Agrees to do or abstains from doing. Does or abstains from doing. Promises to do or abstains from doing. Such act or abstinence is called as consideration. And always remember, consideration need not be adequate. That means what? It's okay. Even if you have agreed for 45,000, that becomes a valid contract only. You cannot back out.
But she is not agreeing to sell the land.
So you see from the top, X, what?
Sold is
Sold means what?
sir, but registration date in not.
Allah, sold means what? There is a contract between you and me that I will be selling you the land and you will be paying me. This is the price that you will be buying the land for. Agreed? Yes or no? Then
Sir, but registration not.
now I'll tell you one thing. Tell me one place where we have seen that if it is land, then registration is mandatory. Tell me where. Natural love and affection. Now, is this a case of natural love and affection? Then don't look for registration condition, not required here. It is not relevant here. You guys have to just pick up that particular, what is that? If it is inadequate, it's okay. Because according to us, we have made an agreement amongst ourselves. I will give you a land. Offer is there. You have accepted for it. Acceptance is there. So as per Indian Contract Act, offer plus acceptance is there. That is Transfer of Property Act. Why do you want? As per Indian Contract Act, offer acceptance is there, no? Only place where does registration come? Natural love and affection. If you first check, is this a case of natural love and affection? If not, then why do you want to bother? Are you getting the point? Hello, all of you? The case is the consideration need not be adequate. Whether X will succeed here, answer is no. Y will get the registration done at the price of 45,000 only. That will be my provision. That will be my facts, and that will be my conclusion. Is this clear? All of you?
21st.
There.
It's answer. I wrote the answer.
What was your answer?
Sir, it is bond bear by bail.
That's all. Duty of a bailee. to give back the product within 161. Duty of bailee. Give back the product as per the bailor's direction. Rahul found a smartwatch in a restaurant. He inquired about all the customers present there, but the true owner could not be found. He handed over the same to the manager of the restaurant to keep till the true owner is found. After a week, he went back to the restaurant to inquire about the smartwatch. The manager refused to return it to Rahul, saying that it did not belong to Rahul. In the light of Indian Contract Act, can Rahul recover it from the manager? Is it possible? Can I recover it? Okay, what type of provision is what? Finder of lost goods. Remember section 71. Easy way to section 71. Easy way to remember, people. Finder of lost goods. You can remember it like 71 only. 7-1. I used to remember it like this. It is like an F only, no? Yes, finder. So try to remember it that way. Yes, like this. Finder. So I'm just saying it is like 71 only, no? Yes, so try to remember it that way. Like that, another thing is, say for example, it's a wagering contract. Wagering contract, what is section?
68.
Section 30. Wager, correct? W. 30 it is. So imagine like a coin. You never know whether it is heads or a tails. Uncertain event. So that is how I used to remember. 3-0. Wagering agreement. Yes, sir. Agreement. What is the definition of agreement? Section?
23.
Agreement.
Two clause C.
2 clause E. Agreement. Forming consideration for each other. That's called as an agreement. 2E. Agreement. What is agreement spelling? Double E. 2E. These are things which I used to remember when I was in law. That's what how I did. Yes, consideration. We remembered for offer, agreement. We remembered contract.
Void contract, whatever.
Yes, 2J contract. So we remembered all of this. So all of this belongs to one place. I remembered like this. So all these sections belong in one home. All these sections belong to this home. So I remembered this as 2H. 2H is nothing but contract. So everything comes in contract. Like I remembered like that. Yeah. So whenever you guys ask, sir, how or what is the better way to remember the sections? Try to link it to anything. For example, there will be your date of birth. There will be something like that. Try to remember it that way. That is the best way you can remember more and more sections. Put some effort in remembering that. Yes? I'll send it to you. I'll pakka send it to you. Okay. Now people, what is that? Now, finder of lost goods. So they're saying section 71. What is the section 71, people? Whenever it is your duty to search for the true owner, but if the true owner could not be found, people, then whoever finds the product will become the next owner. In the given case, Rahul found the smartwatch. If at all the manager has put some expenses to find the owner, it is Rahul's responsibility to pay for it. But who can take the possession of the watch? It is always Rahul who can take the possession of the watch. So a person who finds the goods, if he cannot find the owner, will become the next owner for that particular product. Clear? Yes?
So I have to put in reasonable efforts to find the proof.
Yes. A person who finds goods belonging to another and takes them into his custody is subject to the same responsibility as if he were a bailee. Thus, a finder of lost goods has to take proper care, no right to appropriate the goods, and to restore if the owner is found. If owner is found, it is your duty to give it back. In the light of the above provisions, the manager must return the smartwatch to Rahul, since Rahul is entitled to retain the smartwatch found against everybody except the true owner. If true owner is found, you need to give it back to him. Here are the, okay, you can ignore that. Next one, Mr. Ramesh delivered gold ornaments to a jeweler. Mr. Arun, hey, you wrote 24th one, no? Okay. Mr. Ramesh delivered his gold ornaments to a jeweler, Mr. Arun, for polishing. Arun kept the ornaments in the locker of his shop and locked the premises before leaving. Unfortunately, during the night, thieves broke into the shop and stole the ornaments. When Ramesh asked for the return of his ornaments, Arun expressed his inability to do so and stated that he had taken as much as care of the goods as he would have taken of his own property. Ramesh, however, claimed compensation for the loss on the ground that ornaments had been delivered under a contract of bailment and the bailee was found to return them. The bailee was found to return them. Decide under the Indian Contract Act 1872 whether Arun is liable to compensate Ramesh. Is he liable? No, because whenever a person takes a reasonable care of the goods, then he will not be liable for any of the loss occurred. In the given case, what is the duty of the bailee? Duty of the bailee is to take reasonable care of the goods. What do I mean by reasonable care? As much as care an ordinary man would take for his own goods. So if I have taken that they have clearly given in the question only, he treated as if it is his own goods. So however I would treat my goods, I have treated your goods also in the same way. So my provision goes like the duty of the bailee is to take reasonable care of the goods, like a ordinary prudence man would do. Whatever a ordinary man would take the reasonable care, I have taken the reasonable care of the goods. Now that goes as my provision. What will be my facts? Write down the same thing in 2-3 lines. I have given, he has taken sufficient care, and there is a breakout and thieves have robbed the house. Now what is the conclusion? The conclusion is, people, Ramesh cannot recover any losses from Arun, as Arun has taken reasonable care for the products as a bailee and there has been no negligence. That is my conclusion. Clear? Simple? Yes? Okay. Let's discuss. We'll take like 5 questions. Yeah. Today also there was 5 questions only, no? You wrote? All of you? Illa. Others not writing. Wait, huh? Okay. State which of the following agreements are valid contract under Indian Contract Act 1872. They're asking which of the agreements are valid.
Sir, D.
Okay.
So first one is
A, who owns 2 cars, is selling red car to B. B thinks he is purchasing the black car.
sir, there is not concession added.
This can be answered in multiple ways. This can be considered as first one. There is no consensus ad item. That is the first question. First answer you can write. Next one is, I can also say the offer is not certain because I'm just saying that I want to sell a car. Which car I'm not sure. So the offer is also not certain. The third thing I can say, it can also be a case of bilateral mistake.
Mutual mistake.
The mutual mistake, the bilateral mistake. So whenever there is a bilateral mistake, so the answer can be written in any of these ways. Yeah, consensus ad item, mutual mistake, and what is that? No certain offer. All of this will come under the same genre only. So you can write answer under any of this. It is valid. If you get confused in any of these cases also, you can also write the given scenario comes under no consensus ad item, mutual mistake, as well as your offer. These things are same. Just like I had given you counter offer and unqualified acceptance, they also are same only, right? So you can always write both. Clear all of you? Yes? So is it a valid agreement? Answer is no. A threatened to shoot B if B does not lend him 2 lakh and B agreed to do it. Shoot. This can be considered as something which is forbidden or prohibited under IPC, and hence it is a coercion. So it is a voidable contract. A agrees to sell his house to B against 100 kgs of cocaine. Cocaine, unlawful. Lawful object, lawful consideration. I can consider this consideration as unlawful, and because of that the contract is void. A asks B if he wants to buy his bike for 50,000. B agrees to buy the bike. Is it a valid offer? Valid contract? Yes, it's a valid contract. Mr. X agrees to write a book with the publisher, but after a few days, X dies in an accident.
void contract.
It's a void contract. When they made it, it was valid, but later on it became invalid. That's why we can call this as people void contract. When you made valid, later on invalid. Supervening impossibility, also considered as subsequent impossibility. When made valid, later on becomes void. So that's 1 mark each, and that's 5 marks for you. A enters into a contract with B that he sells his house for 10 lakh to B. Further, they both signed an agreement that if B uses the house for gambling purpose, then B shall pay 50,000 for it. B agreed to do this. However, after a year of sale, B started gambling business in that house. Can A claim 50,000 from B? Discuss with reference to the provisions of Indian Contract Act 1872. What is that they're telling you, people? A has agreed to sell his house to B for 10 lakh rupees. But people, if at all this house is used for gambling, then B has to pay another 50,000 rupees for it. That is what they're telling you. So if it is for, if you're using it for any purpose, then 10 lakh. If you're using for gambling purpose, then it is 10 lakh 50,000. Imagine like this. So I can say there are two contracts here. One is for other purpose 10 lakh. For gambling purpose 10 lakh 50. So what is a provision?
24.
The provision, forget section. What is a provision?
So part is legal.
Whenever there is a legal part, see, when you're using the house for any purpose that is legal, I'm saying for 10 lakh, you can use it for any purpose, and that has no problem in the law. Now, whenever there is in a contract, there are two parts which is separable, which is, you can, separable, non-separable. In this case, it is separable. There are two different contracts. One is a legal part, one is a illegal part. The illegal part can be separate. Yes, sir. So this contract is different. This contract is different. This can be enforceable. This will not be enforceable by law. So unlawful part is void, which is legal is enforceable. That is my provision. Yes. Okay. That probably can be for 3 marks or 4 marks maximum. Seema was running a boutique in New Delhi. She has to deliver some cloth to her friend Kiran, who was putting up an exhibition at Mumbai. Seema delivered the sewing machine and some clothes to a railway company to be delivered at a place where the exhibition was to be held. Seema expected to earn an exceptional profit from the sales made at this exhibition. However, she did not bring this fact to the notice of the railway authorities. The goods were delivered at the place after the conclusion of the exhibition. On account of such breach of contract by railway authorities, can Seema recover the loss of profit under Indian Contract Act 1872? Understood the question now? Now in this case, what happened? You guys understood the question or not? Now what is the answer?
Section 73.
What, Ramana, what is the contract? Now leave section, tell me provision. Huh? Rajeshwari, what is the provision? Ganika, what is the provision? Then general damages. So remember, people, in the given case, see, it is first of all damages. What has happened? One lady has sent sewing machine. It has to go through railway and it has to be delivered in New Delhi. Now what has happened? The day she has given to the railway authorities, she did not say anything. She just said the sewing machine has to be delivered to the other place. That's all. Now because of that, what happened, people? The special circumstances are not communicated. That is, there is an exhibition, it has to be delivered within that. Nothing has been communicated. Now because of that, what people, whatever is naturally related to the contract, that is what you guys can calculate, or you can ask for compensation. So what you can claim is, people, ordinary damages and special damages are not enforceable in the given case because the special circumstances are not communicated, and that is the scenario. Understood? So in this case, can she claim the damages, the profits? Answer is no. But is the railway authorities liable? Answer is yes. But whatever is naturally related to that, for that they will be liable, but not for the profit that she has lost. Agreed? Because it is not directly related to what they have not done. Agreed? Yes. See, whenever you are writing ordinary damages, this words has to be mandatorily there. What is that? Losses that naturally arise in the usual course of business. This is ordinary damages. This is the word. It should be there. Yeah, and whenever there is a special circumstance communicated, then you can claim for the special circumstance as well. Agreed? That becomes your special damages. Yes, okay. And any case law you can quote there? Hadley versus Baxendale. So if anyone who has written that also, you will definitely get an extra mark. Crankshaft. Abhimanyu, a businessman, lost his important documents at a crowded railway station. Ramesh, a passerby, voluntarily collected the documents and returned them safely to Abhimanyu without expecting any reward. A week later, impressed by Ramesh's honesty, Abhimanyu wrote and signed a promise to pay 50,000 as a reward. Later, Abhimanyu refused to pay, arguing that the act had already been performed voluntarily and therefore did not constitute a valid consideration. Ramesh filed a case claiming that the promise was binding. Decide under the Indian Contract Act whether Abhimanyu is liable to pay. Whether Abhimanyu is liable to pay? Why, Abbas?
Sir, no such that intention.
Liable to pay? What is this? This is nothing but people. Voluntary. Whenever you guys are doing anything voluntary. So if there is any voluntary services and if a person has promised to reward you for whatever you have delivered voluntarily, this will come under exceptions to quid pro quo, section 25. That is nothing but whenever I am writing quid pro quo. Now he is saying that this cannot be considered as a lawful consideration. Exceptions to quid pro quo says the rule of quid pro quo. Whenever there is a reward or any compensation that the party has promised for the voluntary services, it will be enforceable in the court of law. And hence, can I recover the money? Yes, I can recover the money. My provision, I need to write this. Yes, sir. And I have told you one more thing. Whichever question they are asking about consideration, just write off consideration definition. What is consideration? When at the desire of the promisor, promisee or any other person does promises. So write the entire thing and write down. Also, the rules of consideration says that a contract which is made for past voluntary services, compensation for past voluntary services is a legally enforceable contract. So on that, yes, I can exercise this contract. So I need to write that entire thing under provision. And then will come facts. Facts can be 1 or 2 lines and conclusion will be same as it is. Ramesh filed a case claiming that promise was binding. Decide under the Indian Contract Act. Now, we'll be writing it this way. See, every conclusion can be different. You can write that the contention of Ramesh is valid and the contract is binding the parties. And hence, Ramesh can enforce the contract and will be successful in claiming the compensation of 50,000 which was declared as a reward. Yes, that will be my conclusion. Clear all of you? Yes. Okay. Because a businessman from Delhi entered into an agreement with Reddy, a trader from Hyderabad, to smuggle a large consignment of gold into India in violation of custom laws. As per the terms, Reddy would arrange the smuggling operation while Vikas promised to provide financial support and safe storage facilities. Both agreed to share the profits equally. The agreement also stated that Reddy would invest a portion of his profit in Vikas's legitimate textile business, which was a lawful activity. After the first successful operation, a dispute arose between the parties. Vikas received the smuggled gold but refused to share the profits, arguing that the agreement was unlawful. Reddy filed a suit for enforcement, claiming that at least the lawful portion of the agreement relating to the textile business should be upheld. decide whether the agreement is enforceable under Indian Contract Act 1872. Enforceable? Why?
Illegal.
What about this, that investment? Would invest a portion of his profit in Vikas's legitimate textile business, which is a lawful activity.
Binding contract also become void.
Tax.
So any contract
Any contract linked to illegal becomes
Become void.
Okay, you guys are saying any contract which is linked to illegality will also become void. Tacit is a silent contract. Huh? If separable. Okay. That is also one of the provision. One second. If separable and if it is non-separable. Okay, why do you think that is the answer?
Because whole contract was an unlawful contract.
Okay.
Money was
Okay, see, that's the main thing I'm trying to understand. Now you are saying agreement connected with illegal agreement. In the previous case also we saw, right? Unlawful in part and lawful in part. You guys said unlawful part is not enforceable, and a contract which is lawful, that will be enforceable. You only said, right? So wouldn't the same answer apply here? No? Why?
Sir, because
What is the difference?
amount coming from the legal profit is
so there illegal thing.
profit.
The profit is coming from
Illegal.
illegal activity. Okay. So, understood people, if you guys have understood the difference, the answer is that in the given case, what has happened, the entire contract is opposed to public policy, smuggling. Anything to do which is forbidden by law is considered as unlawful. So it is an unlawful consideration and opposed to public policy. Agreed? Hello.
So in that question, there was no opposed to.
Now, I'll tell you the difference. See, gamble is one part. There, what happened? There were two contracts. One is, if you use it for any purpose, you will give me 10 lakh. That's one contract. The another contract says, if you use it for gambling, you need to pay me 50,000. Can I say there are two different contracts? Now, can I separate? This is a different contract. This is a different contract. Can I separate it easily? Now that's why what did we do? We exercised this. We did not exercise this because there are two different parts. You can split the contract itself into two. Now in this case, what has happened? First you need to do smuggling. That's the primary activity. From this, if you derive any profits, that will be invested into textile business, which is legal. Now you tell me, how can I separate this? See, first of all, I need to get profits then. The profits are unlawful only. So because of that, this is not a separable contract. It is an inseparable contract. Because profits I need to make to invest it into the textile business. So if I take away profits, even profits is unlawful here. Then how will I be making profit to invest in textile business? Understood? So why did I tell you this is one of a tricky question? No, I would say 80% will be a failure rate in this particular question while you are attempting, because it is tricky. Second thing, writing provision is the challenge. Few people will write it this way, few people will write it this way. Answer is simple. Anything to do which is forbidden under the law, I always tell you, it will be there in the question only. See, to smuggle a large consignment of gold into India in violation of custom laws. Anything which is forbidden under any law, if you enter into a contract to do that, it is considered as what? Unlawful. That's the provision. So writing the provision here is a little challenging to exactly get that point. Understood? All of you? That's the provision. So will I get it? Answer is no. You won't get it. It is not exercisable. The whole contract is unlawful and hence it is void. Understood? All of you? This can be asked for say 5 marks, 5 to 6 marks. But how many of you were able to complete the paper? I don't know if you guys... See, that's where I tell you, if possible, try to come in home. I'm 100% sure you would have written for 2.5 hours. Yes or no? Try to have a clock. If you had written it here, if anyone has written, after say exact 100 minutes, They would have come and they would have taken your paper, or they would have given you some 5 minutes, 10 minutes grace. Agreed, huh? For people who had come here. So if you're doing that, continue to do that. Yes, as I told you, in law, there is two challenges. One is completing. The completion of paper, what is the biggest challenge? You will understand it while you're in exam only, if you do not write it here. Again, I'm telling you, but you will understand it when you're there. For people who are trying to take it up with the timelines, continue doing that. Yeah, it will definitely help you to go towards the 100 mark, whatever, at least 90, 95. Now today in the 5 questions, how many questions were you guys able to write? All 5 you were able to write? Comfortable? Yes? Okay. So by end of the week, by the time you start your next week, you should be able to write 6 questions in a day. Yes? Because today what happened? There was a 3-mark question, there was a 4-mark question. So it was not 5 into 5. So 3 was also there. There was a 4-mark question also. If I take an average, that means it was around 19 marks. So technically it's not 25 marks. Yes? All of you? Okay. Okay, next question. Okay. Mr. Lal, a well-known builder, entered into a contract with Mr. Kumar, a property developer, to construct a large shopping mall in Jaipur for a total consideration of 10 crores to be completed within 18 months. After the work began, both parties mutually decided to alter the nature of their agreement. By mutual consent, a new contract was substituted, under which Mr. Lal would, instead of constructing a 5-star luxury hotel on the same land for an increased price of 12 crore. So instead of large shopping mall, now they want to construct a 5-star luxury hotel. Okay. This new agreement expressly cancelled the earlier mall contract. However, 6 months after the new agreement was executed, the state government, under its urban development policy, passed the law prohibiting the construction of hotels in that particular commercial zone, though the construction of shopping mall was still permitted. Due to this prohibition, Mr. Lal stopped the construction work and informed Mr. Kumar that the contract had become impossible to perform. Mr. Kumar, however, filed a suit against Mr. Lal for breach of new contract, demanding damages on ground that Mr. Lal had failed to perform his obligation. Decide under the provision of Indian Contract Act whether Mr. Lal is liable for breach of contract or whether the contract has become void due to impossibility. First thing, people, you should be very thankful for this question. This question could be made very tricky. They made it easy for you. Very easy for you. For example, this last line could have been literally avoided, not required. It's an help that they made you. One more thing, one more help. This is an help they made you. This and all, if you give me as an exam or a question setter, I would have not added all these details at all. This is something which you guys have to figure out. Now, if you ask me, there is no question only here. Everything they have only explained. But yes, nonetheless, tell me what is the answer. I hope you guys understood the question. A and B entered into a contract to construct one shopping mall. After 18 months, they realized that no, shopping mall is not something that would work out for us. They want to replace this agreement with a new contract. That is, they want to build a 5-star hotel. After they decided and after they replaced an agreement, that state government passed a law saying that you cannot construct this 5-star hotel here. Now, because of this, what did the person decide? The person decided, let us cancel the construction. He informed the person, I cannot construct this particular thing anymore because the law has been made impossibility. They said you cannot construct it anymore. The other party is now filing a case on him, saying that you are doing a breach of contract. Now they're asking you, what is the compensation? Is it a breach of contract? No. What and all are the provisions? What and all you will write? Supervening impossibility. Okay, very good. You have to write. They're asking you breach of contract. Now, technically, there are 2 contracts here. One is a mall. Second one is 5-star hotel. What if they did not tell for which he is filing a breach of contract? Is it towards the mall or is it towards the hotel? It is my duty to write both. So, in this question, provision will be huge. You have to write what is novation. Whenever the parties under section 62 under a mutual agreement, when the old contract is replaced by a new contract, the old contract need not be performed and it is discharged by law. And because of that, you cannot claim any breach of contract or damages for the old contract, that is for the construction of mall. So that is done. Now coming to the 5-star hotel, due to change in section 56, correct, due to change in law, what happened? It became subsequent impossibility and hence it became a void contract. Yes, sir. Now it is impossibility of performance. Now because of that, what happens? You cannot exercise it. It is discharged by law. Even the 5-star hotel also, you cannot perform. So whether he'll be, can he exercise? Answer is no. I don't know who, Mr. Lala, or I don't know, Kumar, however, filed, I don't know. Okay, Kumar filed on Lal. So Lal is right. Kumar cannot, recover any damages from Mr. Lal, as one is discharge due to mutual agreement. Next one is discharge due to impossibility of performance, subsequent impossibility or supervening impossibility, which makes the contract as void. Hello? Yes? Done. See the answer, how big it is. You have to write all the provisions here. Novation, subsequent impossibility, and then the conclusion. Hello? Okay. Albert obtained 2 loans of 3 lakh and 4 lakh respectively from a reputed bank. Out of these, loan of 3 lakh was guaranteed by Robert. So 3 lakh, 4 lakh was taken, it seems. 3 lakh was guaranteed by Robert. Albert sent 2 lakh to bank but did not intimate as to how it is to be appropriated. He repaid 2 lakh to the bank. Albert repaid 2 lakh to the bank. Robert is a surety. I hope you guys understood. The bank appropriated the whole of 2 lakh to the 4 lakh amount. Robert objected on the decision of the bank. He argued with bank that repayment amount should be first adjusted to the guaranteed loan. State with reasons whether the bank was correct in its decision under the Indian Contract Act 1872. Understood the question? What happened? The person has taken 2 loans. One is 3 lakh, one is 4 lakh. The 3 lakh loan has a guarantee, which is given by Robert. It has taken as 2 different contracts. Now Albert repaid the loan, people. How much he has repaid? 2 lakh rupees. Now what did the bank do? Albert did not say to which loan I am repaying. The bank has taken the loan towards the transaction which did not have guarantee. So it has taken towards the 4 lakh. The guarantee, whoever is the surety, he has raised an objection. How can the bank do that? It is arbitrary. They cannot take the entire 2 lakh towards the loan which does not have guarantee. Even I should also get benefited. Now they are asking you whether state with reasons whether the bank was correct in its decision. Is the bank correct? You guys are reading the question first time here, Ada. You didn't even read it. Illa, yaka? Didn't write the test, okay. You can take up at least questions and see, no? Nothing. Okay, tell me at least what it is. What is the Shiva? What is the provision? Appropriation of payment. So is the bank right in what they did? Bank is right in what they did? Remember people, whatever the bank did, the bank is right, sir, because the question, most of the people will think the case in the form, in the scenario of surety and guarantee. The answer is not in that. The answer is in appropriation of payment. Surety is just a deception, that's all. So appropriation of payment rule is simple. If the debtor is silent, if the circumstance is silent, then who will have the right? The creditor's choice. So the bank has a right to take it towards 3 lakh or 4 lakh. It is its choice. So the bank took it towards 4. So whether the action of bank is right, answer is yes. The bank's choice is right. It's unquestionable. Understood? Appropriation of payment. That's the answer. Section 60. 59 is debtor or circumstance. 60 is the creditor. 61 is the payment. Meaning first FIFO when both are silent. C.A. Sarthak Jain had decided to get interior work for his new office. For this purpose, he entered into a contract with Measures. I don't know if you guys are realizing, are you getting the quality of questions? You just imagine, these are RTPs, MTPs. I have not even touched the past papers yet. So RTP only, this plus 40% is the quality in your main exam. Yes, sir. Hello? For this purpose, he entered into a contract with Measures Sharif Fine Interiors. It was agreed that Measures Sharif Fine Interiors will complete the interior work by 31st Jan 2025. On 2025, a CS Arthik Jain observed that only 20 to 30% work is completed. He decided to cancel the contract with Measures Sharif Fine Interiors. Measures Sharif Fine Interiors filed the suit against CA Sarthak Jain for recovery of the cost which he incurred on the interior work. CA Sarthak Jain argued that Measure Sharif and Interiors did not complete the work within the time as per the contract, and further the work done till 31st 25 by Interiors was of no use to him as he has to appoint new interior designer. Explain whether CA Sarthak Jain is liable to pay the cost of the work done by Sharif and Interiors under the provisions of Indian Contract Act 1872. What is the answer? Void contract? Why? What is a provision? I hope by now you and me both understand when I say provision. Now in the previous case, provision means appropriation of payment. You need to tell me what is a provision here. On what grounds you are telling that whether the interior company can recover the cost or not recover the cost. Under what provision? If these two words are wrong, your entire answer is wrong. I will not even read to whatever is the your biodata you have written there. What is a provision? What is a provision?
Compensation after the new one has been appointed, remaining amount has been.
So can he recover money or not?
So you can recover after deducting the reasonable prices which is used for the.
So the question is, I have invested 20-30%. Can I recover money for that or not is the question. Can the interior company recover the 20-30% or not? That is what they are asking you. CA Sarthak Line is he liable to pay the cost of the work done? Can they? What is the provision? Reciprocal promise. Why? What answer do you have in reciprocal promise? No, answer is wrong. See, I thought at least you would say the wrong answer in a right way. That also is wrong only. 90% people will write it as quantum merit, as much as performed. That means what? Hey, you appointed me to do the entire interior work. I have done 30% it seems. And the person cancelled the contract. 30% I have done. Can I recover that money or not? Yes or no? Can I recover or not? So people generally write it quantum merit, but it is wrong. Why? Here again they have given one more hint. What is that? See, first of all, two provisions. One, people will think quantum merit. It's not quantum merit. Now, what is the provision under which I will write it? People, the party can cancel the contract, rescind the contract when the contract is not performed as on the agreed time. So you have clearly said that the agreed time is what? 31st January 2025. The contract is not performed as on 31st Jan 2025. When the contract is not performed as on the agreed time, the contract may be voidable at the option of the party. Now it is my choice. Now I can put an end to the contract because it is not performed on the given time. So because of that, I will treat the contract as void. It is technically voidable. I will put an end to the contract. So I am rescinding the contract. Now the question is, whenever it's a voidable contract, what is the thing? Whatever benefit I have received, I have to return it back. I have taken some benefit. I have to return it back. Now the question is, have I taken any benefit? For that, they are only helping you. I don't know why they are helping you so much. Measure Sharif and okay, see here. CA Sarthak Jain argued that measures Sharif and interiors did not complete the work within the time. So within the time,
Breach of
so I can breach of contract when the it is not agree. I mean, it is not delivered as per the agreed time. Yes, sir. So you can resign the contract. Okay. As per the contract, and further, the work done till 31st December by Measure Shelley is of no use to him. So what benefit have I received? As he has to appoint a new interior designer to re-get everything.
yes, sir.
So have I received any benefit? No, that is my second part of the done. Second part of the answer. What is that? In a voidable contract, a person who treats the contract as invalid will have to return whatever is the benefit received. However, in the given case, Mr. Sarthak Jain has not received any benefit. As the 20 to 30% thing delivered is of no use, and he has to get another interior designer to work the entire thing yet again. So the answer will be what, people? The Sharifai interiors will be unsuccessful in recovering. Even the cost that they have spent, 20-30% also they cannot recover. Understood? Hello? Pakka? Yes? When will it become the case of quantum merit? Quantum merit will come in the scenario 100% of the work is done. I mean 100% of the work was given, but the person has only completed 30%. Completed 30%. Now they would have given in the question the rest of the work should be redone by another person. Contract can be divisible. So in that case, what do? I have to pay for at least, now imagine that we wanted the interior work for this entire floor, but he has done it for 3 classrooms. Another 4 classrooms it is not touched. 3 is done. For that I have to pay. That is the case of quantum merit.
Benefit has been received by the party, we are liable to pay.
They would have given work completed. 30% of the work completed.
So here the 20 to 30% work is completed is given.
That's what I'm saying. They would have said this is given no here.
No use of. No use.
So if that is not given, then yes. That's where I'm saying 30% work completed, and the rest of it he had to get it done again from another interior designer. Here they are telling they have to get everything done from another person. So no, not possible. Understood? Not liable to pay the cost incurred. Did not provide. Because what is the answer? Any benefit received should be returned back. I have not received at all. Are you getting the point? That's why the words makes a difference. Clear? Rakesh, I think this is clear. Okay. Rohan of 17 years has purchased a mobile of 25,000 for his online classes from mobile sales center on credit. On due date, he did not make the payment of mobile. Mobile sales center sued Rohan and his parents for the price of mobile. Rohan has 15,000 as his cash balance, but his father has enough money to pay the price of mobile. Examine the given situation and answer who will be liable to pay the price of mobile as per the provision of Indian Contract Act 1872. Who will be liable? Dad will be liable. Why? Minor case. The dad will be liable. Why will dad be liable? 100 times in the class I have told you, a minor can never bind his parent or guardian. That's the exact provision they want us to write. So you have stepped properly, very grandly, you have stepped on a landmine. So a minor can never bind a parent or a guardian. Here, even if the parent has money, parent is not liable.
So the amount which he has is
Up to 15,000, whatever it's there, that is liable. Beyond that, people, minor will not be liable. That's the answer.
because it is for the essential
Yes, sir.
necessities.
Now see what do they write. A minor is not capable of entering into a contract to the minor is what I mean. So cannot enter into office liability. Parents or guardians are also not liable for any contract entered by the minor. See this. However, a minor is liable for supply of necessaries. Now someone asked a question, sir, how will we know it is necessaries or not? You asked me, remember? Now that's why they are helping you so much for online classes. Make sense, now it becomes necessity, So now what I'll write the minor estate is liable for necessaries. Estate means what? Whatever minor has, that is liable for necessaries. How much does minor has? Minor has 15,000. So minor is liable up to the extent of 15,000. Parents are not liable. Clear? All of you? Rahul hired a car. Okay. Rahul hired a car for 15 days from Measures Kushwa Travels after 5 days. Rahul hired a car for 15 days from Measures Kushwa Travels. After 5 days, Measures Kushwa Travels demanded back his car from Rahul. He was also agreed to compensate for any loss suffered by Rahul due to such premature return of goods. But Rahul refused to return the car before the period of bailment, that is 15 days. Measures Kushwa Travels sued Rahul for recovery of car, referring to the provisions of Indian Contract Act whether Measures Kushwa Travels can recover car from Rahul before the time fixed for bailment or not. They can recover.
No, sir. It is a non-gratuitous bailment.
It's a non-gratuitous bailment. Very good, people. Hey, there are two types of bailment. One is gratuitous, one is for hire. Non-gratuitous. Gratuitous bailment alone can be cancelled. You can ask for returning the goods anytime, only if it is a gratuitous bailment. When no consideration is involved, then compensation will come. You have taken, your friend has taken the vehicle from you. You're asking them to return it back within 5 days only, but you gave it for 30 days. They have spent money to service the vehicle. You have to pay for it. That's why they're confusing you by saying compensate. But however, in this case, it will not come. Why? Clearly, the second word itself is the answer. The car was hired. Whenever the bailment is for consideration, that means it's a non-gratuitous bailment. In such case, premature termination is not possible for any purpose other than inconsistent use. Now, in this case, it is not an inconsistent use. So, in the case, can they cancel the bailment? Answer is no. Provision is that can they recover? Answer is no. They cannot recover as it is a non-gratuitous or a bailment for hire. You can write it as anything. Understood, all of you? Yes. Next one. Ajay appoints Vijay to sell his electronic goods lying in his godown. He also agrees to give 10% commission on the sale price to Vijay. Afterwards, Ajay revokes Vijay's authority by sending the letter to Vijay. The letter was sent on 3rd March, which was received by Vijay on 7th March. On 5th March, Vijay sold the goods worth 1,20,000. He claimed commission from Ajay, but Ajay refused as he already revoked the agency before the sale of goods. Referring to the provisions of Indian Contract Act, whether Ajay was liable to pay commission to Vijay or not. What happened here? Ajay has appointed Vijay as his agent to sell the goods, and he will get 10% commission on whatever sales he makes. Later, people, Ajay has revoked Vijay's agency when he has written a letter on 3rd March that has reached to him on 7th March. Now, meanwhile, what happened on 5th March, Vijay has done a transaction worth 1,20,000. They're asking people whether Ajay was liable to pay commission to Vijay because he has done a transaction after he has revoked the agency. So, is Ajay liable to pay commission to Vijay? Is it required? Yes. Why?
So because he came to know about it only on 7th March, but the transactions happened on 5th March before the communication was accepted by the.
Understood. So provision goes effect of termination. When will the termination be effective? Whenever it comes to the knowledge of the agent. For the agent, if at all they have asked the third party, whenever they knowledge of the third party. You remember, Hello, in the given case, when does the agent comes to know about it? Agent comes to know about it on 7th. So that is when the agency is revoked. Whereas the transactions happened on 5th. So for whatever the transactions happened, yes, people, Ajay will be liable, and they have given you what is the amount. They have given you what is the percentage. Calculate and write also.
12,000.
So he is liable for 12,000 rupees, and he has to compensate Mr. Vijay. Is this clear, all of you? There was a difference between bailment and pledge. Direct answer, I think you guys could have managed. Bailment is your generic transaction, pledge is always for security. Yes, people, the next 5, we wrote 5 only, no, here. Mr. VG and Mr. PG were trading in unlisted shares for the last 7 years. They used to borrow funds from each other whenever required for any trade. Within a week's time, they used to refund the money to each other as per the circumstance of the case. They were following this practice for the last 5 years. On 25th Jan 2025, Mr. PG wants to buy 20,000 shares of unlisted company at 500 rupees each. But due to insufficiency of funds, he asked Mr. VG for 40 lakhs. VG transferred 40 lakhs to Mr. PG after about 3 months. To PG. Full stop. After about 3 months, Mr. VG reminded that Mr. PG had not refunded rupees 40 lakhs to him till then. He asked him to pay back his money. Mr. PG told him that he was trying very hard to sell the shares at a reasonable price of 10% more than price at which he brought these shares, but was unable to do so due to market conditions. He asked Mr. VG to sell his shares on his behalf and authorized him to appropriate the amount of loan of 40 lakh with interest out of the sale proceeds. Mr. VG agreed to do so. After about 15 days, when market started recovering, Mr. PG denied and revoked the authorization by saying that he would sell his shares himself. With reference to the provisions of Indian Contract Act, whether the revocation of said agency by Mr. PG was lawful. What is the provision?
Agency by interested party.
If the agent has an interest in subject of matter of
That is a complete provision. If the agent is interested in the subject matter, the agency stands irrevocable. Now, in the given case, I told you, you sell the property, you take your money from that. In this, they have just given shares. You sell the shares and take the money out of that. Now, because the agency is irrevocable, because even I am interested in the subject matter, my provision is that which agency cannot be revoked? The agency in which the agent is has an interest in the subject matter, such agency cannot be revoked. In the given case, the agency cannot be revoked. That is my provision. It's a September question, yes. And in solution, you wrote answer you had written Hello. Okay. Provision wrong or correct?
Provision correct.
Okay. So people, if provision is correct, you will get the mark. The provision is the interest in the subject matter. Agency is irrevocable. Conclusion. So no, you cannot revoke the contract. Hello? 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 Yes, sir. Okay. This revocation is not lawful. Examine whether the following constitute a contract of bailment under the provision of Indian Contract Act. Vikas parks his car at a parking lot, locks it and keeps the keys with himself. Is it a bailment or not? No. Why? What is the provision? One word is answer. One word is answer. Why is parking not considered as bailment? One word is answer. First of all, is it a bailment or not? No. Why? People, I'm keeping the car there, people. Possession is not given is not the answer. You should specifically tell that what is given is custody. My park is parked in the Forum Mall. Can they shift my car from one place to another? Then what do they have? What they have is custody. Control is with me. Yes? Then next one, seizure of goods by custom authorities. I did some smuggling. I did not pay custom duty. What did the custom authorities do? They have seized the goods from me because I did not pay whatever the duties and all. What would they do? They come, they bring it, and they further sell it in the auction also, or they will keep it until whatever is required. Now you tell me, is it bailment or not? Why? Do they have control or not? Custody only. Seizure of goods.
No possession.
The customs authorities, they do not have control. People, authorities, people, they have control over your product. Of course they have. I'm telling you, if you do not pay the money within 1 month, do you think they will wait with your products in the godown only? They will auction it off. What more control you want than that? Hello? Yes or no? Custody, this is the word. If this is not there, take away 3 marks from your answer. Custody should be there. That's the main word. Okay, Sarthak is employed as a cashier on a monthly salary of 50,000 by ABC Bank for a period of 3 years. Mohit gave surety for Sarthak's good conduct. After 9 months, the financial position of the bank deteriorates. Then Sarthak agrees to accept a lower salary of 40,000 per month from the bank. 2 months later, it was found that Sarthak had misappropriated cash from the time of his appointment. What is the liability of Mohit taking into account the provisions of Indian Contract Act? What is the liability? Nothing but, people, I'm telling you, provision is nothing but, see, this is the contractor. Later on, the bank and the person, they have changed their agreement. So variation in the contract without surety's approval will always discharge the surety because there is a change in the contract. So when there is a variance in the terms and the contracts between creditor without surety's consent, it would discharge the surety in respect of all transactions taking place subsequent to the variance. Now, when did the variation happen? After 9 months. Hello? So, surety is discharged after 9 months, not for the 9 months. Hello? Yes, sir? Yes or no? Okay, next one. Ayaba, what is this? This big girl. Paridhi, a minor falsely representing her age, enters into an agreement with an authorized laptop dealer, Mr. Mittal, owner of MP Laptops, for purchase of laptop on credit amounting to 60,000 on 1st August 2022. She promised to pay back the outstanding amount with interest at the rate of 16% per annum by 31st July 2023. She told him that in case she won't be able to pay the outstanding amount, her father, Mr. Ram, will pay back on her behalf. After 1 year, when Paridhi was asked to pay outstanding amount with interest, she refused to pay the amount and told the owner that she is minor and now he cannot recover. Okay. She will be a major on 1st Jan 2025 and only after that agreement can be ratified. Explain by which of the following ways Mr. Mittal will succeed in recovering the outstanding amount. By filing a case against Paridhi, a minor, for recovery of outstanding amount with interest. Will he na? Void ab initio. By filing a case against Mr. Ram, father, will he succeed? No. Why? Provision. Minor cannot bind parents or guardian. That is a start using the provisions. Cannot bind. Word that should be that. Am I explaining the entire paragraph? Don't you think I'm just telling the keywords? That is what should be there.
The case study of
Dharmodas Ghosh, you can write. By filing a case against Paridhi, a minor, for recovery of housing after she attains majority, possible? Minor agreements can never be ratified. That is the answer. Understood? Done. Ankit has taken a loan of 1 lakh from Kishore on the guarantee of Sudeep at the interest rate of 12% per annum. After some time, due to financial crisis of Ankit and at his request, Kishore reduced the rate of interest to 8% and also extended the time for repayment of loan without the consent of. Same thing, What is that? Variation. Hello? Surety is always discharged for the subsequent thing. Yes or no? Classify the following transaction according to the types of the goods they are. A wholesaler of cotton has 100 bales in his godown. He agrees to sell 50 bales and these bales were selected and set aside. What type of goods is this? These are called ascertained goods.
Existing goods comes under asset.
They are existing goods, correct?
Because they are selected from 100. Particularly 50 they are selected, specified, identified.
The contract is for logic is from the bulk separated.
Existing goods the section.
Yes. Now the next one, A agrees to sell B 1 packet of sugar out of the lot of 100 packets lying in a shop. What type of goods? Uncertain, because I don't know which one I'm going to get. It is still in the 100 packets, so it is a uncertain goods. T agrees to sell to S all the apples which we produced in his garden this year. A textile merchant for 50 rolls of premium silk cloth at an agreed price. It was clearly mentioned that the cloth should be of premium quality silk and suitable for manufacturing wedding garments. Mr. Kapil delivered the goods on the scheduled date. On a casual examination at the time of delivery, the rolls appeared to be fine, so Rahul accepted them. However, later, while cutting and using the cloth for tailoring, it was discovered that the rolls contained a mixture of synthetic fiber and had hidden defects. See, hint. See, hidden, latent. That's why I always say examiners will help you. They love you. If not, that's why you guys generally ask, sir, how will we know the defects are hidden? They always will help you. The question will be very to the point. That's why I say read the question. That's the best habit. Okay, such as small holes and stains. These defects made the cloth unfit for making wedding garments, causing heavy losses to Rahul. When Rahul demanded a refund, Kapil refused, contending that Rahul had already inspected the goods and accepted the delivery. State with reasons whether Rahul can reject the goods and recover the price under the Sale of Goods Act or not. Possible, la? What type of goods are these? Premium silk cloth. So I'm saying premium silk. I'm selling it by a description. So whenever I'm selling by a description, it has to always meet with the description.
Sale by description section.
And the quality and fitness, they don't fit for wedding arrangements. Sale by quality.
Yes, so one more thing is, it was clearly mentioned that the cloth should be of premium silk, quality silk and suitable for manufacturing wedding garments. Hey, appeared to be fine on a casual inspection. And hidden defects. These are all the provisions I need to write. So I can write this answer under one is sale by description. And I have to check. I should be given an opportunity to check. And it is hidden defects which is not visible to a naked eye. It is not visible. In such cases, I cannot be saying that you have already examined the goods. I am still protected. That is one thing. And remember, whenever I have made known my purpose, you have to sell me the product which belongs to that quality or fitness. This premium wedding, it is clearly made no. So on these grounds, people, am I liable? Answer is no. Implied condition. So what can the person do? He can cancel the contract. He can also claim damages if needed. Hello? Do not forget to write description. That is the first thing they are saying. Yes or no? Yes or no? That will be my provision. Hence, Rahul is entitled to reject the goods and recover the price. See, this is important. If people do not write this, you are gone. Because you need to say it is implied condition or implied warranty. Yes, sir. Kapil cannot avoid liability merely on the ground that casual inspection was done because it is defects. Look at the word. Why do I say latent? That's why I say keywords. That is important. That is what will be picked to give you the mark. Hello? A good question. Miss Seema went to local rice and wheat wholesale shop and asked for 100 kgs of basmati rice. The shopkeeper quoted the price of the same as 125 rupees per kg, to which she agreed. Miss Seema insisted that she would like to see the sample of what would be provided to her by the shopkeeper before she agreed upon such a purchase. The shopkeeper showed her a bowl of rice as a sample. The sample exactly corresponded to the entire lot. The buyer examined the sample casually without noticing the fact that even though the sample was that of basmati rice, it contained a mix of long and short grains of rice. Exact thing we saw by giving Shiva as an example. The cook on opening the bags complained that the dish, if prepared with the rice, would not taste the same as the quality of rice was not as per the requirement of the dish. Now Miss Seema wants to file a suit of fraud against the seller, alleging him of selling a mixed good and cheap quality rice. Will she be successful? What would be her answer in case Miss Seema specified her exact requirement as to the length of the rice? There are two questions. One is here, one is here. First question, it is your duty to check. Sample was specifically what was shown was what was bulk corresponded to the sample. In that case, it is the duty of Seema to be careful. She should have, because it is not something latent, Noda, clearly visible. So Seema cannot reject the product. Is it clear, all of you? The next one, what would be your answer in case Seema specified exact requirement of length? Imagine I clearly said I want long grain rice only. Now I have made you know my purpose. Quality or fitness will now come into picture. It is your duty to give that. Allah, I am saying my requirement. Whenever I say my requirement, fitness will come. No. So it is your duty to fit that purpose. Now in that case, yes, I can reject the goods, but not in the first case. Understood? Hello? Because people, yes Ram, correct. KVA tempter will apply. X contracted to sell his car to Y. They did not discuss the price of the car at all. X later refused to sell his car to Y on the ground that agreement was void, being uncertain about the price. Can Y demand the car?
Yes.
Yesterday we saw that people, if at all ascertainment of a price, remember in Sale of Goods Act, even if the price is not ascertained, the buyer has to pay what is reasonable goods. That is what reasonable price, remember. Are you guys seeing that these are the words we write in our notes? You need to think if you remember that is sufficient. But it is your intelligence to build the answer. And that is what I am trying to do through this tests. Hello? That is okay. This will make up for your grammar mistakes. It will completely make it up for your grammar mistakes. Clear? You have to underline them. Okay. Mr. Prakash reaches a sweet shop and asks for 1 kg of barfi. The sweets are fresh. Seller replies, sir, my all sweets are fresh and of good quality. What will this become? Description. I am describing my sweets as fresh and good quality. It is your duty to make sure you satisfy the description. Prakash agrees to buy on the condition that first he tastes 1 piece of barfi to check the quality. The seller gives him 1 piece to taste. Prakash, on finding the quality is good, asks the seller to pack. On reaching the house, Prakash finds that barfi is stale, not fresh, while the piece tasted was fresh. Now Prakash wants to avoid the contract and return the barfi to the seller. See what happened? One, sample should correspond to the bulk. Next one, description. When you say it is fresh and of good quality, you have to satisfy a description. Can I say sample and description? Yes. State with reasons whether Mr. Prakash can avoid. Will your answer be different if Prakash does not taste the sweets? What will be your answer? If Prakash did not taste the sweet at all, sample he is not taken at all, can he still cancel the contract? Why?
It did not correspond
Stands for the description.
if you don't specify the fresh.
If fresh good quality is not satisfied, that's a different story. That is what they're telling. In the instance case, the sale of sweet is by sample and the quality of bulk does not correspond with quality of sample. Hence, Prakash can return the sweets and avoid the contract. In other case, the sale of sweet is by case of. Yes? Hello? Done. 43. What has happened in 43? In this case, what happened? In this case, if you see, when goods are bought by description, what are the goods bought here? You have clearly said no, premium silk cloth. So, when you supply me the goods, now I'll be given an opportunity to check. I'm inspecting. Now, if at all there are hidden defects, now first thing your goods did not satisfy with the description. And any defects which are hidden, latent in nature, those things will not bind upon me in the contract. If at all it is visible, then I am liable, like that long grain and short grain. Here it is a latent thing. How will I be able to make it out? That is what they are telling you. Clear? It was difficult. Okay, we'll see. Mr. Rohit, the trader, entered into a contract with Mohan for the purchase of 100 shares for a total consideration of 1 lakh. The agreement expressly provided that ownership of the goods, the ownership of the goods would pass to Rohit immediately, while the price was to be paid in 2 equal installments within 30 days. The goods were duly delivered in accordance with the contract. However, when the second installment became due, Rohit defaulted in payment and contended that since a part of the price remained unpaid, the transaction amounted only to an agreement to sell and not completed sale. On this basis, he refused to pay the balance amount. Examine the legal validity of Rohit's contention with reference to the Sale of Goods Act. What it is, people?
Higher purchase.
Sale.
Ownership is transferred. But still
He is telling ownership is transferred now, but he said as the payment of price will be in 2 installments in the future, because of that, he is saying it is just an agreement to sell and not a sale. Price is irrelevant for the ownership is transferred. So the sale is made. Okay. So the exact answer was, people, if you guys remember, if the property in goods is transferred at the time of contract, it is a sale. If the transfer is to take place at a future time or object to some conditions, it is an agreement to sell. Thus, the distinction lies in passing of the ownership. In the former, ownership is transferred and the buyer becomes owner and must pay the agreed consideration. One more thing you can write here is, people, always remember, in a contract of sale, the ownership can pass immediately and the delivery can be in the future, the payment can be in the future, the payment can be in installments, and the delivery can be in installments. So that is what is the scenario. You guys you can also write that point. So it is all subject to the contract. If you guys want to transfer the ownership immediately, payment of the price does not decide transfer of ownership. In the given case, transfer of ownership happened with immediate effect. So because of that, people, it is not agreement to sell, it is contract of sale only. Because a sale has nothing to do with transfer of, payment of price or transfer of delivery. It is irrelevant to decide transfer of ownership. Yesterday only we saw that. Agreed? So that is the answer here. Okay. See, since the ownership of shares has already been transferred to Rohit at the time of delivery, the contract was a completed sale. Rohit's contention that it was only an agreement to sell is legally unsustainable. He is bound to pay the balance of the price. Simple? Yes? Okay. Next one, Mr. Samir, a retail shopkeeper, purchased 10 cartons of packaged fruit juice fruit juice bottles from Fresh Foods Limited, a reputed beverage dealer. The cartons were sealed and appeared to be in good condition, and therefore Samir accepted them without objection. Subsequently, when the bottles were sold to customers, it was discovered that several of them were contaminated with fungus, and a few customers even fell ill after consuming the juice, compelling Samir to issue refunds and causing significant reputational damage to his business. When Samir demanded compensation from Fresh Foods Limited, the seller refused, contending that the goods had been sealed and were accepted by him at the time of delivery. Examine whether Samir can succeed in his claim under the Sale of Goods Act 1930. What is the provision?
Sale by description.
Huh?
Merchant-
Sale by description, merchantable. So the main provision will go towards people. See, purchase 10 cartons of packaged fruit juice bottles from Fresh Fruit Limited, reputed beverage.
wholesomeness and merchantable quality both will come through. Both.
Okay, see, description, it is just an assumption. Description is not very evident. What is evident in the given cases? Whenever people, remember, merchantable, we generally use it, people, it should be free from defects, correct? But whenever it is edible items, we also write majorly wholesome. So if you ask me, the major provision has to be wholesome, but the institute has given an answer in a different way. Tell me.
Sale by description.
Description, now they have to describe something like that, right? Now see, they're telling 10 cartons of packaged fruit juice bottles. Nowhere it is given that it is fresh, high grade, nothing, right?
So appear to be in good condition.
Appeared, right? It is appeared, not marketed or sold. It looks is what they are telling. Yes, Sam. See, description is simple. If you are describing it like that, then description will come into picture. So I would like to deviate with what Institute has said here. It said when goods are bought by description from a seller who deals in goods of that description, there is an implied condition that the goods shall be of merchantable quality. In addition, so according to me, this becomes the main provision, because I always tell you, in the case of edible items, it is always wholesome is what we use. Latent also you can do it, which is not, that is also hidden defects, something which is not visible to a normal eye. So that is also something which you can write 100%. Yes. Yes, sir. So that is what I'm telling you. There is an implied condition as to wholesomeness, that is, the goods must be fit for human consumption. Where such goods are harmful or dangerous to health, the buyer is entitled to reject them and also claim damages. One of the basic conditions is that goods must be of merchantable quality and also satisfy the implied condition of wholesomeness. It was duty of the seller to ensure that food products supplied were fit for human consumption. Hence, Samir is entitled to reject the goods, recover the price, and also claim damages for the loss suffered. Agreed? Yes, sir. Okay. Next one. Mr. G sold some goods to Mr. H for a certain price by issue of an invoice, but payment in respect of same was not received on that day. The goods were packed and lying in the godown of Mr. G. The goods were inspected by H's agent and were found to be in order. Later on, the dues of the goods were settled in cash. Just after receiving cash, Mr. G asked Mr. H that goods should be taken away from his godown to enable him to store other goods purchased by him. After one day, since Mr. H did not take delivery of the goods, Mr. G kept the goods out of the godown in an open space. Due to rain, some goods were damaged. Referring to the provisions of Sale of Goods Act 1930, analyze the above situation and decide who will be held responsible for the above damage. Will your answer be different if dues were not settled in cash and are still pending? Risk passes with the ownership. So who will be liable? H will be liable. So what is the provision you guys are going to write? Risk passes with the ownership. That's the provision, and nothing else will come.
Goods are put in.
Very good, Rakesh. That's one of the main provision you need to write. But who will be liable? What else provision you will write?
Goods are
Party in default. What exact party in default? Yesterday I told you in one place exactly where question will come. Whenever people upon a sale, the goods are still with the seller or buyer because of the other person's defect or default. In such case, what did we decide? If you guys remember, I gave you an example. Ramana's Amazon, he attempted the delivery. Amazon, he did not take the delivery. Now, whenever the risk, the delivery date is pushed by buyer or seller, whoever is the party in default, he will be liable. Now see, technically the date of delivery is today. According to me, I have clearly told you have to take. But you did not take the delivery. Agreed? Now after that, the goods are still with me. Remember, they are telling you, whoever is a party in default, he continues to be at risk. But you have other point also which you wrote. What is that? That doesn't mean whoever is having the goods, I am not the owner of it, correct? Now technically, I should have given you the goods, I have given it. I have, as a bailer of the goods, as a bailee of the goods, your goods are with me now. It is my duty to take reasonable care of the goods. Now both the points has to be written. Now in the given case, is the reasonable care taken or not? Is it taken? No. Now try to see. That's why I always say they will help you in the question only. What have they said? The goods were packed and lying in the godown of Mr. J. The goods were inspected and everything is done. Later on, the dues of the goods were settled in cash. Just after receiving should be shaken and goes on. 2. That means what, people? Don't you think even I have my own business? I have other materials coming in. If I keep your goods there, then when will I do my business? Imagine if at all, because you did not take it on time, I might have lost some opportunity of making some money because I did not order new stock. For that, will you pay compensation? Right? Now people, what did he say? He gave you a reasonable opportunity. Any person who do the same, no people, I will first treat my goods. I gave you an opportunity also. Now if you did not take it out, then I have to keep it out. I have other stock to come. So as a bailee, he has taken reasonable care of the goods. I getting the point? Because when there is no other place, then what do you expect? Do you expect me to keep your goods inside and my goods outside? You tell me, which brain person will do that? Hello? Agreed? Yes, sir. That is what is the answer. Whoever is the party at default, they will be at risk. If at all there is a delay in delivery, whoever is the party in default, they will bear the risk. Next one, but that does not discharge your duty as a bailee. As long as you are taking reasonable care of the goods. What is reasonable care? Whatever an ordinary man would treat as the goods are his own. He has taken that care because he has his business to run. That is the maximum he can do. Hello? Done now? We'll see what they have said. According to them, when the seller is ready and willing to deliver the goods and requests the buyer to take delivery and the buyer does not within a reasonable time after such a request, he is liable to the seller for any loss occasioned by his neglect or refusal. Correct? Hello? And also for a reasonable charge for the care and custody of the goods. Risk of goods prima facie follows the ownership. Goods remains at seller's risk unless the property therein is transferred to the buyer. But after transfer of property, the goods are at the buyer's risk whether delivery has been made or not. Agreed? You saw yesterday's mic example. I have given the mic to Ramana, but it is still with me. The risk is with the Ramana only. Once the ownership is transferred, who has the goods is irrelevant. Agreed? Yes? Okay. In the given case, Mr. G is already intimated, and because of the people, G should be borne by Mr. H. If the price of the goods were not settled in cash and some amount would have been pending, then Mr. G would be treated as an unpaid seller and he can enforce the following rights against the goods. We'll see this. What is this? I think unpaid seller had not done it yet. No, sorry. Okay, leave that. It's okay.
If with the unpaid,
We have it. Today's unit will be doing it.
they will sell it, right? Probably.
Unpaid seller, the buyer will get a right to sell it to someone else.
Sell it to someone else.
We have a right to resale. It's called.
Yes, right.
Okay, we'll see that today. We have it. What is unpaid seller? I'll tell you. Samuel purchased a television set from Arun, the owner of Gada Electronics, on condition that for the first 3 days he will check its quality, and if satisfied he will pay for that, otherwise he will return the television set. On the second day the television set was spoiled due to an earthquake. Arun demands the price of television set from Samuel. Whether Samuel is liable to pay the price under Sale of Goods Act, who will be ultimately liable to bear the loss?
Earthquake is the impossible.
Sale of the.
So whenever now what will you write? What will be my provision? My provision is people. Section 24, which talks about sale or return basis. In sale or return basis, when will the ownership pass? Buyer accepts the goods. If he keeps the goods beyond the reasonable time,
He does the same as equal to the.
he does something equivalent to an acceptance. Now in the given case, none of it is done. Agreed? It's still the second day. Now people, that means what? According to the rule, risk always transfers with the ownership. Now the risk, that ownership is still with the seller because buyer has not yet given his consent. Agreed? Then what is the responsibility of the buyer here? The responsibility of the buyer here is nothing but people, bailer, bailee. I'm a bailee. So I have a duty to take reasonable care of the goods. As long as I'm taking reasonable care, I am discharged. In earthquake, we saw the same example also yesterday. What reasonable care I can take? Now people, because of that, I am free from my liability as a bailee also. So in the given case, who will be liable? The seller will be liable. Understood? Yes, sir. All of you? Okay, that is the 50th. Oh, sorry. Okay. Akash purchased 100 kgs of wheat from Bhaskar at 80 rupees per kg. Bhaskar says that wheat is in his warehouse in the custody of Kishore, the warehouse keeper. Kishore confirmed to Akash that he can take the delivery of wheat from him, and till then he is holding wheat on Akash's behalf. Before Akash picks the goods from warehouse, the whole wheat in the warehouse has flowed in flood. Now Akash wants his price on the contention that no delivery has been done by seller. Whether Akash is right with his views under Sale of Goods Act. Akash purchased 100 kgs of wheat from Bhaskar at 80 rupees per kg. So he is purchasing, correct? Okay. Bhaskar says that wheat is in his warehouse. That means there is a godown. It is there, it seems. And that godown is taken care by a person called as Kishore. He is called as a warehouse keeper. Kishore has confirmed to Akash that he can take the delivery of wheat from him, and till then he is holding wheat on Akash's behalf. That means, sir, my owner has told me that you can come and take the goods. Until then I will hold it for you. You don't worry. I'm taking care of the goods.
The ownership is with the Akash, right?
Now you understood the scenario, no? And now try to think and tell. What has happened? Before Akash picks the goods from warehouse, the whole wheat in the warehouse has flowed in flood. Now Akash wants his price in the contention that I have never taken the delivery at all. It is still with you guys. I have not taken the delivery. He is saying delivery didn't happen at all. It is with you guys only. So I am not liable. Liability is on you. I am not liable is what Akash is telling. Now they are asking your opinion. What is your opinion? Symbolic delivery? Why symbolic? It is constructive delivery, people. See, types of delivery. There are 3 types of delivery. One is called actual. When a product is taken, kept in your hand. Symbolic delivery. A product cannot be kept in your hand. We give something else as a token of transfer of something else. To give a car, you give a key. That is called symbolic. The third one is called as constructive delivery. What is constructive delivery? I told you also. The custody, wherever the product is, it will not even move 1 inch. Wherever it is still there only. Then in constructive delivery, how does the delivery happen? Delivery happens through acknowledgement. Someone calls you and says, sir, the product is received, or the product, I'm going to hold it for you going forward. Someone acknowledges that. Now the way Kishore said, sir, you can come and take the goods, until then I will hold it for you. He has said on behalf of Akash. That means what? The goods did not move even 1 inch. But the delivery has happened. Why? That is what is called constructive delivery. In constructive delivery, delivery happens through acknowledgement. That's the word you need to write. If acknowledgement word is there, you guys will get a maximum marks. So 2 words that the valuer will look for. One is constructive. Next one is acknowledgement. Hello? If these 2 words are there, you will get maximum marks. Is this clear, all of you? Yes? Clear? Understood? Okay. Question 51, people. 51 to 55 we are doing, no? Okay. Sonal went to jewelry shop and asked the sales girl to show her diamond bangles with the ruby stones. The jeweler told her that we have a lot of designs of diamond bangles, but with red stones, if she chooses for herself any special design of diamond bangle with red stones, they will replace red stones with ruby stones. But for the ruby stones, they will charge an extra cost. Sonal selected a beautiful set of designer bangles and paid for them. She also paid the extra cost for ruby stones. Understood till now what is happening? She wanted ruby stones, but in the shop there is nothing with ruby stones. So she asked the shop, if you guys can give me ruby, I'll take it. They said, okay, you choose it. You will replace the red stones with ruby stones. Yes, Sam. The jeweler requested her to come back a week later for the delivery of those bangles. He is your younger brother, he is elder brother. For sharp 4:20 will come. 4:20, correct? See? The year means you have to come at 4:10. When she came after a week to take delivery of bangles, she noticed that due to ruby stones, the design of the bangles had been completely disturbed. Now she wants to terminate the contract and thus ask the manager to give her money back. But he denied the same. Answer the following questions as per Sale of Goods Act. And one more question the students will generally have is, sir, what if this is not mentioned? I always tell you people, whoever is the paper setter, they are always on your side. So they will definitely mention which act it is. If this is not mentioned, no, trust me, the first question that will start is whether it is Indian Contract Act or Sale of Goods Act. To figure that only, we will take time. So remember, the examiner, that is the paper setter, is always on the student side. He will help you. He or she, sorry. Yes, sir. Which act will always be there? All the questions, Indian partnership, in the last 25 attempts they are mentioning. I'm sure in your attempt also they are mentioned. Yes. If not means a little, the question should be little difficult, that's all. It'll take little time. But 99% they will mention. Okay. State with reasons whether Sonal can recover the amount from jeweler. What would be your answer if the jeweler says that he can change the design but he will charge extra cost for the same? State with reasons whether Sonal can recover the amount from the jeweler. Can she recover? That means what? She has paid advance money, right? Now the entire design itself is changed. Can she recover the money? Is it possible? What did you guys write? She can recover. Now the main thing comes down to is provision. What is a provision? Sale by description. Okay. But where is description here?
So they told that it will be after exact same design by replacing the
No, they said it is a diamond bangle. Now they replaced with ruby bangles. Technically, if you see, they got ruby bangles only, but the shape is not there.
He specified the design which she wanted.
See, what are they telling you? The design is disturbed. That means what? It is not completely proper. So how is that description?
Sir, no sir, she selected the design which she wanted.
No, no. What you are saying is correct. But provision?
Conditions in which sale has happened through description, the seller must be right.
You are again saying description only. No, description no. Huh? Sample olla. Sample means what? I've showed you something and the bulk should always be the replica of what I've showed. So that will become sale by sample. That means I should have showed you a picture. And what I've given it should be that. Here I've showed you the actual model only. But we have removed the stones and we have put back something else. That is the thing they are telling. Quality or fitness? Also no. Merchantability? Also no. See, if you ask me in a way, people, if you ask me, merchantability to an extent fits the answer. Point 1. Merchantability fits. Next thing, people, another set of students also feel that, sir, this can be a question of goods to be put into deliverable state. That means the product still something is to be done. If it is not done properly, then the ownership does not pass. Correct? When will the ownership pass? Only when the goods are in deliverable state. That is one more school of thought. People will think that is also the answer. The third thing, people, the right thing that as given by the institute is, this is they are asking what type of contract is this? Is it a contract of sale or is it a contract of agreement to sell? It's an agreement to sell. It's not a contract of sale. That means what? Ownership is not passed immediately. It's an agreement. Even though I've paid the money, ownership is not passed, because ownership will pass only after you give me the product you have properly promised. You have not given me that product. So as the condition is not met, in agreement to sell, what is happening? It is a condition. The condition is I will buy the ruby bangles. Now the condition is not met by the seller. And hence, because it is an agreement to sell, it's not a sale. Ownership is not yet passed. Now because of that, she has every right to deny the contract, because the ownership is not yet passed. The risk is still on the seller only. Now on these grounds, I can take back my money allowed. So the contract what they're answering on, the provision what they're answering on is contract of sale, agreement to sell. They're saying it is an agreement to sell and not contract of sale. Hence the ownership is not yet passed. I get in the point. Because the ownership is not yet passed, the risk is on the seller. That is the answer.
It is not sale by description.
Sale by description, though, definitely no. I would have given merchantability here and there, yes. Second thing is goods to be put into deliverable state. So this is also one more thing I will say. Okay, you guys are somewhere nearby. Description, no. 100% no. Because there is defect. I have end of the day given you ruby bangle only, no. But the shape is little changed. So merchantability, yes, it may come. But they have given it as an agreement to sell. Yes, that's why I say, even if you guys have written these two, I would somewhere feel it is still okay only. But yes, institute has given a different answer. Yes, next one is people. What would be your answer if the jeweler says that he can change the design, but he will charge extra cost for the same? Can he charge extra? So people, he can give the same design, but remember, he cannot charge the extra cost for the same. It is on him. It is not my mistake. The ownership is also with him, and the defect has to be fixed by him only, not by me. So him charging extra for it is not fair. That's the answer. Understood? Yes, sir. Provision, this is what is important. Transfer of property happens on a future date. That is, ownership is transferred in the future date. And the ownership only transfers upon fulfillment of condition. What is the condition? The ruby bangles has to be properly designed. That is a condition. So until the condition is met, the ownership will not pass. That's the first answer. Second one is jewelers offers to bring the bangles to the original position by repairing. He cannot charge extra cost to Sonal. Simple? Yes? Understood or illa? Description we saw, no, like previous yesterday's and all the class test, fresh sweets, and I don't know, two scenarios we had seen. Description is that whenever you're premium silk cloth, that is also description. That what is that? Fresh sweets, that was also description. So you're describing. Fresh is the description. Now imagine I said fresh, but I gave you stale. That's why description came. Here I said ruby, I'm giving you ruby only. That's why description is not coming. Agreed? Okay, next one. Samar was in search of second-hand car. For this purpose, he approached Carwala 007, a dealer in pre-owned cars. The sales manager of Carwala showed him 3 cars which were standing in the parking lane just outside the office. Samar finalized red Wagoner car. After completing the documenting formalities and receiving the price of the car, the sales manager of the car handed over the keys of car to Samar. But when Samar was coming to the parking area for picking the car, the electric pole fell on the car which badly damaged the car. Samar claimed that repair expenses of the car should be borne by Carwala 007. As car was not delivered to him, referring to the provisions of Sale of Goods Act, state who will be liable to get the car repaired. Samar? Why? Symbolic delivery. Very good. Key is, you guys will be writing as this amounts to a symbolic delivery, transfer of one thing in token of transfer of something else. So the handover of keys here amounts to handover of delivery of the car. So the ownership for the car has been transferred to Samar and Samar will bear the risk. Yes, they is similar to our Nexa showroom, the cylinder blaster. That is what I told you. Real life it is different. But that is what happened there. If you remember, one thing came and fell on the car, which was already registered. Hello? Huh? Case law? The Nexa showroom. Hey, that is here, near our.
Can you also mention that for specific goods, the delivery takes place at the time of contract?
For specific goods, the delivery. No, that was ownership only, right? Here they are clearly telling you. So, okay. Now, let us. Yes, okay. Kiran has a good question. Sir, why can't we take it as when does the ownership pass? Depends upon types of goods. Car was there only. So, existing goods. Identified. So, it becomes specific goods. So, why can't I take it as specific goods and why can't I answer as per specific goods? Remember, here Samar is telling the car was not delivered to him at all. That is what is the thing. Hint by the examiner. Now you need to tell no, car was delivered to you. Now only place where I can see transfer of ownership does not talk about delivery at all. So in transfer of ownership we saw the goods can still be with me, but the ownership is transferred. There we do not speak about delivery.
Instead of delivery, he is arguing that I can't bear the loss. That car wala has to bear the loss.
If he says, let us imagine, this point is not given at all. If he says, you are the owner, I am not the owner. You are free to write risked prima facie transfers with ownership in the case of existing specific goods which are identified, passes whenever the contract of sale is made. That time you can write. That's why I always say people read the question. Question is the hint. If you actually read the question now, you see 100, 150 questions. I'm telling you, you will become an expert in identifying the provision. Like this, you can pick up the provision. But you need to read the question carefully. Clear? Okay. Okay. Next one. Good question.
This question, sir.
PTC hotels in Bombay decided to sell their furniture by auction sale. First time ever an auction sale, lot of points were touched. This is the first question. I am saying in multiple attempts. For this purpose, they appointed RN and Associates as auctioneers. RN and Associates as auctioneer means the people who come and hit that hammer and they make the sale. They invited top 10 renowned architects in Bombay for bidding. A right to bid was notified by them. Furniture was put up in lots for sale. It was decided that for every lot of furniture there will be a reserve price, base price. On 25th Feb 2024, the auction sale was started. For a special lot of furniture, 3 parties came for bidding. Mr. Neil, Mr. Raj, Mr. Dev, on behalf of their respective companies. Bidding was as follows. Neil said 5.7, Raj 4.85, Dev said 6.10 lakh. The sale was completed in favor of Mr. Neil by RN Associates by fall of hammer. Mr. Dev's bid was rejected on the grounds that the right to bid was reserved and the company of Mr. Dev was not invited to the bid. For another bid of Italian furniture was made by 2 parties as follows. Mr. Deer 15 lakh, Mr. Madhu on behalf of RN and Associates 15.2 lakh was completed in favor of Deer instead of Mr. Madhu. Mr. Dev and Mr. Madhu argued that auction sale was not lawful. Give your opinion with reference to the provision of Sale of Goods Act whether auction sale will be considered lawful or not. What happened, people? There is an auction conducted. In the first auction, 3 people participated. Neil, Raj, Dev. Neil said 5.7, Raj said 4.85, Dev said 6.10. Who gave the highest? Dev. But whom did they sell it to? They sold it to Neil. Now, first of all, is that valid? Is it valid? Highest bid you should give. What have you guys written? What was your answer?
So it is unlawful.
You wrote it as unlawful. Why?
So because only top 10 renowned architects have been invited for the Bombay bidding auction. But they did not, none of the company have been reserved the right to bid. They have been mentioned over there. A right to bid was not notified by them.
Where?
So in the third line.
A right to bid was not notified by them. They invited top 10 renowned architects in Bombay for bidding. A right to bid was not notified by them. Furniture was put in up. Okay, that is what you wrote. Okay, understood.
Not notified by them. So it is not mentioned that only the top 10 has to be participated. So it is in general, Mr. Dev's company has a option to participate and he is the highest bidder. So it can be sold to him unlawfully. It has been sold to Mr. Neil by the contract which has been told that only the top 10 renowned architects have to be participated in this auction. So only because of the
Okay, you are saying the first one was unlawful or lawful?
unlawful.
Unlawful. Second one was?
Because it is by the seller's agent, which is not to inflate the price, only to tell the
Okay, you are saying first one was unlawful, second one was lawful. That is what all of you wrote? What did you write? Same? Same? Arna, you wrote all same? What did you write? Second one was unlawful. First one is? Both were unlawful. Okay. Now people, now try to understand what is that they are telling. What did you write, Shravya? You did this you didn't attempt or?
I need to try.
Okay. Now sir, Ramana? First one, what did you write? Unlawful. Okay. Now people, try to understand what they are telling you is, they appointed RN Associates as auctioneers. They have invited top 10 renowned architects in Bombay for bidding. A right to bid was not notified by them here means people nothing but the seller is there, no. The seller has not informed the auction, neither the auctioneer has informed the auction that someone from us will come and participate in the auction. We have not intimated. That means what? We have not reserved the right to bid. That's the meaning of a right to bid was not notified by them. Meaning, we have not reserved the right to bid. That means we cannot participate.
from the seller.
Seller or auctioneer. Whoever is selling. What did we write? Seller or any other person acting in such behalf. If they want to participate in the auction, you are supposed to notify the right to bid. They have not notified. That is what they are telling you.
So, but then the second one is not law.
Now try to see. Okay. Now furniture was put in lots. Now in this case, what happened? Neel, Raj, Dev. Dev did the highest bid, correct. But what did they give? See, they have only given in the answer. I mean, they have only given in the question. Mr. Dev bid was rejected. Why? On the ground that the right to bid was reserved and the company of Mr. Dev was not invited to the bid at all. Yesterday I told you, what do I mean by that right to be bid may be reserved or it can be notified. That means I can tell, yesterday I told you government tenders and all I told you, right? I will say that you should be at least 10 years experienced because we do not trust as government. Government tenders do that. So when I have invited here top 10 people, some other person also has come and participated in the bid. He did not get an invitation at all. So by default, we will reject his bid because that is the meaning of notified or identified or invited. That's why they have given it here. Where is that? 10, top 10 companies somewhere they would have given. They invited top 10 renowned architects in Bombay for bidding. So it means what? Only they should come. Someone else is coming means you are not allowed. So on those grounds I am telling you, the first sale is lawful. Second one is, in second one what happened? For another bit of Italian, I made two parties as follows. Dheer and Mr. Madhu on behalf of RNS Associates. Sale was completed in favor of Dheer instead of Madhu. So there are two people, Dheer and Madhu. Madhu is representing RNS Associates. Have they reserved right to bid? A right to bid was not notified by them. Hello? That means can they participate? No. So people, Madhu cannot participate at all. So now two people participated in the bid. One is Dheer and one is Madhu. Madhu's bid is invalid. So whom did they give that furniture to? Dev. So is it lawful? It is lawful. Understood? You said unlawful. Lawful. Both are lawful. So the auction was lawful. Understood? That's why I am saying first time they have given this entire provision connecting all the points.
So it's confusion by the law.
No. You can just write 3 points. One. See, one is right to bid is reserved. Right to bid may be notified. And what is the other one? Completion also no. Pretended bidding is not allowed. On that ground, I cannot give it to Mr. Dheer. So these 2 points, section 64, and I will write 2-3 points as provision, more than sufficient. If they are giving this question, it will be at least for 5 marks or 6 marks. Is this clear? 5 marks they will give.
Confused only by the
I know. But remember, okay, next one. A government department conducted an auction of used vehicles. Mr. Suresh bid for a truck at 5 lakh rupees. Before the auctioneer's hammer fell, Suresh tried to withdraw his bid, but the auctioneer refused. Later, the auctioneer also bid through his agent without prior notice to the bidders. Another bidder, Mr. Akash, complained that the auction was not fairly conducted. Decide with reference to the Sale of Goods Act. Again, 2 things are there here.
not valid. Invalid.
First one is, can he withdraw the bid?
Yes.
He can.
Before the hammer falls, he can withdraw. And then the prior information.
You should have notified. So always remember, people, fall of hammer, that is the completion. Before that, people, I am free to withdraw. When will the offer get accepted? Whenever there is a 3 times of hammer fell, that is when offer and acceptance meet. Before that, can I withdraw? Yes, I can withdraw. Why can't I withdraw? So it is possible. So that is unlawful. Next one is, what is that? someone has participated on behalf of the auctioneer or the seller, and it is not intimated, prior intimation is not given, that is unlawful. Whenever it is unlawful, people, you can consider it as voidable. That has to be written.
So that is fraud.
Fraud, voidable. Answer is you should say it is voidable. Correct? Huh? Those are the keywords. That two has to be there. Clear? Okay, next one. Mr. Varun, a laptop distributor, delivered 20 laptops to his friend, Mr. Mohit, on the condition of sale on approval or return within 10 days. Rohit neither returned the laptops within the stipulated period nor informed Varun of any rejection. Instead, he kept the laptops in his office showroom and sold 5 of them to Mr. Anuj, claiming to be absolute owner. Anuj purchased the laptop in good faith, paid full consideration, and even issued a receipt for it. After 15 days, Varun demanded the return of all the laptops, including those sold to Anuj. Rohit refused, arguing that he had acted as the owner. Anuj also defended himself, claiming that he was a bona fide purchaser for the value. Varun, however, relied on the principle that no one can transfer a better title than he himself has. Decide under the Sale of Goods Act whether Anuj has acquired a valid title and whether Varun can recover the goods.
So Anuj has acquired a valid title.
So Varun has given to Rohit, Rohit has given to Anuj.
So now in this case, Varun have given the 20 laptops to Rohit. In case if you want to return it within 10 days or any approval or rejection should be conveyed by the Rohit to Varun. There is no any return of goods for the 10 days, and there is no any approval or rejection given by the Rohit to Varun. So according to sale or return basis, the sale is completed. Once this been transferred to Rohit because the stipulated period has been over and he kept the good with him and he acted upon the sale equivalent to the sale. That is, he gave the goods to another or in possession of the equivalent to sale. So the ownership is given to Rohit. So Varun is not liable to recover any product from the Rohit and Anuj has a bona title acquired.
Okay. Good. Two provisions that you guys need to write here is, one is from his point of view, one is from his point of view. One, whether Rohit got the title or not. In sale or return basis, when is the acceptance complete? Three things has to happen. One, I should have communicated my acceptance. Second thing is I should have kept the product beyond the return period. Third thing is I do something equivalent to an acceptance. Here they have clearly given people that he has kept the product beyond the stipulated period. That means 10 days, I have kept it for 15 days. That means that is one way of acceptance. Second one, people, I do something equivalent to an acceptance. You gave it to me. I can only sell it if I think it is mine. So in both the grounds, people, I have communicated my acceptance. So no, Varun cannot recover the laptops. This on sale or return basis, the acceptance has been communicated and hence the ownership has been delivered. Now this is from Varun to Rohit's point of view. Answer number one. Now answer number two, from Rohit to Anuj. Now this is where most of the people wouldn't have answered. You will write sale or return and you will leave it. The next thing you guys need to write is, what is the question they have clearly asked you? There is a principle it seems which says, see again I am saying you, the examiner helped you. There is a principle which says no one can transfer a better title than he has. That means what? They are asking you, Nemo dat quad non habet ka exception. Sale by a owner in possession before getting the property. You would have written CA, sale by a owner getting possession before getting the property. There you would have written in the brackets, sale or return basis. So on that ground, people, Anuj got a good title. So you need to write both. Understood? Yes. You need to write that as well as this. If you write both, you will get marks. If not, no. Clear all of you? Got it? See, are you getting what do we miss? Yes. So we need to read the question properly and we need to write whatever completely is required. We would have written one part. We wouldn't write the second part. Now are you getting? In exam, this is what happens. We would have written half and half. We would have thought, sir, I've answered, no, sir, sale or written basis. But why did they not give mark? That's why whenever students say, sir, they did not do valuation properly, I'll say, you get your papers. Today only I'm telling you, for all of you, if you think after something and all, after exams and all, if you think somewhere you got marks less than what you anticipated, you meet me with your paper only.
Then what is the mark without writing that?
There will be, now if it's a 5 mark, they will definitely cut 2 marks or 2.5 marks because it is not complete. So you might get 2 marks. So 2 or max to max. If everything else is good, then 3. So you can imagine for every 5 mark question, if you're losing 2 or 3, you would have lost around 45-50 marks there. That's where, that it will dip. Clear all of you? Yes? Okay. Okay. Question 51 people, 51 to 55 we are doing, no? Okay. Sonal went to jewelry shop and asked the sales girl to show her diamond bangles with ruby stones. The jeweler told her that we have a lot of designs of diamond bangles, but with red stones, if she chooses for herself any special design of diamond bangle with red stones, they will replace red stones with ruby stones. But for the ruby stones, they will charge an extra cost. Sonal selected a beautiful set of designer bangles and paid for them. She also paid the extra cost for ruby stones. Understood till now what is happening? She wanted ruby stones, but in the shop there is nothing with ruby stones. So she asked the shop, if you guys can give me ruby, I'll take it. They said, okay, you choose it. You will replace the red stones with ruby stones. Yes, ma'am. The jeweler requested her to come back a week later for the delivery of those bangles. He is your younger brother, he is elder brother. For sharp 4:20 will come. 4:20, correct? See? The year means you should come at 4:10. When she came after a week to take delivery of bangles, she noticed that due to ruby stones, the design of the bangles had been completely disturbed. Now she wants to terminate the contract and thus ask the manager to give her money back. But he denied the same. Answer the following questions as per Sale of Goods Act. And one more question the students will generally have is, sir, what if this is not mentioned? I always tell you people, whoever is the paper setter, they are always on your side. So they will definitely mention which act it is. If this is not mentioned, no, trust me, the first question that will start is whether it is Indian Contract Act or Sale of Goods Act. To figure that only, we will take time. So remember, the examiner, that is the paper setter, is always on the student side. He'll help you. He or she, sorry. Yes, sir. Which act will always be there? All the questions, Indian partnership, in the last 25 attempts they are mentioning. I'm sure in your attempt also they are mentioned. Yes. If not means a little, the question should be little difficult, that's all. It'll take little time. But 99% they will mention. Okay. State with reasons whether Sonal can recover the amount from jeweler. What would be your answer if the jeweler says that he can change the design but he will charge extra cost for the same? State with reasons whether Sonal can recover the amount from the jeweler. Can she recover? That means what? She has paid advance money, right? Now the entire design itself is changed. Can she recover the money? Is it possible? What did you guys write? She can recover. Now the main thing comes down to is provision. What is a provision? Sale by description. Okay. But where is description here?
So they told that it will be after exact same design by replacing.
No, they said it is a diamond bangle. Now they replaced with ruby bangles. Technically, if you see, they got ruby bangles only, but the shape is not there.
Did he specify the design which she wanted?
See, what are they telling you? The design is disturbed. That means what? It is not completely proper. So how is that description?
Sir, no, sir. She selected the design which she wanted.
No. What you are saying is correct. But provision?
Can't in which sale has happened through description, the seller must be like.
You're again saying description only. No, description no. Huh? Sample olla. Sample means what? I've showed you something and the bulk should always be the replica of what I've showed. So that will become sale by sample. That means I should have showed you a picture. And what I've given it should be that. Here I've showed you the actual model only. But we have removed the stones and we have put back something else. That is the thing they are telling. Quality or fitness? Also no. Merchantability? Also no. See, if you ask me in a way, people, if you ask me, merchantability to an extent fits the answer. Point 1. Merchantability fits. Next thing, people, another set of students also feel that, sir, this can be a question of goods to be put into deliverable state. That means the product still something is to be done. If it is not done properly, then the ownership does not pass. Correct? When will the ownership pass? Only when the goods are in deliverable state. That is one more school of thought. People will think that is also the answer. The third thing, people, the right thing that as given by the institute is, this is they are asking what type of contract is this? Is it a contract of sale or is it a contract of agreement to sell? It's an agreement to sell. It's not a contract of sale. That means what? Ownership is not passed immediately. It's an agreement. Even though I've paid the money, ownership is not passed, because ownership will pass only after you give me the product you have properly promised. You have not given me that product. So as the condition is not met, in agreement to sell, what is happening? It is a condition. The condition is I will buy the ruby bangles. Now the condition is not met by the seller. And hence, because it is an agreement to sell, it's not a sale. Ownership is not yet passed. Now because of that, she has every right to deny the contract, because the ownership is not yet passed. The risk is still on the seller only. Now on these grounds, I can take back my money allowed. So the contract what they're answering on, the provision what they're answering on is contract of sale, agreement to sell. They're saying it is an agreement to sell and not contract of sale. Hence the ownership is not yet passed. I get in the point. Because the ownership is not yet passed, the risk is on the seller. That is the answer.
It is not sale by description.
Sale by description, though, definitely no. I would have given merchantability here and there, yes. Second thing is goods to be put into deliverable state. So this is also one more thing I will say. Okay, you guys are somewhere nearby. Description, no. 100% no. Because there is defect. I have end of the day given you ruby bangle only, no. But the shape is little changed. So merchantability, yes, it may come. But they have given it as an agreement to sell. Yes, that's why I say, even if you guys have written these two, I would somewhere feel it is still okay only. But yes, institute has given a different answer. Yes, next one is people. What would be your answer if the jeweler says that he can change the design, but he will charge extra cost for the same? Can he charge extra? So people, he can give the same design, but remember, he cannot charge the extra cost for the same. It is on him. It is not my mistake. The ownership is also with him, and the defect has to be fixed by him only, not by me. So him charging extra for it is not fair. That's the answer. Understood? Yes, sir. Provision, this is what is important. Transfer of property happens on a future date. That is, ownership is transferred in the future date. And the ownership only transfers upon fulfillment of condition. What is the condition? The ruby bangles has to be properly designed. That is the condition. So until the condition is met, the ownership will not pass. That's the first answer. Second one is the jeweler offers to bring the bangles to the original position by repairing. He cannot charge extra cost to Sonal. Simple? Yes? Understood or illa? Description we saw, no, like previous yesterday's and all the class test, fresh sweets, and I don't know, two scenarios we had seen. Description is that whenever you're premium silk cloth, that is also description. That what is that? Fresh sweets, that was also description. So you're describing. Fresh is the description. Now imagine I said fresh, but I gave you stale. That's why description came. Here I said ruby, I'm giving you ruby only. That's why description is not coming. Agreed? Okay, next one. Samar was in search of second-hand car. For this purpose, he approached Carwala 007, a dealer in pre-owned cars. The sales manager of Carwala showed him 3 cars which were standing in the parking lane just outside the office. Samar finalized red WagonR car. After completing the documenting formalities and receiving the price of the car, the sales manager of the car handed over the keys of car to Samar. But when Samar was coming to the parking area for picking the car, the electric pole fell on the car, which badly damaged the car. Samar claimed that repair expenses of the car should be borne by Carwala 007, as car was not delivered to him. Referring to the provisions of Sale of Goods Act, state who will be liable to get the car repaired. Samar? Why? Symbolic delivery. Very good. Key is, you guys will be writing as this amounts to a symbolic delivery, transfer of one thing in token of transfer of something else. So the handover of keys here amounts to handover of delivery of the car. So the ownership for the car has been transferred to Samar and Samar will bear the risk. Yes, they is similar to our Nexa showroom, da? The cylinder blaster. That is what I told you. Real life it is different. But that is what happened there. If you remember, one thing came and fell on the car, which was already registered. Hello? Huh? Case law? The Nexa showroom. Hey, that is here, near our.
Sir, can you also mention that for specific goods, the delivery takes place at the time of contract?
For specific goods, the delivery. No, that was ownership only, right? Here they are clearly telling you. So, okay. Now, let us. Yes, okay. Kiran has a good question. Sir, why can't we take it as when does the ownership pass? Depends upon types of goods. Car was there only. So, existing goods. Identified. So, it becomes specific goods. So, why can't I take it as specific goods and why can't I answer as per specific goods? Remember, here Samar is telling the car was not delivered to him at all. That is what is the thing. Hint by the examiner. Now you need to tell no, car was delivered to you. Now only place where I can see transfer of ownership does not talk about delivery at all. So in transfer of ownership we saw the goods can still be with me, but the ownership is transferred. There we do not speak about delivery.
Instead of delivery, he is arguing that I can't bear the loss, that Carwala has to bear the loss.
If he says, let us imagine, this point is not given at all. If he says, you are the owner, I am not the owner. You are free to write risked prima facie transfers with ownership in the case of existing specific goods which are identified, passes whenever the contract of sale is made. That time you can write. That's why I always say people read the question. Question is the hint. If you actually read the question now, you see 100, 150 questions. I'm telling you, you will become an expert in identifying the provision. Like this, you can pick up the provision. But you need to read the question carefully. Clear? Okay. Okay. Next one. Good question. PTC hotels in Bombay decided to sell their furniture by auction sale. First time ever an auction sale, lot of points were touched. This is the first question. I'm saying in multiple attempts. For this purpose, they appointed RN and Associates as auctioneers. RN and Associates as auctioneer means the people who come and hit that hammer and they make the sale. They invited top 10 renowned architects in Bombay for bidding. A right to bid was notified by them. Furniture was put up in lots for sale. It was decided that for every lot of furniture, there will be a reserve price, base price. On 25th Feb 2024, the auction sale was started. For a special lot of furniture, 3 parties came for bidding. Mr. Neil, Mr. Raj, Mr. Dev, on behalf of their respective companies. Bidding was as follows. Neil said 5.7, Raj 4.85, Dev said 6.10 lakh. The sale was completed in favor of Mr. Neil by RN Associates by fall of hammer. Mr. Dev's bid was rejected on the grounds that the right to bid was reserved and the company of Mr. Dev was not invited to the bid. For another bid of Italian furniture was made by 2 parties as follows. Mr. Deer 15 lakh, Mr. Madhu on behalf of RN and Associates 15.2 lakh was completed in favor of Deer instead of Mr. Madhu. Mr. Dev and Mr. Madhu argued that auction sale was not lawful. Give your opinion with reference to the provision of Sale of Goods Act whether auction sale will be considered lawful or not. What happened, people? There is an auction conducted. In the first auction, 3 people participated. Neil, Raj, Dev. Neil said 5.7, Raj said 4.85, Dev said 6.10. Who gave the highest? Dev. But whom did they sell it to? They sold it to Neil. Now, first of all, is that valid? Is it valid? Highest bid you should give. What have you guys written? What was your answer?
So it is unlawful.
You wrote it as unlawful. Why?
So because only top 10 renowned architects have been invited for the Bombay bidding auction. But they did not, none of the company have been reserved the right to bid. They have been mentioned over there. A right to bid was not notified by them.
Where?
So in the third line.
A right to bid was not notified by them. They invited top 10 renowned architects in Bombay for bidding. A right to bid was not notified by them. Furniture was put in up. Okay, that is what you wrote. Okay, understood.
Not notified by them. So it is not mentioned that only the top 10 has to be participated. So it is in general, Mr. Dev's company has a option to participate and he is the highest bidder. So it can be sold to him unlawfully. It has been sold to Mr. Neil by the contract which has been told that only the top 10 renowned architects have to be participated in this auction. So only because of the
Okay, you are saying the first one was unlawful or lawful?
unlawful.
Unlawful. Second one was?
Because it is by the seller's agent, which is not to inflate the price, only to tell the
Okay, you are saying first one was unlawful, second one was lawful. That is what all of you wrote? What did you write? Same? Same? Arnav, you wrote all same? What did you write? Second one was unlawful. First one is? Both were unlawful. Okay. Now people, now try to understand what is that they are telling. What did you write, Shravya? You did this you didn't attempt or?
I didn't try this.
Okay. Now sir, Ramana? First one, what did you write? Unlawful. Okay. Now people, try to understand what they are telling you is, they appointed RN Associates as auctioneers. They have invited top 10 renowned architects in Bombay for bidding. A right to bid was not notified by them here means people nothing but the seller is there, no. The seller has not informed the auction, neither the auctioneer has informed the auction that someone from us will come and participate in the auction. We have not intimated. That means what? We have not reserved the right to bid. That's the meaning of a right to bid was not notified by them. Meaning, we have not reserved the right to bid. That means we cannot participate.
from the seller.
Seller or auctioneer. Whoever is selling. What did we write? Seller or any other person acting in such behalf. If they want to participate in the auction, you are supposed to notify the right to bid. They have not notified. That is what they are telling you.
So then the second one is unlawful.
Now try to see. Okay. Now furniture was put in lots. Now in this case, what happened? Neil, Raj, Dev. Dev did the highest bid, correct. But what did they give? See, they have only given in the answer. I mean, they have only given in the question. Mr. Dev bid was rejected. Why? On the ground that the right to bid was reserved and the company of Mr. Dev was not invited to the bid at all. Yesterday I told you, what do I mean by that right to be bid may be reserved or it can be notified? That means I can tell, yesterday I told you government tenders and all, I told you, right? I will say that you should be at least 10 years experienced because we do not trust as government. Government tenders do that. So when I have invited here top 10 people, some other person also has come and participated in the bid. He did not get an invitation at all. So by default, we will reject his bid because that is the meaning of notified or identified or invited. That's why they have given it here. Where is that? 10, top 10 companies somewhere they would have given. They invited top 10 renowned architects in Bombay for bidding. So it means what? Only they should come. Someone else is coming means you are not allowed. So on those grounds I am telling you, the first sale is lawful. Second one is, in second one what happened? For another bid of Italian, two parties as follows. Dheer and Mr. Madhu on behalf of R&S Associates. Sale was completed in favor of Dheer instead of Madhu. So there are two people, Dheer and Madhu. Madhu is representing R&S Associates. Have they reserved right to bid? A right to bid was not notified by them. Hello? That means can they participate? No. So people, Madhu cannot participate at all. So now two people participated in the bid. One is Dheer and one is Madhu. Madhu's bid is invalid. So whom did they give that furniture to? Dev. So is it lawful? It is lawful. Understood? You said unlawful. Lawful. Both are lawful. So the auction was lawful. Understood? That's why I am saying first time they have given this entire provision connecting all the points.
So it's confused by the-
No. You can just write 3 points. One. See, one is right to bid is reserved. Right to bid may be notified. And what is the other one? Completion also no. Pretended bidding is not allowed. On that ground, I cannot give it to Mr. Dheer. So these 2 points, section 64, and I will write 2-3 points as provision, more than sufficient. If they're giving this question, it will be at least for 5 marks or 6 marks. Is this clear? 5 marks they will give.
confused only with the-
I know. But remember, okay, next one. A government department conducted an auction of used vehicles. Mr. Suresh bid for a truck at 5 lakh rupees. Before the auctioneer's hammer fell, Suresh tried to withdraw his bid, but the auctioneer refused. Later, the auctioneer also bid through his agent without prior notice to the bidders. Another bidder, Mr. Akash, complained that the auction was not fairly conducted. Decide with reference to the Sale of Goods Act. Again, 2 things are there here.
Not valid, invalid.
First one is, can he withdraw the bid?
Yes.
He can.
Before the hammer falls, he can withdraw. And then the prior information.
You should have notified. So always remember people, fall of hammer, that is the completion. Before that people, I am free to withdraw. When will the offer get accepted? Whenever there is a 3 times of hammer fell, that is when offer and acceptance meet. Before that, can I withdraw? Yes, I can withdraw. Why can't I withdraw? So it is possible. So that is unlawful. Next one is, what is that? Someone has participated on behalf of the auctioneer or the seller and it is not intimated. Prior intimation is not given. That is unlawful. Whenever it is unlawful, people, you can consider it as voidable. That has to be written.
So that is fraud.
Fraud, voidable. Answer is you should say it is voidable. Correct? Those are the keywords. That 2 has to be there. Clear? Okay, next one. Mr. Varun, a laptop distributor, delivered 20 laptops to his friend, Mr. Mohit, on the condition of sale on approval or return within 10 days. Rohit neither returned the laptops within the stipulated period nor informed Varun of any rejection. Instead, he kept the laptops in his office showroom and sold 5 of them to Mr. Anuj, claiming to be absolute owner. Anuj purchased a laptop in good faith, paid full consideration, and even issued a receipt for it. After 15 days, Varun demanded the return of all the laptops, including those sold to Anuj. Rohit refused, arguing that he had acted as the owner. Anuj also defended himself, claiming that he was a bona fide purchaser for the value. Varun, however, relied on the principle that no one can transfer a better title than he himself has. Decide under the Sale of Goods Act whether Anuj has acquired a valid title and whether Varun can recover the goods.
So Anu just required a valid title.
So Varun has given to Rohit, Rohit has given to Anuj.
So now in this case, Varun have given the 40 laptops to Rohit in case if you want to return it within 10 days or any approval or rejection should be conveyed by the Rohit to Varun. There is no any return of goods for the 10 days and there is no any approval or rejection given by the Rohit to Varun. So according to sale or return basis, the sale is completed. Once this been transferred to Rohit because the stipulated period has been over and he kept the good with him and he acted upon the sale equivalent to the sale. That is, he gave the goods to another or in possession of the equivalent to sale. So the ownership is given to Rohit. So Varun is not liable to recover any product from the Rohit and Anuj has a title acquired.
Okay, good. Two provisions that you guys need to write here is one is from his point of view, one is from his point of view. One, whether Rohit got the title or not. In sale or return basis, when is the acceptance complete? Three things has to happen. One, I should have communicated my acceptance. Second thing is I should have kept the product beyond the return period. Third thing is I do something equivalent to an acceptance. Here they have clearly given people that he has kept the product beyond the stipulated period. That means 10 days, I have kept it for 15 days. That means that is one way of acceptance. Second one, people, I do something equivalent to an acceptance. You gave it to me. I can only sell it if I think it is mine. So in both the grounds, people, I have communicated my acceptance. So no, Varun cannot recover the laptops. This on sale or return basis, the acceptance has been communicated and hence the ownership has been delivered. Now this is from Varun to Rohit's point of view. Answer number one. Now answer number two, from Rohit to Anuj. Now this is where most of the people wouldn't have answered. You will write sale or return and you will leave it. The next thing you guys need to write is, what is the question they have clearly asked you? There is a principle it seems which says, see again I am saying you, the examiner helped you. There is a principle which says no one can transfer a better title than he has. That means what? They are asking you, Nemo dat quad non habet ka exception. Sale by a owner in possession before getting the property. You would have written CA, sale by a owner getting possession before getting the property. There you would have written in the brackets, sale or return basis. So on that ground, people, Anuj got a good title. So you need to write both. Understood? Yes, you need to write that as well as this. If you write both, you will get marks. If not, no. Clear all of you? Got it? See, are you getting what do we miss? Yes. So we need to read the question properly and we need to write whatever completely is required. We would have written one part. We wouldn't write the second part. Now are you getting? In exam, this is what happens. We would have written half and half. We would have thought, sir, I have answered no, sir, sale or return basis. But why did they not give mark? That's why whenever students say, sir, I did not get, they did not do valuation properly, I'll say, you get your papers. Today only I'm telling you, for all of you, if you think after something and all, after exams and all, if you think somewhere you got marks less than what you anticipated, you meet me with your paper only. There will be, now if it's a 5 mark, they will definitely cut 2 marks or 2.5 marks because it is not complete. So you might get 2 marks or 2 or max to max. If everything else is good, then 3. So you can imagine for every 5 mark question, if you're losing 2 or 3, you would have lost around 45-50 marks there. That's where it will dip. Clear all of you? Yes. Okay, we'll see 61. That's what we need to see. A, B and C are partners. A, B and C are partners of a partnership firm carrying on the business of construction of apartments. B, who himself was a wholesale dealer of iron bars, was entrusted with the work of selection of iron bars after examining its quality. As a wholesaler, B is well aware of the market condition. Current market price of iron bar for construction is rupees 350 per kilogram. B already had 1000 kg of iron bars in stock, which he had purchased before price hike in the market for 200 per kg. He supplied iron bars to the firm without the firm realizing the purchase cost. Is B liable to pay the firm the extra money he made, or he doesn't have to inform the firm as it is his own business and he has not taken any amount more than current prevailing market of rupees 350? Assume there is no contract between the partners regarding the above. What is the answer? Payal, what is the answer? You wrote yes? He is liable to give back whatever that 150 rupees are. 150 rupees per kg. Why? What is the provision? He made secret profits. That's what you guys wrote. Remember, if you make any, what is a provision? Provision is nothing but whenever a partner makes any money using the firm's transaction or using the firm's name or using the firm's network, or if he does any competing business or any secret profit, in any of these scenarios, you are liable to compensate the firm for whatever is the profit you made. In the given scenario, secret profit also can be written. Also, it is firm's transaction, no? That is, firm had to buy iron rods. In that transaction, he is making profit, which is not allowed. Now see, specifically, we write all the places unless otherwise agreed. To help you is what they have given you this point. Assume that there was no other contract contradictory. That means there was no private contract. So you guys have to assume that whatever was a contract made in our partnership deed, there was no other provision regarding that. So I'll be writing that is my provision. The partner made money using the firm's transaction.
So, but that is his own business.
Correct. Now they had to buy iron rods. So partnership firm is buying iron rods. Now who is selling? He is selling that. That means it became the partnership's transaction. So in the partnership transaction, if you are making any money, it is your duty to disclose. That's why we write secret profits are not allowed.
So
It is your private business, correct?
in the case if he is buying for 330 and if he is telling us 350, in that case he can be telling us the secret profit.
No. See, secret profit is what? He made a profit end of the day. That becomes.
If he disclose means it can.
See, the thing is what you're saying is correct. He is making the business for his thing. That is agreed. He made profit for his business. Agreed. But you made the profit using which transaction? You could have sold it to an outsider. That is nowhere the firm is involved. For that, we are not telling anything. You sold that for the firm. And does the firm know from whom did you buy it? No. So that yesterday also, if you remember, that is what I told you. It's not that I'm not telling you cannot have a business. You can have a business. The only thing you need to do is you need to disclose that to the firm that it is from this transaction we made this much of money. So you're not supposed to make a profit. You can make profit. It is your own business, agreed. That's why I added the term called secret profit. That you're not supposed to make. Agreed?
If he buy earlier he bought for 200 per kg and he sold it for 350 per kg. That is the difference amount he made.
150 rupees, he has to give it back to the
But
firm.
if he gave to the firm for the 200 per kg also, it's a secret profit.
Profit only did not made, no. Now the secret profit scenario itself will not come. What was the provision? Whatever profit you made, that you have to give it back to the firm. In this case, I did not make profit only. So if he purchased at 200, if he sold it back at 200 only, then I did not make profit at all. So I need not have to compensate firm for anything.
Sir, if we disclose and told that I got 200, but I am selling to 350 because it is my own business.
In the case if they have given that I have purchased at 200, it's my own stock, I'm selling it for 350 and partner's approval was taken, then absolutely no problem. You can keep the 150 rupees profit you made. You need not have to give it back to the firm. Why am I saying you have to give back is because you did not disclose. Understood? Huh?
There can be use of firm's property here in the provision.
No, we did not use the firm's property, no? Use of firm's properties now, for example, I'm using this camera and making my own private video. That becomes use of firm's property. Transaction of the firm means we are buying something or we are paying someone something. I'm doing it through me. Then I am making profit out of it. They're telling that is not allowed.
So market is here, the market price is 350. So if he is selling for 300, he is selling below the market price.
Still he is making profit. His stock is 200. You're saying instead of 150, he's selling it at 100. I mean, instead of 150 profit, you're saying he's selling at 100 rupees profit. Profit only. Yes. So what we are trying to tell is, it is your duty to disclose that you are doing. Why I am telling you this is, try to understand. See, now you know that the firm wants iron rods. Here it is not that you are helping the firm. We are not denying it. The intention is clear. In the name of the firm, you are not supposed to cheat the firm. Now here you know everything. That's why you are questioning. In reality, do you think you will know everything? Do you really know what outsiders are charging for that iron rods? Would you really know? In reality? That's exactly I'm saying. In the question they have given, in reality, what I'm saying is the intention why we have introduced that provision. If the agent is telling, that is, if the partner is telling that this is how you are making the profit, that means what? You are being transparent. If I do not know that, how will you know what is a genuine transaction, what is not a genuine transaction? How would you know? If you actually see, the market price is also told by the partner only, no? How did you get to know market price is 350? That also partner would only have told you. So you look at the reality. That's why they said you cannot make a secret profit. You disclose and do, we are okay. Now my question is, my simple provision, why cannot you tell that it is your stock? Are you scared of something? Or are you hiding anything? Don't you think that is the easiest one? Just to tell and make profit? So the act presumes that when a person is not disclosing, that means he is hiding something. Yes, sir. Hello? This is arising purely out of transaction with the firm. Hence, Mr. B is accountable to the firm for extra profit earned thereby. Okay, Next one. Mr. A transfers his share in the partnership firm to B. Mr. B felt that the books of accounts was displaying only a small amount as profit in spite of a huge turnover. He wanted to inspect the books of accounts of the firm, arguing that it is his entitlement as a transferee. However, the other partners were of the opinion that Mr. B cannot challenge the books of accounts. As an advisor, have you guys written this?
Yes, sir.
You guys wrote? No, okay. This I think we are going to see this today. That is when the topic is there. I think it came early.
Sir, you can.
But what is the answer is nothing but people remember, whenever in a assignment, whenever there is a transfer of share, the transferee will not have the same right as that of a partner. So I'm just telling the provision for the sake of it, but when the provision comes, I'll explain it to you. But the answer is nothing but people, the transferee will not enjoy the right to inspect the books of accounts, ask for the books of accounts. You cannot interfere in the conduct of the business. That is a provision. So in the given case, whoever is a transferee, B cannot interfere in the business.
We can go to dissolution.
We will see that. For now, I'll not take that particular thing. I'll explain it to you. We have it today. Today, we'll be seeing that particular provision. That time I'll tell you. Clear?
Actually, all the partners have the right to inspect.
Correct. Yesterday also, if you remember, in rights and duties, we wrote in one place in the brackets except transferee. You remember? Rights and duties. When we started unit 3, initially only we would have written C. Brackets it will be there. In one place you would have written transferee.
Except the transfer.
Except the transferees. That is his provision.
In the case of ownership.
In the case of a person who can interfere with the books of accounts and all, a transferee can never interfere with the books of accounts. Why and all, I'll tell you the logic today. We have the topic today. Okay, next one. MN partnership firm has two different lines of manufacturing business. One line of business is the manufacturing of Ajinomoto, a popular seasoning and taste enhancer for food. Another line of business is the manufacture of paper plates and cups. One fine day, a law is passed by the government banning Ajinomoto's use in food and to stop its manufacturing, making it an unlawful business because it is injurious to health. Should the firm compulsorily dissolve under the Indian Partnership Act, how will its other line of business be affected? What is the provision? Compulsory dissolution. Under voluntary dissolution, we saw compulsory dissolution. Compulsory dissolution, when will it happen? Whenever all the partners become insolvent or all but one becomes insolvent or happening of any contingency which makes the carrying on of business unlawful. Now, whenever a business has two separate line of businesses, meaning if I'm carrying on more than one business, we saw it, right? General partnership and particular partnership. I explained this in both the scenarios. One during general partnership, when I'm carrying on 2-3 businesses, in the class example we saw was, if at all I'm doing tobacco, if tobacco is coming to an end, if my legal part can continue, then you need not have to dissolve the partnership firm. Whatever is the illegal part, you need to shut down that business. The legal part can continue. In the given case, Ajinomoto will come to an end. Paper plates can continue. Dissolution of partnership, compulsory dissolution. Provision is compulsory dissolution. It can happen whenever all the partners become insolvent or in the case of
It's a happening event making law.
which makes it unlawful. Shavani, after how many days? I saw you in your childhood. Okay, next one. Sohan, Rohan and Jay were partners in a firm. The firm is dealer in office furniture. They have regular dealings with AB and Co. for the supply of furniture for their business. On 30th June 2018, one of the partners, Mr. J, died in a road accident. The firm has ordered AB and Co. to supply the furniture for their business on 25 May 2018 when J was also alive. Now Sohan and Rohan continue the business in the firm's name after J's death. The firm did not give any notice about J's death to the public or the person dealing with the firm, Measures AB and Co. delivered the furniture to the firm on 25th July 2018. The fact about J's death was known to them at the time of delivery of goods. Afterwards, the firm became insolvent and failed to pay the price of furniture to Measures AB and Co. Now, Measures AB and Co. has filed a case against the firm for recovery of the price of furniture. With reference to the provision of Indian Partnership Act, explain whether J's private estate is also liable for the price of furniture purchased by them. I think even this provision is also not covered. Okay, we have to. This also will come today only. In short, I told you also. Whenever a partner dies, his estate will stop to be liable after the date of death. In the case of insolvent, when will the partner's estate become, when will it stop to be liable? On the day when the court is adjudicating that partner as insolvent. And I told you also, in the case of death or even in the case of sleeping partner, when they are leaving, you need not have to even give public notice. So from the date of the death, their estate is not liable. That's the provision. But I'll tell you when we are explaining the concept, we'll be going in detail. We have both the concepts today only.
Even if they are not issuing notice, the further transaction should take place in the name of firm or else the remaining partners.
So in this case, what is happening? If 3 partners are there, a partner died. Whenever he dies, whoever is continuing, they will be liable. That is, the partnership firm will be liable, not my share. Now let us imagine if the total share of the partnership firm is 10 lakh. In this, if my share is say 3 lakh worth, this will not be liable in that transaction. Only your 7 lakh will be liable and not my 3 lakh. You know what is the tricky part here, which we are yet to see? That is not the scenario. When did they enter into a contract? contract was entered on, let us imagine 1st Jan 2026, when the partner was alive. But did the furniture get delivered? That means was a contract performed? No. Let us imagine he died on 10th Jan 2026. Furniture was delivered on 20th Jan 2026. Now the question is that furniture is delivered on 20th Jan 2026, but he died on 10th Jan. But the contract to buy the furniture was entered on 1st Jan. So is the partner who died, is he liable for this contract? So this is where, I mean, we are yet to see that, it will come today. Remember, on the day of the death, if the contract is not yet done, whatever are the contracts that it is not yet performed on my death, that happens, are done. That's all, people. From here, your liability comes to an end.
Sir, and also they know that he died.
That is also there. But I'll tell you, when will this come to an end? We will see. We'll be seeing it today. So remember, after the date of the death of a partner, any contract which is not yet performed will be coming to an end from that partner's point of view, not the other partners, I'm telling. For this partner, he will be discharged. Because that is what we saw, right? One word I said, that is, from the date of the death, he is discharged. So his estate is also discharged. So is he liable? Answer is no. Are the other partners liable? Answer is yes. Okay, last one. Moni and Tony were partners in the firm, Measures Moto and Company. They admitted Sony as a partner in the firm and he is actively engaged in day-to-day activities of the firm. There is a tradition in the firm that all active partners will get a monthly remuneration of 20,000, but no express agreement was there. After admission of Sony in the firm, Moni and Tony were continuing getting salary from the firm, but no salary was given to Sony from the firm. Sony claimed his remuneration, but denied by existing partners by saying that there was no express agreement for that. Whether under the Indian Partnership Act, Sony can claim remuneration from the firm. Is it allowed? Custom. So when can a partner claim remuneration? My provision is, people, if at all my partnership deed provides, if at all the custom provides. Custom means what? In our partnership firm, we have been used to paying the remuneration. If that is there, then I can provide remuneration to the partners. So in this case, Sony will be entitled for remuneration because in the partnership firm, it's a custom to provide the remuneration. That's my provision.
From the date he no.
From the day he claims, yes, he can be entitled for remuneration. Yeah. Sahil and Amit and Kunal were partners in a firm. The firm is a dealer in office furniture. They have regular dealings with AB and Co. for the supply of furniture for their business. On 30th June 2023, one of the partners, Mr. Kunal, died in a road accident. The firm ordered Measures AB and Co. to supply the furniture for their business on 25th May 2023. Okay. Now Sahil and Amit continue the business in the firm's name after Kunal's death. The firm did not give any notice about Kunal's death to public or the persons dealing with the firm. Measures AB and Co. delivered the furniture to the firm on 25th July 2023. The fact about Kunal's death was known to them at the time of delivery of goods. Hey, sure, Ada, we did not do this. Afterwards, the firm became insolvent and failed to pay the price of furnitures to Measures AB and Co. Now, Measures AB and Co. has filed a case against the firm for recovery of the price of furniture. With reference to the provisions of Indian Partnership Act, explain whether Kunal's private estate is also liable for the price of furniture purchased by the firm. Liable? Kunal's estate is liable. Remember the provision, people. Three things here. Whenever a partner dies, his estate ceases to be liable for any actions of the firm. Even though the contract was entered before his death, but the contract was not yet performed on the date of the death. If it is performed, it's a different story. As the contract is not yet performed, any contracts that happens after the death, the estate of the partner ceases to exist. Exit. So there will be no liability of Kunal's property. One more thing you guys have to mention, in the case of a death, you need not even have to give a public notice because they stressed upon that point. you have to write public notice point also not required, and upon the death, the partner's property ceases to exist. So I will not be liable for any of the firm's contracts after the death of the partner. Clear?
Provision repeated, sir, not the question.
Huh?
Provision repeated, not the question.
Provision repeated. Okay. That's where I remember somewhere I explained you this. Okay, therefore the estate of the deceased partner may be absolved. They use the word illa. Absolved means what? It can be exempted. Once in a while, they nowadays that they are trusting hi-fi English words and all. This is only called as context reading. You should be able to pick up the meaning of the word from the context. What if they had asked in a question, would Mr. Kunal's property be absolved from the liability? Absolved here means exempted. They just drop like a bomb. You have to do, this is called context reading. You need to get the meaning of the word from its neighboring words. Getting the point? X and Y were partners in a firm. The firm was dissolved on 12th June 2022, but no public notice was given. Thereafter, X purchased some goods in the firm's name from Z. Z was ignorant of the fact of dissolution of the firm. Ignorant here means he was not knowing. X became insolvent and Z filed a suit against Y for recovery of his amount. State with reasons whether Y would be liable under the provisions of Indian Partnership Act 1932. What Abbas?
Yes.
Will he be liable by provision?
So in partner case, that if one become insolvent, so other will be.
No, they're saying dissolved. The firm was dissolved on 12th June. After that, one partner has entered into a contract with an outsider.
Sir,
After dissolution.
at the time of dissolution, the notice should be given to all the creditors and third parties.
Remember, people, just like active partner, whenever the partner dissolves, active partner had to whenever a partner resigns, he had to give a public notice. Cut, copy, paste provision we saw in the case of firm, whenever the partnership firm is dissolved, the partner's liability continues until the date of public notice. In the given case, as the public notice is not given, the partner's liability continues. So in this case, people, will Y be liable? Yes, Y will be liable because public notice was not given yet. That's a provision.
The mutual agency among the partners.
See, now you should not write mutual agency. Because there is a bigger provision involved. What is you can write mutual agency. The partner will continue to be liable. Correct. Yes. In the case of dissolution, the partnership firm is liable to give the public notice and the partner's liabilities continues until the date of the public notice is given. That's the complete provision. Yes. Measures LMP and Associates, the partnership firm engaged in carpet manufacturing and exporting, was initially managed by a senior partner, LM&P. On 25th August, the firm admitted Mr. G, an expert in carpet manufacturing, as a partner. However, on 10th Jan 2024, G was accused of unauthorized activities and subsequently expelled from the partnership with the unanimous approval of the remaining partners. With reference to the provisions of Indian Partnership Act, answer each of the following. Examine whether action by partners was justified or not. What are the factors which should be kept in mind prior to expelling partner from the firm, by the other partners? Expulsion of a partner. I told you all the conditions to be satisfied. Tell me what are that? First of all, you need to have that right in the partnership deed. Right of expulsion should be there in the partnership deed and majority partner should agree. Here everyone has agreed. It's okay. Third, it should be in the good faith. He has done some injustice. Correct? So yes, it is justified. And one more thing. When will we say it is good faith? You should be given opportunity of being heard. Next one, notice has to be served to him. Hello? And it should be in the interest of the partnership. If all these conditions are satisfied, then expulsion is valid. Hello? See, Yes. So here they're asking you, is the expulsion valid? Correct? Huh? You need to assume and write. Assuming that the notice has been given, assuming that this has been done, because they have not given. Have they given? Huh? You need to assume. You need to say assuming that. Hello? Okay. What do you mean by partnership for a fixed period? Direct questions? A partnership which is carried on for a duration as per its agreement. Post which should you wind up? No, you can continue provided you will be considered as partnership at will. When can the continuing guarantee be revoked under Indian Partnership Act 1932? Huh? Anytime. And remember, whenever there is reconstitution, for the future acts you can revoke, but not the previous acts. Whenever there is an admission of a partner, resignation of a partner. Hello? Third one, what do you mean by goodwill? Goodwill, reputation of the company, as the case may be. Any change in constitution of the firm. Hello? Remember and go. Okay. PQR formed a partnership agreement to operate motor buses along specific routes for a duration of 12 years. After operating the business for 4 years, it was observed that the business incurred losses each year. Despite this, P is determined to continue the business for the remaining period. Examine with reference to the Indian Partnership Act, can P insist to continue the business? If so, what options are available to Q and R who are reluctant to continue the operating people? Reluctant means what? They are opposing, who are not interested. Reluctant means they are not interested.
They can go to the court and
Dissolve.
they can dissolve.
Okay, what is the scenario? It comes under dissolution by order of the court. So, a person whenever, what is the ground? Dissolution of order of court, what is the exact provision?
Continuous loss.
Perpetual losses. Whenever the firm is incurring perpetual losses, now what I can do? I can go to the court, majority of the partner may request, then yes, it is one of the ground for dissolution. Now we will go with the court's order. Now people can P continue. P can request to continue. Yes, he is valid because you have opened for 12 years. What is the advice Q and R? What is the options they have? They can go under court, dissolution by court. That is under perpetual losses because for the 4 years they are in loss. Hello? Ram and Shyam are partners in a partnership firm styled as RS & Co. Gopal, a renowned businessman, is their common friend. Ram introduced Gopal to Sundar, a supplier to a firm, as his newly joined partner. Same case we saw, na? Gopal, knowing that he is not a partner, preferred to keep quiet on such an introduction. This information about Gopal being a partner of the firm was shared by Sundar with another businessman, Madhav. Next day, Sundar supplied the raw material on credit and Madhav lent 5 lakhs to the firm for a short period on the understanding that Gopal is a partner of the firm. On due dates, the firm failed to discharge its liability towards both. Advise Gopal whether he is liable to Sundar and Madhav for the aforesaid liability of the firm. Tell me, is he liable for both or only one? I specifically made you guys write that also. For both or one? One. Because people direct representation I am liable. Indirect representation? Bomb question it was. Clear, huh? So this is nothing but partnership by holding out or estoppel. Whomsoever we made a belief, a direct representation, for them we are liable. Indirect representation we are not liable. So wherever I represented myself, there I am liable. Indirect representation I am not liable. Clear? Okay. Yes, people? Mr. M is one of the 4 partners in Measures XY Enterprises. He owes a sum of 6 crore to his friends, to friend Mr. Z, which he is unable to pay on due time. So he wants to sell his share in the firm to Mr. Z for settling the amount. In the light of provisions of Indian partnership, discuss each of the following. Can Mr. M validly transfer his interest in the firm by way of sale? So what has happened here? M has taken money from someone, he is not able to repay. Can he sell this interest in the for the loan that he has taken? Is it possible? You have to do it only after the consent of all the partners. But can you pledge? Can you do all of that? Answer is directly no. There is a restriction, but after the approval, yes, you can do. A transfer of partners' interest in the firm is absolute or by mortgage or by the creation of any charge or such does not entitle the transferee during the continuance of the firm to interfere in the conduct of the business or to require accounts to inspect, but transfer. Yes, Mr. M can validly transfer his interest in the firm by way of sale. When, if at all the others are not willing to buy it, then I can sell it. There is no restriction on that. Agreed? Okay, next one. What would be the rights of the transferee in case M wants to retire from the firm after a period of 6 months from the date of the transfer? Rights of transferee. You cannot inspect the books. You cannot interfere in the conduct of the business. You cannot require the books of accounts. So that is your rights. Simple. That's my provision. To receive the share of assets, for the purpose of asset in day. I also fell for it. What would be the rights, da? What did we say? We said restriction. You wrote restrictions only, Rights, people. What are the rights? I'm entitled for my share of profits every month. If at all we are entering into dissolution, I'm entitled for the share of my asset and also I'm entitled for the accounts from the dissolution order. That is my right. My God. Durandar. Hey, exam, this is how it will happen. And I also fell for it. Bhagwan. Mr. Raj formed a company with capital of 50,000. He sold his business to another company for 40,000. For the payment of sale, he accepted shares worth 30,000. The balance 10,000 was considered as loan and Mr. Raj secured the amount by issue of debentures. By now only you should know which case. His wife and 3 daughters took 1 share each. Owing to the strike, the company was wound up. The assets of the company were valued at 6,000. The debts were 8,000. Mr. Raj retained the entire sum of 6,000 as part payment of loan. To this, other creditors objected. Their contention was that a man could not own any money to himself and the entire sum of 6,000 should be paid to them. Examine the rights of Mr. Raj. What is the answer? Remember, people, separate legal entity, the shares, the shareholder is different and the company is different. As Mr. Raj had a secured debenture, he will be given the priority in repayment because from the company's point of view, both are seen as outsiders only. Why corporate will? Why are you lifting corporate will? Simply, sir, anywhere it's lifted. No, separate legal entity. What did he do injustice? What is the case law? Salomon versus Salomon. You will give a reference to Salomon versus Salomon. That case law you saw under separate legal entity. Where? Huh?
Corporate theory we can mention also. Not lifting of corporate.
Okay. Yes, that too. Lifting that's what okay. Corporate wheel is yes. That is nothing but separate legal entity. Lifting of corporate is you're lifting the identity of separate legal entity. That is okay. Lifting of corporate wheel alla. Salomon versus Salomon. This is very, very important. That case should be mentioned in your answer. Okay, based on that, whether Raj can take it? Yes, because he has a secured debenture. BC Private Limited and its subsidiary KL Private Limited are holding 90,000 shares and 70,000 shares respectively in BC and its subsidiary. This is holding are holding 90 and 70,000 respectively in PQ. The paid up share capital of PQ is 30 lakhs. The total PQ's capital is, or basically take it as 3 lakhs. That is total paid up capital. Okay, analyze with reference the provision of Companies Act. Hey, 9 plus 7 how much na? 16. So 1/2 is 1.5. They are holding 1.6. Add these two. What is the provision? Write down subsidiary company. 2 clause 87. A company in which majority of the board of directors are controlled. Composition of board of directors, or when a company either on its own or together with its subsidiary controls more than 1/2 of the total voting power, either on its own or together with its subsidiary. So I will be adding 90 plus 70k. That's my provision. Yes, PQ Limited is a subsidiary company of BC Limited. What would be your answer if KL Private Limited is holding 1,60,000 shares in PQ Private Limited and no shares are held by BC? They are telling in second scenario. What if KL only directly holds 1.6 lakh? Then what will be the scenario? Deemed subsidiary of whom? PQ will be a deemed subsidiary of BC Limited. Remember. Hello? KL becomes a holding, but BC Limited will become the ultimate holding company. So it will be, you need to write the word deemed subsidiary company. Okay, next one. A company ABC Limited as on 31st March 2025 had a paid up capital of 1 lakh. In June 2025, ABC Limited has issued additional 10,000 equity shares of 10 each. Out of 10,000 shares, 5,000 of these shares were issued to XYZ Private Limited. XYZ is a holding company of PQR Private Limited by having control over the composition of its board of directors. Okay, how many companies came? Okay, XYZ is a holding company of, okay, ABC has a total paid up capital of 10,000 equity shares. In June 2025, ABC Limited has issued additional 10,000 equity shares. So totally how much they have? 20,000 shares. Out of 10,000 shares, 5,000 of these shares were issued to XYZ.
In 20,000.
Okay, in that 20,000, 5,000 is held by XYZ in ABC. Okay, now PQR Private Limited claims the status of being a subsidiary of ABC Limited. PQR Private Limited claims the status of subsidiary of ABC Limited. That is XY. Okay, wait. ABC Limited as being a subsidiary of its subsidiary, that is XYZ Private Limited. Examine the validity of the claim of PQR Private Limited. State the relationship, if any, between ABC Limited and XYZ Private Limited as per the provision of Companies Act. Tell me, people.
Sir, relationship between ABC and XYZ is an associate company.
Very good. The people, ABC totally has 20,000. In that, how much am I holding? 5,000 shares. That is nothing but 25%. Definitely, I am not a subsidiary company. They are not holding anything here. So there is no relationship of subsidiary holding company here. But XYZ is holding 5,000, which is 25% of its total shares. So this, what type of company it will become? It will become associate company. Clear? Correct? Whether PQR is a subsidiary company and XYZ is it a holding company?
No,
XYZ PQR is a subsidiary.
no, sir.
But so the question was like whether PQR is an
What are they asked?
It is written now.
Excess is
PQR.
holding a piece. They have
Now, PQR Private Limited claims the status of being a subsidiary of ABC Limited as being a subsidiary of its subsidiary, that is XYZ Private Limited. Is PQR a subsidiary company? No, ABC is not holding anything in PQR, no.
ABC itself, it's not a subsidiary company.
Correct. So is it? No. But is PQR a subsidiary of XYZ? Yes. Why?
They have
They mentioned that XYZ is over.
so
They shouldn't have said that, but they should have given it to you this way. When one company controls the composition of board of directors of another company, you will be deemed to be a holding subsidiary company. Remember that. That is what we wrote to the left. Majority of directors. Hello? Clear? Okay. Do you agree that a company is an artificial person? Yes, that's all done. Elucidate. Also explain how the authorization by Beta Limited, a company incorporated under companies that can be made in case it does not have a common seal. So if a company does not have a common seal, you need to sign it by 2 directors. If at all you have a company secretary, it will be 1 director and 1 company secretary. That is answer, huh? Okay. Narendra, we have not written, right? Yes, people. 78th question. So from here it was only companies related questions, right? Okay, Narendra Motors Limited is a government company. Shah Auto Private Limited have share capital of 10 crore in the form of 10 lakh shares of 100 each. Narendra Motor Limited is holding 5 lakh 5,000 shares in Shah Auto Private Limited. Shah Auto Private Limited claimed the status of government company. Advise as a legal advisor whether the Shah Auto Private Limited is government company under the provision of Companies Act 2013. Is it a government company? No. Why?
Subsidiary company. Because it is not holding more than 50%.
50.5%.
They are holding 50.5 percentage. Remember, what is the status? Huh?
No, it is a subsidiary company, but not
associate company.
associate.
Associate less
Less than 50.
Tell me correctly. What is your answer? It is not a government company. It is a subsidiary company. Which one? The Shah Auto Private Limited is a. It is claiming the status of government company. You are saying it is not a government company. It is a subsidiary company. What is your answer? Same only. Same only.
Should own
Huh? You should hold.
51% of the.
They wait. We wrote one provision in subsidiary company note. What is that?
Deemed subsidiary.
Ah.
Yeah, deemed subsidiary.
Count rate. What are they telling you? This company has how many shares? 10 lakh shares. Out of 10 lakh shares, there is one company called as Narendra Company. This is holding 5 lakh 5,000. Correct? 5.05 is what they are holding. Now, people, what is the definition of subsidiary companies here? If at all a company is holding more than 1/2 of the total voting power, half is 5 lakh. More than 1/2, 5 lakh, 1 share is equal to also more than 1/2 only. So because of that, the Shah Private Limited becomes subsidiary company of Narendra Limited. Now what is Narendra Limited? Narendra Limited is a government company. Now what is the provision? Remember, a subsidiary company of a government company is a deemed government company. So yes, you will get the status of government company only. As per section 2 clause 87, you are a subsidiary. Hello? I'll be writing 2 provisions. One is government company and one is subsidiary company. Clear? 245 and 287. So Sharp Auto Private Limited being a subsidiary of Narendra Motors Limited will also be considered as clear? Okay, XYZ is a company incorporated under the Companies Act 2013. The paid up share capital of the company is held as on 31st March 2024 in as under Government of India, LIC. We have seen this. We already did yesterday only. Remember, what is the question? For the sake of this, again I am telling you, there is a company XYZ. In this, Government of India is holding 20%. LIC is holding, this is central government. LIC is holding how much? 8%. And who else? The Tamil Nadu government is holding 10%. Rajasthan is holding 10%. ABC Limited, which is owned by government company. ABC Limited, which is owned by government company, they are holding 15%. They're asking you what is the status of XYZ Limited. Now, what is a common mistake people will do? People will add 20 plus 10 plus 10. They will add this also. Remember, the definition of government company is simple. If at all more than 51% of paid up share 51% or more paid up share capital having to voting power, if it is held by central government, state government, center plus state governments, I need to consider it as a government company. So I'll only consider central government. I will add state government. The definition does not tell me to add government company or LIC holding at all. So I will not add 8% or I will not add 15%. Sir, but previous question you said subsidiary company of a government company is deemed to be a subsidiary company. Now tell me, it is not a subsidiary. It is only holding 15%. Nowhere they said you can add 15. That provision is nowhere there. So hence I am ignoring it. Sir, what if instead of this 15, if this is 55? Now yes, XYZ becomes a deemed government company because it is controlled. Clear? Hello? Okay. Stuti Textiles Private Limited is a wholly owned subsidiary of SS Textiles Limited. Whenever you are seeing this subsidiary company, this relationship and all, first to write off. Stuti Textiles is a wholly owned subsidiary of SS Textiles Limited. It has only 5 members and restricts the right to transfer their shares to any person other than a person who is in employment of the company. Some members opposed the decision of the company as they want to invite a group of people to subscribe shares in Stuti Textiles Private Limited. Decide with reference to the provision of Companies Act whether restriction of company to transfer share is correct. Is it correct? Hello?
So if it is a public company, it can be
Restrict
transferred.
to transfer.
Sir,
Sir, but if
yes,
they,
sir, it is because restrict means a private company can restrict to transfer shares, sir. It is mentioned that only 5 members are there.
so it is
That
like
means,
partnership.
7 members are
They're telling, can I restrict my shares from transferring from one person to another person? Is it allowed? Is what they're
You
telling.
have to see what it is private or public company.
No,
Sir, yes, sir, it is a private company.
Sir, ಇದು partnership ತರ ಅದೇ
You have to ask. Restriction is what you're saying. See what they're saying. People, according to section 268, private company means a company which restricts the rights to transfer his shares. Correct? They written the point. But according to 271, public company which is subsidiary of a company not being private shall be deemed to be a public company for the purpose of this act. Where such subsidiary company continues to be a private company in the article of association. The shares of public company is freely transferred. In instance case, since Sudhi wholly owned to transfer shares not correct as it is deemed to be a public company, thus the restriction on transfer of shares is incorrect. Hello?
Sir, but in that case, 5 members are there. It's a private company.
In view of the above, the restriction of share transfer by Stuti Textile Private Limited is legally correct, even though it is a subsidiary of a. What is the answer here? What is the answer here? How can it have to? You know what? This is your Jan 2026 exam question. This alternate answer is given by your institute only, not me. You can write both. But people, I am telling you the industry answer. This is the answer. Legally correct. The restriction is correct because
Only 5 members are there in the company.
no, not like that. What did I tell you? See, people, what is the scenario, people? This Stuti, Estes Textiles Limited, this is a public company, limited, public company. This is Stuti Textiles Private Limited. It is a wholly owned subsidiary, so it's a subsidiary company. If you're a subsidiary of a public company, what will be your status? Deemed public company. In public company, can you transfer your shares freely or not? Yes. In a private company, can you transfer or not? No. Now the question is, when you are deemed to be a public company, can you freely transfer the shares or not? You are deemed to be a public company. People, I answered this question also in the class. Remember, people, for the purpose of restrictions, you will still continue to be a private company because in your articles of association, you would have written those 3 points. What are the 3 points? Restriction to right to transferability of shares, limit the number of members to 200, prohibit inviting public. You cannot go for an IPO. According to me, this answer is absolutely incorrect, which the institute has given as alternate answer. 100% incorrect. First answer. Because, now what did I say? They are telling you, because if you are taking the view, the subsidiary of a public company will be deemed to be a public company, hence you can freely allow the transferability of shares. Anyone can transfer shares to anyone. If you take that view, now my question is, then can this company go for an IPO? You're saying you can go because it's a deemed public company. Can this private company go for an IPO? Can it go? 100% no. So how can you take that view? You can never take that view. So only answer according to me is this. Even though you are a deemed public company, only for exemptions. You will not enjoy the exemptions like a private company. I told you, private company enjoys a lot of exemptions. Like for example, you need not have to prepare cash flow statement. Like that, there are so many benefits. That benefits you will not enjoy as a private company. You will be treated as a public company only. Hence, no exemptions. You have to follow all the rules like a public company. Rules.
So the private company is free of exceptions, which is given to the private company as it is deemed to be an
It's deemed to be a public company. So the exceptions that is given to a private company, you will not enjoy. That's the answer. I say 100% valid. I don't even want what others say. That is the answer.
the restrictions which are to be mandatory towards the private company will be
You have to follow. I'll tell you one thing, Ada. My question, it's deemed to be a public company, no? Hello? Deemed to be a public company, no? Then why write it as Stuti Textiles Private Limited? Write as Stuti Limited only, no? Deemed public oh, no. That restriction private. Then if you write it as private, it is a private company for the restrictions. You will have those 3 points in your articles. But yes, for your level, this is a very complicated question. Institute also knows. That's why they have given you both the perceptions. But this is wrong. This is right. Because the question is complicated, in the guideline answer only they have given alternate answer. That means in the exam, whoever has written as yes also would have got marks, no also would have got marks. If you ask me, the purpose is defeated.
Sir, it is mentioned that subsidy of a public company is deemed to be a public company.
Correct. That is what we also discussed. But operationally, you cannot become public company only. Are you getting that point? I hope you guys are understanding. Whatever restriction, private company definition, what is private company definition? First point you would have written, a company which by its articles of association. That means you guys should have written those 3 points in your articles. Hello? Understood? So based on that, I am telling you, the restriction of transferability of share is correct. Clear? Hello?
So can you also mention that
No. I hope that is clear. Okay. The paid up capital and turnover of Aradhya Cosmetics Private Limited for financial year 24-25 is 4 crore and 45 crore respectively. What is this? Capital and turnover. Directors of ACPL decided not to follow some provisions as it is a small company according to section 2 clause 85. The company secretary of Pooja Fashions Private Limited contended that ACPL is not a small company as ACPL is holding company. Decide whether ACPL Cosmetic Limited can avail the status of small company according to the provision of Companies Act. Can they? Hello? So people, today this anyways has gone up. This is Jan exam attempt. What is the first thing? See, first thing people, as per the paid up capital and turnover, our books are still not yet amended. Our book says still 4 crore and 40 crore. To be on a safer side, even in your exam, you guys write it as, what is a small company? A company which is having a paid up capital of 4 crore, turnover of not exceeding 40 crore. Amended, now it is 10 crore, 100 crore. Write it, it's okay. Clear? Hello? So in the given case, the paid up capital, let us answer it as per old provision only. Paid up capital is 4 crore. Turnover is 45 crore. As per new provision, it is within the limit. Can they be a small company? Yes or no?
Small company.
They have already helped you completely, people. They have only given in the question. Some companies cannot be called as a small company. Who are they? Public company can never be a small company. Next one. Holding company or a subsidiary company can never be a small company. Next one. Section 8 company. Next one. Statutory company. This is a holding company and hence it can definitely not become a small company. The contention of the company secretary here is correct. Huh?
Holding company.
Holding company, small company definition, Correct. Full. What is written after that? What is small company definition? You have written it as small company or not? How? You have only seen limits. You have not seen the other conditions.
So they have mentioned that holding company.
That is what they are telling. They are telling clearly it's a holding subsidiary. Okay. The paid up share capital of Abhinav Natural Gases is 140 crore. The holdings of central government and Maharashtra government are 40.10 and 30.20 crore respectively. In one tender relating to natural gas, directors of ANGL quoted it as government company. Decide according to the provisions of Companies Act whether ANGL can be tagged as government company. One provision. See the way the questions are asked. Only government company. I gave at least 4 different ways of question being asked. And people say, sir, question paper is difficult. That's why I tell you the key to pass is the more questions you see. See, one provision is showing you 4 different perspectives. Correct? Tell me, what is the total capital? 140 crore. How much are they holding? Central and Maharashtra together? 70.3. Is it
More than 51%.
more than 51?
No, sir, more than 50.214.
50.214. Shall not be tagged as government company. What is government company? You should be a 51% or more. Clear? People, you know why this provision is given? Subsidiary company and government company, everyone will get confused. Subsidiary companies more than one half. Government companies 51% or more. Remember those numbers. That's where maximum people will go wrong. In the given case, what they are holding together is 70.3. That is less than 51%. Correct? How much is 140 into 51? You guys do, you'll get it. 140 into 51%. How much is it? 140 into
71.4.
71.4. How much you got? 70.3. If you want, if I was a student, I would have written to become a government company, the Abhinav Natural Gases, I don't know who it is. Abhinav Natural Gases, the government should have held at least 71.4 to become or to be called as a government company. In the given case, it being less than 51 percentage, it cannot be tagged as a government company. 2 clause 45. Clear all of you? Yes. And I'm telling you, I can give you even 10 more perspectives on government company. That is the number of questions that can be asked. Remember in exam, names always play a role. Simply they will not give off SST Limited, SS Private Limited. A small company can never be a public company. Name plays a huge role. You need to watch the names also. Names are important. Because what is the definition of small company? A company other than public company. So public company can never be a small company. So, clear? Okay. Let's catch up tomorrow again. See you all. Yes, people. Online audible, nada. Online audible. Online, beka, online. Yes, okay. Okay, question number 88. According to the provision of LLP Act, state the provision with respect to the registered office of LLP and changes therein. What would be the consequences if these provisions are contravened? People, out of 100% from LLP, the chances of indirect question is almost like 5 or 10%. 90% of the times, pakka it is a direct question. And I'm saying no doubt. Very rarely you will get an indirect based question from LLP, but if not, it's a direct based question only. Even if it's an indirect based question, there will be very less of your brain usage. It will be direct points only. Yeah, so there will be nothing to worry as such. Okay, according to the provision of LLP, state the provision with respect to the registered office of LLP. What is this? Every LLP, once it is incorporated, should have the registered office going forward. Whenever there is a change, should I inform anyone? Yes, you need to inform to the registrar. And remember, if I have to give notice to the LLP or if I have to give notice to any person, I can just give it to the LLP, I can give it to the partner, I can give it to the designated partner by a post or by a registered post, as the case may be. Failure to comply with this, what was the penalty? We had seen also 500 per day up to 50,000 rupees for LLP and the partners, for both. That was the penalty, that was the provision. Okay, discuss the provisions of LLP relating to the minimum number of partners required and eligibility criteria for becoming a partner in a LLP. Okay, tell me, what is the minimum number of partners required? Two. Tell of designated partners also, it's okay. What is the minimum number of designated partners? Two. And should we have anyone resident and all? Yes. How many? One. So we should have one resident partner who is in India. Okay. And individual is? Sorry. What is the qualification? Who can become a partner? Allah, there was a eligibility criteria for becoming a partner. BCom, engineering is okay? Illa. Hey, what are the disqualifications, da? You should not be insolvent. You should not be unsound mind. You should not have applied to become an insolvent. Correct? That is a qualification. My God, the question day, disqualification we wrote. If at all you are not disqualified, means you are qualified. No. People, you know what? Everyone will have something called as left part of the brain. They use it, da. Yenilla. Listening adanno. Is it, sir? Ama, sir? 5 close friends decided to form a LLP with a dude for educating poor children as non-profit organization. They were Mr. A, non-resident, B, non-resident, C, resident, D, resident, E, resident. It was decided that Mr. A and Mr. B will be appointed as designated partners. with reference to the provision of LLP, answer each of the following. Whether eduded LLP can be formed for the above purpose. Possible? Look at the lot read, 6 marks. Abba. That's why I'm telling you, LLP should be your strength. Indian regulatory framework and LLP should be your strength. You should not even lose 1 mark from these 2 chapters, because I'll tell you one thing, you will get 10 marks max to max within 10 or 15 minutes. For the rest of the 90 marks you have to fight. But these 10 marks you will pakka get it within max to max 15 minutes. You're seeing how easy the questions is. What is the answer? Tell me. Can be found for the above purpose. Possible or no? Why? LLP cannot be formed for a non-profit organization. It is only formed for the purpose of carrying on any business for profits. If needed, I'll just say, if you want to open a Section 8 company, if you want a limited liability or separate legal entity or a corporate personality, then form a Section 8 company. But under LLP, you cannot run a non-profit organization. Okay, done. Next one. Whether Mr. A and B can be appointed as a designated partner? Not possible. Why? See, first of all, not possible. They cannot do this business at all. But even otherwise, if you want to do any other business also, A and B cannot be appointed as a designated partner. The reason is, at least one of them should be resident in India. What is resident in India? 120 days in the during the financial year. Raju and his friend Anil have approached you to help them to form a LLP. The object proposed of LLP is to run a charitable school. Same, See the answer also, 3 marks. You cannot form Section 8, meaning non-profit, not allowed, no? Hello? Explain the provision relating to change of name of LLP under LLP Act 2008. Change of name, when will change of name happen now? Whenever the name of an LLP is similar to an existing LLP, existing company or any registered trademark, and upon an application filed by them to the central government, if it is a registered trademark, that means within 3 years of the company LLP getting registered, I need to file an application to central government. What will central government do? Central government, if it is convinced, they will pass an order to the LLP to change its name. Within how many days should they change the name? Within 30. Within 3 months, the LLP has to change its name. Within 3 months, LLP has to change its name. Failure to change within 3 months, what will the government do? The government will allot a new name of its own and also issue a certificate of incorporation. And remember, you need to intimate this to the registrar within 15 days. You also need to update your agreement within 30 days. Clear? 15 or 30 will come there. It shall within about 15 days and give notice to the registrar. Within 30 days, update the LLP agreement. Hello. We wrote from 88, 89, 90, 91, 92. These were the 5 questions now. Okay, done. Yes, people. This is the last day of your 20-day challenge. I believe whoever have written, you guys would have actually learned something. If you guys have written, definitely would have been benefited out of it. Again, I'm telling you, remember the summary is very simple. If you're struggling with law, it can be your first attempt, it can be your second attempt, or if you are a repeater, remember one part is studying and revising. That will make a lot of difference. But remember that alone is not sufficient. If you read 2 times, 3 times, that alone is not sufficient. Unless and until you start solving more and more questions. I always prefer and I always suggest, if you are a person who's thinking law is difficult for you, at least try to practice writing 2 or 3 questions in a day. There should be a regular practice. Write it. The next thing is, whenever you're revising, imagine if you're invest in a good scanner, whichever scanner you guys are doing. Yeah? Invest in a good guide or a scanner. If you're studying chapter 1, once chapter 1 is done, you guys have to refer to all the questions from the chapter 1. Once you're doing chapter 2, once your chapter 2 is done, you guys have to revise all the questions of the chapter 2. So this has to be an ongoing effort. So remember, the more questions you solve, the better for you. Because if you have seen all the different ways a question can be asked, then there is no other way that it can come. Names can change, situation will remain the same. So, and always remember, failing is okay, but do not fail without trying. That is a sin. So it's okay to fail, but it's not okay to not attempting or not preparing yourself and then failing. That is a sin. Clear, all of you? So I have stopped today with 100 questions. Let me know if you want to consolidate this particular all the questions also. I can consolidate everything and I can also post it, but let me know if you guys want it, then I can consolidate it for you. Yeah. Yes. You want it, Ada? Comment. Yeah. So yes, if you want, let me know. I'll consolidate for you. And yes, in this video, you guys can find out. I'll be sending you the entire key for all the 20 days one, whatever is there with question and answers. I'll be sending it to you. And today, I believe you guys would have also received the section sheet. The section chart, I think you guys have received as well. So have that also. Remember, probably after 2 weeks or something, I'll be uploading one more video, which will be a consolidated video of, I'm just telling you what are the videos that I'll be doing in the pipeline. Please have an eye on the ArivuPro YouTube channel. That is for CA. Have an eye on that. I'll be doing one video where I'll be explaining all the case laws in one video. All the case laws. In depth, complete. Even if one letter is mentioned, I will explain that particular case law. So that video will be coming. Remember that. One more video that will be coming is all the difference between questions discussed in one video. So whenever you guys want, just open it. I'll be doing all the difference between questions in one video. That is one thing that I'll be doing. And I'll be doing the last 10 or the 10 attempts ka model test papers. That will be coming as one video. Watch that. And the marathon will be coming somewhere by this month end. A complete revision. That is also something in the pipeline. So all these will be coming. Have an eye on YouTube so that you will not miss on those particular videos. Clear? Yes. Okay. So the last 20th day ka thing, we'll finish it off. I have added, I think, 7 or 8 questions from Negotiable Instruments so that we'll have good number of questions from every chapter. Okay. Mr. Anil drew a bill of exchange in Kolkata on Mr. Bimal, a resident of New York, and made it payable in Delhi. On maturity, the bill was dishonored, and Anil sued Bimal in India, claiming interest at the rate of 18% as applicable in Kolkata. Bimal contended that his liability was governed by New York law, where the rate of interest was only 6%. Decide the liability of Bimal with reference to the provision of Negotiable Instrument Act. I hope you guys know what is the provision. We are seeing the type of instrument, that is foreign instrument here. In a foreign instrument, always which one is a law that will be governed? The first one is wherever the bill is made. Next one is, first of all, what type of bill is the Mr. Anil drew a bill of exchange in Kolkata. Okay, drawn in India. On Mr. Resident of New York, drawee resides in New York, and made it payable in India. Hey, first of all, what type of instrument is this? It is an inland instrument. So decide the liability of Bimal. Of course, it is an inland, it is an Indian instrument. Whatever is the rate at Kolkata, that only will apply. Correct? Yes, remember, see, they tried to confuse you. They have clubbed both provisions. In example, you would have seen this as a foreign instrument, but the provision is similar to inland instrument. No, you have to, because foreign instrument is nowhere involved here. You have to write the definition of inland instrument. What is inland instrument? Any instrument drawn in India and payable in India or drawee resides in India. Any one condition to be satisfied. Correct? Here it is drawn in India and payable in India. So two conditions satisfied. Hence it becomes a inland instrument. Okay, next one. Mr. Y issued a check for 10,000 to Mr. Z, which was dishonored by the bank because Y did not have enough funds in his account and has no authority to overdraw. Examine as per the provision of negotiable instruments whether Mr. Y is liable for dishonor of check. If yes, what are the consequences for such an offense? Is Y liable for dishonor? Answer is yes, you are liable. You have issued a check which has no balance in it. Are you liable? Yes. What are the consequences for that offense? You can be imprisonment for up to 2 years and you can be levied a penalty up to twice of the amount of the check. You can directly write the penalty can go up to 20,000 rupees or both. Okay, what would be your answer if Y issued a check as a donation to Mr. Z? Remember, always the check, the check bounce case or dishonor of check, section 138 will apply only when people in the case of it is a legally enforceable debt. If it's a security, if it's a donation, if it's a gift, you will not get any right over the instrument. In that case, yes, my answer will be different. My provision is a legally enforceable debt alone attracts a check bounce case. In the given scenario, if it's a security or if it's a donation or if it's a gift, you cannot call it as a check bounce. So yes, in our case, Z cannot recover any compensation if it was given as a donation. Clear? All of you, look at the marks. Cakewalk it was. Yes? Okay. With reference to the provision of Negotiable Instruments Act, tell the instances where a person shall be deemed to have committed an offence for dishonor of check and what are the conditions to be complied with not for constituting such an offence. What is it, people? Whenever I issue a check, whenever the money is insufficient to pay, completely insufficient, that is, imagine I have a zero payment or I have even partial, it is not sufficient. I have given a check for 1 lakh. I am only having 50,000 in the bank account. In both the cases, it is considered as a dishonor. But remember, a dishonor of a check can always happen only in the case of legally enforceable debt. That is, it cannot happen in the case of gift, donation, or security, and all of that. Agreed? Sir, in this case, what is that they're asking you? And what are the conditions to be complied with for not constituting such an offence? That means what?
Before 3 months.
You have to clearly say, I need to deposit the check within 3 months or
Like if there is no amount,
the validity period, whichever is earlier.
and if there is no amount, should inform the employee before 30 days.
Okay, if it is not paid, dishonored, then what should the person do? Notice of dishonor has to be given to the drawer. Now, drawer has to make the payment within how many days?
15 days. 15 days.
Within 15 days, the drawer has to make the payment. If not paid, I will go and file a complaint to the court. Correct? That is what the timeline they're asking you. Check should be presented within the validity period. Demand for payment through the notice. That is what? Within 30 days of the receipt of information by the bank, I need to ask you to make the payment. And you need to make the payment within 15 days. Correct? See, if that 3 steps if you remember. And how many marks? 4 marks. Yeah? Easy? We are just written in 3 steps. 1, 2, 3 arrow marks we have written. All checks are bills, while all bills are not checks. Explain the additional features of a check which differentiates a check from a bill. What is the difference? Always remember in the case, what is the difference between bill of exchange and what is the difference between check? Remember, check is also a bill of exchange only, but not all bill of exchanges are checks. That's what they're asking you. What is the difference? First one, in a bill of exchange, drawee can be any person. It can be Abbas, it can be Nihal, it can be Payal, it can be anyone. But in the case of check, the drawee is fixed always. It's always a specified bank. Correct? That will never change. The second one, sir, always remember, in the case of check, you can always make it payable on demand. I told you, always checks are payable on demand, but not all bill of exchanges. Whenever you go deposit, you will get your money, right? In the case of check, that's not the case in the case of bill of exchanges. You'll have to wait for 3 months if the bill says so. It must be payable on demand. Thus, all checks are bills, while all bills are not checks. Clear? Huh? Yes, sir. Okay, what are the rules governing the compensation payable in the event of dishonor of a negotiable instrument? Compensation payable. Negotiable instrument, the last topic, that 5 points. First point is, I'll be entitled for all the amount on instrument mentioned plus expenses of noting, protesting and any other expenses involved. Next one, whenever both the parties, if they live in 2 different places, I am entitled for the compensation at the current rate of exchange. Third one, whenever there is a endorsement, if an endorser makes a payment, he is entitled for a compensation at a rate of 18% per annum as an interest until his entire money is settled along with all the expenses. Next one, if at all the endorser and the drawer, if they reside in 2 different places, again you need to make the settlement at the current rate of exchange. And the last one is, we can also enter into a new bill. You can make a new bill for the compensation of all these expenses. You can enter into a new bill. These are the 5 points, correct? 98. Anjali purchased various cosmetic products worth 15,000 during the last week from Sushil, a shopkeeper, on credit of 1 month. After a fortnight, she makes out a blank promissory note. So Anjali has given a promissory note, signed it and delivered it to Sushil. Blank promissory note. So what type of instrument is it called? Blank. Inchoate instrument. Inchoate means, people, it's a blank instrument, incomplete instrument. Always remember, in the negotiable instrument chapter, if they are giving you the question, please open your eyes, read it carefully, which bill it is in the first place. Is it negotiable? Is it promissory note? Is it bill of exchange? Because based on that, the question will change, the parties will change. So keep that in mind. And delivered to Sushil, who further endorsed it. Sushil has endorsed it to Manish for payment of his dues. It seems he has taken some money, he has given this bill to him. Manish, who is holder in due course, he is HDCA. He filled up the due amount, so Sushil had to give him 17,000. He wrote 17,000 and on maturity presented it to Anjali for payment, but she refused to pay because the amount filled up is more than the agreed amount of 15,000. It is to be noted that the amount of 17,000 is covered by the stamp affixed on it. Referring to the provision of Negotiable Instrument Act, whether Anjali is liable to honor the promissory note to Manish for 17,000. Is it required? Answer is yes, people, it is required. Because whenever you are a holder in due course, you are entitled to recover the money up to the stamp duty affixed. Agreed? Yes, sir? Okay. Next one. Priya, a small business owner, receives a bill of exchange from her customer, Sanjay, which is due for payment on October 15th. On October 12th, Priya presents the bill of exchange for payment at Sanjay's office during regular business hour. But Sanjay is not present. Priya leaves the bill with Sanjay's assistant requesting to be presented to Sanjay for payment when he returns. However, Sanjay's assistant forgot to give the bill and Sanjay does not make the payment by the due date and the bill is dishonored. Based on the provision of Negotiable Instrument Act, examine whether Priya's presentation of the bill of exchange to Sanjay's assistant is valid under the law. Is it valid? No. Why?
Because Sanjay was not
Not-
legal.
We have clearly seen, I made you write also presentment, endorsement. If it is to be complete, you have to always present it to the right party. It can be drawee or drawer or whoever it is. You have to present it to them. If they are unavailable or if they have authorized any other person as authorized representative, you can give it to them. In the given case, I will write it with an assumption. Assuming that the assistant is not the authorized representative of Sanjay and Sanjay, who is he? I don't know who gave it. Priya. Okay, Priya has assumed it, people. So Priya cannot give that bill of exchange to the assistant as he has no right to receive the bill. You have to either give it to the person or you have to give it to their authorized representative. We have written this as a note also. See how they can ask you. 3 marks question. What they have given, see. The promissory note below must be presented for payment to the maker, acceptor or drawee thereof respectively. Or, correct, huh? Or on their behalf. You can give it to, see the words, keywords. That's why I say you need to have that. If it is there, underline it. Clear? All of you? Okay. The last ones are 100th one now. Ababa. Delivery of an instrument is essential whether instrument is payable to bearer or order for effecting the negotiation. Discuss the statement with reference to the provision of Negotiable Instruments Act 1881. Delivery of an instrument is essential whether instrument is payable to bearer or order effecting the negotiation. Discuss this statement with reference to the provision of Negotiable Instrument Act. Tell me, what is it? I hope you guys understood something. People, there are two types of instruments, people. One is called as bearer instrument, one is called as order instrument. How do you transfer? How do you negotiate? How do you endorse a bearer instrument? Just by delivery. How do you endorse a order instrument? Endorsement plus delivery. That means what? You need to do it on a piece of paper. You need to sign it. You have to properly follow everything. If it is a order instrument, and delivery can be of two types. Remember what? One is can be actual delivery. Next one is constructive delivery. That means actual means giving it to them only. Constructive means giving it to their authorized representatives or their any agents as the case may be. Agreed? Hello? All of you. That is this. So yes, delivery is mandatory. Whether it is whichever type of instrument, whether bearer or order, delivery is mandatory. Clear? All of you? Done. So this is your 20 days and that is your 100 questions. So good. I don't know how many of you guys were able to complete 5 questions in 30 minutes in the awarded time. Continue having the practice. That is the key for you to reach 90 marks. Remember, our goal has to be to attend at least 90 marks. The more it is, the merrier. We are absolutely fine with it. But you should never fall short in attending the questions. Your aim has to be at least 90. Is this clear? All of you? The more you practice, the better for you. Clear? All of you? Okay. So wish you guys the best on that. Yeah? Okay. Yes, people. This is the last day of your 20-day challenge. I believe whoever have written, you guys would have actually learned something. If you guys have written, definitely would have been benefited out of it. Again, I'm telling you, remember the summary is very simple. If you're struggling with law, it can be your first attempt, it can be your second attempt, or if you are a repeater. Remember, one part is studying and revising. That will make a lot of difference. But remember that alone is not sufficient. If you read 2 times, 3 times, that alone is not sufficient unless and until you start solving more and more questions. I always prefer and I always suggest, if you are a person who's thinking law is difficult for you, at least try to practice writing 2 or 3 questions in a day. There should be a regular practice. Write it. The next thing is, whenever you're revising, imagine if you're invest in a good scanner, whichever scanner you guys are doing. Yeah, invest in a good guide or a scanner. If you're studying chapter 1, once chapter 1 is done, you guys have to refer to all the questions from the chapter 1. Once you're doing chapter 2, once your chapter 2 is done, you guys have to revise all the questions of the chapter 2. So this has to be an ongoing effort. So remember, the more questions you solve, the better for you. Because if you have seen all the different ways a question can be asked, then there is no other way that it can come. Names can change, situation will remain the same. So, and always remember, failing is okay, but do not fail without trying. That is a sin. So it's okay to fail, but it's not okay to not attempting or not preparing yourself and then failing. That is a sin. Clear, all of you? So I have stopped today with 100 questions. Let me know if you want to consolidate this particular all the questions also. I can consolidate everything and I can also post it, but let me know if you guys want it, then I can consolidate it for you. Yeah. Yes, you want it, Ada? Comment. Yeah. So yes, if you want, let me know. I'll consolidate for you. And yes, in this video, you guys can find out. I'll be sending you the entire key for all the 20 days one, whatever is there with question and answers. I'll be sending it to you. And today, I believe you guys would have also received the section sheet. The section chart, I think you guys have received as well. So have that also. Remember, probably after 2 weeks or something, I'll be uploading one more video, which will be a consolidated video of, I'm just telling you what are the videos that I'll be doing in the pipeline. Please have an eye on the ArivuPro YouTube channel, that is for CA. Have an eye on that. I'll be doing one video where I'll be explaining all the case laws in one video. All the case laws. In depth, complete. Even if one letter is mentioned, I will explain that particular case law. So that video will be coming. Remember that. One more video that will be coming is all the difference between questions discussed in one video. So whenever you guys want, just open it. I'll be doing all the difference between questions in one video. That is one thing that I'll be doing. And I'll be doing the last 10 or the 10 attempts ka model test papers. That will be coming as one video. Watch that. And the marathon will be coming somewhere by this month end. A complete revision. That is also something in the pipeline. So all these will be coming. Have an eye on YouTube so that you will not miss on those particular videos. Clear? Yes. Okay. So the last 20th day ka thing, we'll finish it off. I have added, I think, 7 or 8 questions from Negotiable Instruments so that we'll have good number of questions from every chapter. Okay. Mr. Anil drew a bill of exchange in Kolkata on Mr. Bimal, a resident of New York, and made it payable in Delhi. On maturity, the bill was dishonored, and Anil sued Bimal in India, claiming interest at the rate of 18% as applicable in Kolkata. Bimal contended that his liability was governed by New York law, where the rate of interest was only 6%. Decide the liability of Bimal with reference to the provision of Negotiable Instrument Act. I hope you guys know what is the provision. We are seeing the type of instrument, that is foreign instrument here. In a foreign instrument, always which one is a law that will be governed? The first one is wherever the bill is made. Next one is, first of all, what type of bill is the Mr. Anil drew a bill of exchange in Kolkata. Okay, drawn in India. On Mr. Resident of New York, drawee resides in New York and made it payable in India. Hey, first of all, what type of instrument is this? It is an inland instrument. So decide the liability of Bimal. Of course, it is an inland, it is an Indian instrument. Whatever is the rate at Kolkata, that only will apply. Correct? Yes, remember, see, they tried to confuse you. They've clubbed both provisions. In example, you would have seen this as a foreign instrument, but the provision is similar to inland instrument. No, you have to, because foreign instrument is nowhere involved here. You have to write the definition of inland instrument. What is inland instrument? Any instrument drawn in India and payable in India, or drawee resides in India. Any one condition to be satisfied. Correct? Here it is drawn in India and payable in India. So two conditions satisfied. Hence it becomes a inland instrument. Okay, next one. Mr. Y issued a check for 10,000 to Mr. Z, which was dishonored by the bank because Y did not have enough funds in his account and has no authority to overdraw. Examine as per the provision of negotiable instruments whether Mr. Y is liable for dishonor of check. If yes, what are the consequences for such an offense? Is Y liable for dishonor? Answer is yes, you are liable. You have issued a check which has no balance in it. Are you liable? Yes. What are the consequences for that offense? You can be imprisonment for up to 2 years, and you can be levied a penalty up to twice of the amount of the check. You can directly write the penalty can go up to 20,000 rupees or both. Okay, what would be your answer if Y issued a check as a donation to Mr. Z? Remember, always the check, the check bounce case or dishonor of check, section 138 will apply only when people, in the case of, it is a legally enforceable debt. If it's a security, if it's a donation, if it's a gift, you will not get any right over the instrument. In that case, yes, my answer will be different. My provision is a legally enforceable debt alone attracts a check bounce case. In the given scenario, if it's a security or if it's a donation or if it's a gift, you cannot call it as a check bounce. So yes, in our case, Z cannot recover any compensation if it was given as a donation. Clear? All of you, look at the marks. Cakewalk it was. Yes? Okay. With reference to the provision of Negotiable Instruments Act, tell the instances where a person shall be deemed to have committed an offence for dishonor of check and what are the conditions to be complied with not for constituting such an offence. What is it, people? Whenever I issue a check, whenever the money is insufficient to pay, completely insufficient, that is, imagine I have a zero payment or I have even partial, it is not sufficient. I have given a check for 1 lakh. I am only having 50,000 in the bank account. In both the cases, it is considered as a dishonor. But remember, a dishonor of a check can always happen only in the case of legally enforceable debt. That is, it cannot happen in the case of gift, donation, or security, and all of that. Agreed? Sir, in this case, what is that they're asking you? And what are the conditions to be complied with for not constituting such an offence? That means what? You have to clearly say, I need to deposit the check within 3 months or the validity period, whichever is earlier. Okay, if it is not paid, dishonored, then what should the person do? Notice of dishonor has to be given to the drawer. Now, drawer has to make the payment within how many days? Within 15 days, the drawer has to make the payment. If not paid, I will go and file a complaint to the court. Correct? That is what is the timeline they're asking you. Check should be presented within the validity period. Demand for payment through the notice. That is what? Within 30 days of the receipt of information by the bank, I need to ask you to make the payment. And you need to make the payment within 15 days. Correct? See, if you, that 3 steps if you remember. And how many marks? 4 marks. Yeah? Easy? We are just written in 3 steps. 1, 2, 3 arrow marks we have written. All checks are bills, while all bills are not checks. Explain the additional features of a check which differentiates a check from a bill. What is the difference? Always remember in the case, what is the difference between bill of exchange and what is the difference between check? Remember, check is also a bill of exchange only, but not all bill of exchanges are checks. That's what they're asking you. What is the difference? First one, in a bill of exchange, drawee can be any person. It can be Abbas, it can be Nihal, it can be Payal, it can be anyone. But in the case of check, the drawee is fixed always. It's always a specified bank. Correct? That will never change. The second one, sir, always remember, in the case of check, you can always make it payable on demand. I told you, always checks are payable on demand, but not all bill of exchanges. Whenever you go deposit, you will get your money, right? In the case of check, that's not the case in the case of bill of exchanges. You'll have to wait for 3 months if the bill says so. It must be payable on demand. Thus, all checks are bills, while all bills are not checks. Clear? Yes, okay. What are the rules governing the compensation payable in the event of dishonor of a negotiable instrument? Compensation payable. Negotiable instrument, the last topic, 5 points. First point is, I'll be entitled for all the amount on instrument mentioned plus expenses of noting, protesting and any other expenses involved. Next one, whenever both the parties, if they live in 2 different places, I am entitled for the compensation at the current rate of exchange. Third one, whenever there is a endorsement, if an endorser makes a payment, he is entitled for a compensation at a rate of 18% per annum as an interest until his entire money is settled along with all the expenses. Next one, if at all the endorser and the drawer, if they reside in 2 different places, again you need to make the settlement at the current rate of exchange. And the last one is, we can also enter into a new bill. You can make a new bill for the compensation of all these expenses. You can enter into a new bill. These are the 5 points, correct? 98. Anjali purchased various cosmetic products worth 15,000 during the last week from Sushil, a shopkeeper, on credit of 1 month. After a fortnight, she makes out a blank promissory note. So, Anjali has given a promissory note. Signed it and delivered it to Sushil. Blank promissory note. So, what type of instrument is it called? Blank. Inchoate instrument. Inchoate means, people, it's a blank instrument, incomplete instrument. Always remember, in the negotiable instrument chapter, if they are giving you the question, please open your eyes, read it carefully, which bill it is in the first place. Is it negotiable? Is it promissory note? Is it bill of exchange? Because based on that, the question will change, the parties will change. So keep that in mind. And delivered to Sushil, who further endorsed it. Sushil has endorsed it to Manish for payment of his dues. It seems he has taken some money, he has given this bill to him. Manish, who is holder in due course, he is HDCA. He filled up the due amount, so Sushil had to give him 17,000. He wrote 17,000 and on maturity presented it to Anjali for payment, but she refused to pay because the amount filled up is more than the agreed amount of 15,000. It is to be noted that the amount of 17,000 is covered by the stamp affixed on it. referring to the provision of Negotiable Instrument Act, whether Anjali is liable to honor the promissory note to Manish for 17,000. Is it required? Answer is yes, people, it is required. Because whenever you are a holder in due course, you are entitled to recover the money up to the stamp duty affixed. Agreed? Yes, sir? Okay. Next one. Priya, a small business owner, receives a bill of exchange from her customer, Sanjay, which is due for payment on October 15th. On October 12th, Priya presents the bill of exchange for payment at Sanjay's office during regular business hour. But Sanjay is not present. Priya leaves the bill with Sanjay's assistant, requesting to be presented to Sanjay for payment when he returns. However, Sanjay's assistant forgot to give the bill and Sanjay does not make the payment by the due date and the bill is dishonored. Based on the provision of Negotiable Instrument Act, examine whether Priya's presentation of the bill of exchange to Sanjay's assistant is valid under the law. Is it valid? No. Why?
Because Sanjay was not there and legal.
We have clearly seen, I made you write also presentment, endorsement. If it is to be complete, you have to always present it to the right party. It can be drawee or drawer or whoever it is. You have to present it to them. If they are unavailable or if they have authorized any other person as authorized representative, you can give it to them. In the given case, I will write it with an assumption. Assuming that the assistant is not the authorized representative of Sanjay and Sanjay, who is he? I don't know who gave it. Priya. Okay, Priya has assumed it, people. So Priya cannot give that bill of exchange to the assistant as he has no right to receive the bill. You have to either give it to the person or you have to give it to their authorized representative. We have written this as a note also. See how they can ask you. 3 marks question. What they have given, see. The promissory note below must be presented for payment to the maker, acceptor or drawee thereof respectively. Or correct, or on their behalf. You can give it to. See the words, keywords. That's why I say you need to have that. If it is there, underline it. Clear? All of you? Okay. The last one, sir, 100th one now. Ababa. Delivery of an instrument is essential whether instrument is payable to bearer or order for effecting the negotiation. Discuss the statement with reference to the provision of Negotiable Instruments Act 1881. Delivery of an instrument is essential whether instrument is payable to bearer or order effecting the negotiation. Discuss this statement with reference to the provision of Negotiable Instrument Act. Tell me, what is it? I hope you guys understood something. People, there are two types of instruments, people. One is called as bearer instrument, one is called as order instrument. How do you transfer? How do you negotiate? How do you endorse a bearer instrument? Just by delivery. How do you endorse a order instrument? Endorsement plus delivery. That means what? You need to do it on a piece of paper. You need to sign it. You have to properly follow everything. If it is a order instrument, and delivery can be of two types. Remember what? One is can be actual delivery. Next one is constructive delivery. That means actual means giving it to them only. Constructive means giving it to their authorized representatives or their any agents as the case may be. Agreed? Hello? All of you. That is this. So yes, delivery is mandatory. Whether it is whichever type of instrument, whether bearer or order, delivery is mandatory. Clear? All of you? Done. So this is your 20 days and that is your 100 questions. So good. I don't know how many of you guys were able to complete 5 questions in 30 minutes in the awarded time. Continue having the practice. That is the key for you to reach 90 marks. Remember, our goal has to be to attend at least 90 marks. The more it is, the merrier. We are absolutely fine with it, but you should never fall short in attending the questions. Your aim has to be at least 90. Is this clear? All of you? The more you practice, the better for you. Clear? All of you? Okay. So wish you guys the best on that. Yeah? Okay.